of what is this one-day inquiry by the committee into the proposed changes to the liability and entitlements for psychological injury in New South Wales. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respect to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Greg Donnelly and I'm the chair of the committee. I ask everyone in the room to please turn their mobile phones to silent if you've not done so already. Parliamentary privilege applies to witnesses in relation to evidence they give today. However, it does not apply to what witnesses say outside the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Now, due to the time frame of the inquiry, I advise that witnesses that the committee has resolved that with respect to any questions on notice taken today, the return of answers to those will be close of business, i.e. 5 p.m. next Wednesday. Now that date is next Wednesday, just refresh my memory.
Sorry, we can't hear.
Okay. Okay, no, okay, thank you. That's fine. There's no intentions to not have you here. I apologise. So the date next Wednesday, what's the date next Wednesday? The 21st. So return to the Secretariat by close of business on that date, answers to supplementary questions that may be taken. Sorry, questions on those, I should say. Now, members should also note, and members of the committee, but also the witnesses today over the course of the day and the public at large, that there'll be no provision for supplementary questions to witnesses after the hearing, which otherwise would be normally provided through the committee secretariat from members of the committee. So good morning, Treasurer and Minister Cotsis. Welcome and thank you for being available as our first witnesses today. Treasurer and Minister Cotsis, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. Now, just so we're clear for our witnesses and other witnesses today and the public at large, we are in effect starting 15 minutes late today, and I do apologise for that to our first witnesses and the consequential knock-on effect for all the witnesses for the rest of the day. That will simply push everything forward 15 minutes. So I want to make that very clear. That's the effect of the delay that we have, and once again through no fault of any of the witnesses, but some work that needed to be done through deliberation by the committee before we formally started. So with that introduction, I think there's no more to say at this stage. Just to obviously make the point for anyone who's watching, there are representatives on this committee from the government, the opposition and the crossbench who will be participating today. With that, Treasurer and Minister, would you like to start by making a short statement?
Thank you, Chair. I would. And thank you, Chair, and thank you to the Law and Justice Committee for permitting our appearance today. The exposure draft this committee is inquiring into arises from the failure of our existing workplace health and safety laws, industrial relation laws, and our workers' compensation system to prevent psychological injuries and return those with psychological injuries to their health and to their work. I set out the reasons why in my statement to the House in March. But since March, there has been some further developments, namely the finalisation of the December valuations. And I want to brief the committee on those changes. At the June 2024 valuation, the nominal insurer held 85 cents for every dollar it expected to pay in compensation. Since then, the scheme has plunged further into deficit. I regret to inform you that as of December 31, the scheme is only now holding 82 cents in assets for every dollar it expects in future claims. Absent reform, I expect the scheme to plunge further into deficit when the scheme is revalued in 6 weeks' time. Fast deterioration has real implications for the sustainability of the scheme. Workers get less, businesses pay more. Put simply, you can have the best workers' compensation scheme in the world on paper. If it has no money, it's not helping anyone. Turning to the TMF, the government's self-insurer, I regret to inform the committee that as a result of the December valuation, absent reform, the forthcoming budget will report another $2.6 billion write-down just 6 months since the half-year with review. With reform, that cost might be avoided. By way of context, the half-year review reported a $204 million write-down. The 2024 budget recorded a $2.4 billion write-down. The 2023 half-year report reported a $170 million write-down, and my first budget recorded a $1.3 billion write-down. In fact, the state budget has recorded a cumulative $4.1 billion in write-downs arising from the TMFs in my 2-year tenure as Treasurer. As the TMF continues to deteriorate, the pressure for cash injections grows. Since I became Treasurer, the government has authorised an additional $1.2 billion in cash injections to keep the public insurer funded. Treasurers Perrottet and Keane authorised an earlier $4.9 billion. Since 2018, governments have borrowed $6.1 billion, so the TMF's assets equals its liabilities. I will not be authorising any further injections, not until Parliament decides its collective response to a scheme that most acknowledge is failing, and not when that money is coming at the expense of schools, hospitals or kids in need of out-of-home care. That choice is clear for me. Turning to the state of the system, as I said in my ministerial statement in March, claims for psychological injury have doubled in just 6 years. While 91% of physical injury claims resolve within 13 weeks, 50% of psychological claims are not resolved after a year. The average cost for a psychological claim has also massively increased from $146,000 in 2019 to $288,542 in 2024. These costs have increased premiums for businesses by 8% annually for 3 years. Without reform, claim-free businesses will see a 36% rise in premiums by 2027-2028. These costs are in turn having very real consequences, of course, on the viability of those businesses as well as our broader economy. But beyond that cost, the system is disrupting workplaces by sidelining trained staff and worsening conflict. The impact on injured workers is no better. These facts demand reform. The exposure draft of the Workers' Compensation Legislation Amendment Bill takes the first step. It's important for us to say it's not the government's final position. Your deliberations and our consultations with the New South Wales trade union movement, employers and members of Parliament will shape the bill the government intends to introduce shortly. That bill aims to stabilise the scheme, but ultimately more reform will be needed. New South Wales needs to break the habit of set and forget when it comes to WHS laws, IR law and workers' compensation scheme design. The state needs to make a decisive shift towards fostering a culture of prevention. Us parliamentarians need to lead it. Ultimately, the best workers' compensation scheme is one no one ever needs to use. Until that is possible, I urge Parliament to act to save the scheme we have and fight to stop people from being injured in the first place.
Thank you, Treasurer. Honourable Sophie Cotsis.
Thank you, Chair. Chair, it's clear to everyone, injured workers, unions, business and the government, that the current New South Wales workers' compensation system is failing, especially for psychological injuries. A change in volume of claims impacts revenues. There is no doubt mental health is a societal issue, but the increase in psychological claims would indicate that the system has become a place where industrial relations and general health issues are being managed through a system that was designed to support those injured at work to recover and to return to work. The Minns Labor government is committed to reforms that ensure these types of injuries are prevented from occurring in the first place. We have restored Safe Work New South Wales as a standalone regulator. With more inspectors, we will have a new commissioner at its head. We're investing in stronger enforcement of psychological risk regulations. And we have launched the 2024-2026 Psychological Health and Safety Strategy, shifting focus from education to compliance. We have also implemented the government's whole of government return to work strategy to find suitable job pathways for injured public sector workers with a capacity and desire to work. Last year, Mr. Chair, we identified over 3,068 New South Wales public sector workers who, on workers' compensation, who have claims in this position. Now, this is unacceptable because these public sector workers have capacity to work, but the system has these artificial barriers that doesn't allow them to get back into the system. Now, what we're doing is we're implementing this strategy backed by $1.2 million that is led by a team in the Premier's department. The government has also been clear that iCare needs to get better with both governance and claims management after the errors of the last 10 years. Since coming to office, the government has established statutory objectives for iCare, mandated that an employee and employer representative must be on the board of iCare, put a Treasury official on the board of iCare, and required that iCare must table a statement of business intent to Parliament each year. iCare has also now implemented professional standards for claims managers across the nominal insurer and the Treasury managed fund for the first time, and is also now looking at ways to expand its test and learn model into the broader scheme. Claims managers are at the front line of our workers' compensation system, and it is critical that they have the skills to support injured workers recover. These professional standards are an important step in that direction. Mr. Chair, we want to build a system that both respects and treats injured workers and gives confidence to New South Wales businesses that the premiums they pay are fair and are being used in the best possible way to return workers back to work.
Thank you, Minister Cotsis. We'll now move to questions from the committee members. It's been previously resolved that we'll divide the time between the three groups represented at the table here in the order of opposition, crossbench and government. So I ask the government, and I believe starting by the Honourable Damien Tudhope.
Thank you. And Minister Cotsis, if I can start with you. This is an inquiry into the exposure bill, so I'm not going to ask you questions about the statement you've just made. So it's an inquiry into the bill which you've put before us. So just in relation to that bill, the Fair Work Commission says that its aim is to resolve most bullying and sexual harassment cases within 16 weeks. Are you aware of that?
The Fair Work Commission does have a bullying jurisdiction, that's right.
And it tries to resolve those within 16 weeks. Are you aware of that?
Yeah.
What is the likely time frame that you perceive for resolving such applications under your proposed new industrial relations jurisdiction? And can you confirm that no weekly payments will be made for medical, or medical treatment will be able to be claimed for workers' compensation during those weeks or months while the Commission is hearing the application?
Mr. Tudor-Hope, this is an exposure draft. It is a pathway to reform, because what we've seen particularly over the last five to 10 years, particularly as the Treasurer noted, that we have seen a doubling of psychological claims.
No, I'm just asking you about, Minister Bill, I've got very limited time this morning.
I've got limited time as well.
This is a very quick inquiry.
And this is very important. But I want to explain.
Chair, I have to say that this is a very direct question in relation to the new proposed Industrial Relations Commission jurisdiction. Will people making a claim under that jurisdiction have no access to workers' compensation payments or medical payments pending the outcome of that inquiry?
Mr. Tudor-Hope, this is a proposal in the exposure draft. The government has committed to expanding the Industrial Relations Commission's remit.
Well, is it in the exposure draft? In the exposure draft, is that the
Mr. Tudor-Hope, we are expanding the bullying and harassment jurisdiction in the New South Wales Industrial Commission, unlike you, where you strip the industrial court. And what we are going to do in this process is we are going to have a stop bullying, stop sexual harassment order with damages. This is a roadmap to reform. We are listening to what everybody is saying about this process. And I hear what
Minister, I'm aware of what you're submitting to me. So, in the circumstances and under the exposure draft which you've submitted, a sexual harassment claimant who is suffering from a psychiatric disorder caused by sexual harassment would either have to keep attending work or take leave if available and pay for their own medical treatment. Is that what is
Yeah.
provided under the exposure draft?
Can I just-
No, I'm asking the Minister, Treasurer.
Well, I can provide you information.
I'm asking the Minister.
Perhaps-
Is that the case?
Yeah, no, I'm happy for the Treasurer to respond to that.
Can I
because
say,
it's been posed to us.
your point, Mr. Tudub, is taken. You are quite right to say that in the absence of a determination by a tribunal, the concept of being able to access what is currently termed provisional liability is affected. But I just take one step back. You're referring to cases which are complex. The current system isn't resolving them quickly. The cases that you're resolving you're pointing to, which are valid points, under the existing status quo, are not being resolved.
But their
Second point-
payments are being made, aren't they, Treasurer?
Order.
Yes,
Order.
and I take your point. I do take your point. And I make the point to you, Mr. Tudor Hope, that the point you're making is something we're seriously considering. About how you consider the application of a concept like provisional liability in such a scheme. Part of the reasons why I think we've issued the exposure draft is to tease out these issues and to bring them to the fore and to allow us to respond to them.
Treasurer, I've got when you sat in this chair, you have very limited time, and you have given us very limited time in relation to this inquiry. So if you bear with me in just relation to these questions, I can get through them. Minister, back to you, Minister Cotsis. Under the Work Health and Safety Regulations, employers are required to address psychosocial hazards in the workplace, which according to Safe Work Australia can include conflict or poor workplace relationships and interactions, job demands such as sustained high mental, physical or emotional effort required to do the job, and shifts that do not allow adequate time for sleep or recovery. Can you confirm that under the draft bill that they will remove the existing right for workers to claim common law damages if an employer's negligence in addressing such psychosocial hazards causes a permanent psychological injury?
Mr. Tudor Hope, as you know, and as the Treasurer has stated, this is an exposure draft where...
Well, again, Treasurer, can you say
Yeah,
that
I
this
can
is...
talk to you about this.
This is a...
Yeah, I mean, look, actually, the answer to on the corners to the exposure draft is that the requirement I think you're referring to is under the provision that affects work injury damages.
That's right.
The work injury damages provision at the existing status quo requires the establishment of negligence. Under the exposure draft provisions, that wouldn't change, but what the level of impairment that is required would change. That is the way technically the exposure draft works. I just stress again the concept of work injury damages obviously is very important because it is there to stand in the place of common law rights. But the requirement to prove negligence is unaffected by the exposure draft. That remains. What is changing is the threshold of impairment under the exposure draft.
Well, let me ask you that.
Can I also... can I just respond?
No, I just want to take up just so that we have some clarity on this. Has this exposure draft been to Cabinet or caucus?
Yes. I won't comment on caucus Cabinet deliberations. But yes, we have obviously published the exposure draft. Yes, we've referred it to our caucus. Yes, we've referred it to you. Yes, we've referred it to all members of the Parliament. And yes, we're inviting feedback from our caucus, from you, from this committee, from...
So has the exposure draft been approved by Cabinet?
Again, I won't comment on Cabinet deliberations other than to say that, of course, the decision to publish the exposure draft was authorised.
So, Minister Cotsis, do you agree with this, the provisions contained in this exposure draft?
As the Treasurer said, that this is a decision's been made to release the exposure draft for the simple fact that we're here today to listen to what stakeholders have to say, and we have been listening particularly over the last couple of years, as you know, Mr. Tudor Hope, that there has been a rise in psychological claims, and there are responsibilities in the Work Health and Safety Act. There are responsibilities that employers have in the Work Health and Safety Act, and we do need to tighten those because we have to go back to the cause. This is looking at everything holistically. This is looking at what is the cause, and what are the things that we need to be doing, what are the things that employers need to be doing.
This bill represents your considered view of what we should be doing?
There are a number of things that
Is this
that
your
the
considered
government,
view of what we should be doing?
Mr. Tudor-Hope, this is a roadmap to fixing a broken system that was left by your government. And what we're trying to do here is we're trying to we are
dealt with exactly the same
investing
problem.
in preventative. We are investing in preventative programs. We are doing a lot of work at the front end, and one of the things that the government has achieved is we have been working with public sector agencies, with public sector unions, to establish a whole of government return to work. And what I see is that there are 3,068 public
Well,
sector
let me ask you about
workers
that. Let
who-
me ask you about
who-
your consultation, Minister, because the Public Service Association says this: the proposed changes will not improve workers' health, but will instead exacerbate their injuries and cause them further harm. As Minister for Work Health and Safety, do you agree with the PSA?
With respect to the whole of government return to work,
Yes.
the strategy that we've established.
With this exposure draft.
No, I'm talking about the strategy.
The
I'm talking
exposure
about.
draft, Minister, suggests that, and this is what they say in their submission, these proposed changes will not improve workers' health, but instead exacerbate their injuries and cause further harm. Is that improvement to work health and safety?
Mr. Tudor-Hope, we're expanding the jurisdiction, the bullying and harassment jurisdiction of the Industrial Relations Court. We have established the whole of government return to work strategy. There are over 3,000 public sector workers today that have capacity to work, and there are artificial barriers that your government didn't take on the challenge to fix.
So let me just ask you
And we
about
have
that.
spent-
Order. The Minister stands in
Well,
question.
Chair, I have limited time. This is not helpful in terms of getting through the question.
I'm not interrupting you. I'm just asking you to call to order to get on with it.
Minister, let me just ask you this. There is another bill, is there not, in relation to the amendment of the Industrial Relations Act?
A proposal will come to.
Why haven't we seen that?
What do you mean?
Why isn't there an exposure draft?
I don't work on your timetable. So
Treasurer,
I don't
can
work
you tell
on your
us-
timetable.
Can you tell us?
Can I
House of support it.
Mr. Tudor, this bill obviously is an exposure draft. As I said at the outset of my ministerial statement, it's not the government's final position. And in fact, whilst I well and truly accept the view that exposure drafts are simply that, but we think it's a good thing we've released it to allow people to see the detail in time before we present it to Parliament. You are also right to say that accompanying such changes, the government intends to introduce the biggest shake-up to WHS laws in New South Wales to help us shift towards a culture of prevention. That will establish a bullying and harassment jurisdiction as effectively the third wave of the work that this government has done in 2 years. We obviously restored the independence of the umpire by removing the wage cap. We've done in the last Parliament extended the system in respect to gig economy workers. The third component of what we wish to do, amongst other changes, is to establish a bullying and harassment jurisdiction, because a person who works for the public sector should have the same right as a person who's in the private sector. Equally, you're quite right to say that the exposure draft contemplates a system in which the two systems operate in parallel. The reason why that's important is because no workers' compensation scheme can order any employer to change anything. Nothing. And part of the reasons why having a modern industrial tribunal that is capable of concurrently exercising power on WHS law at the same time as it's making workers' compensation determinations is to remove psychological hazard. I think, Mr. Tudor, what you agree on is that we want to prevent people from being injured. And we actually want the legal edifice to reflect
is it your
that.
belief that this solves a financial problem, or does it solve workers getting injured, Treasurer?
Well, both. I mean, and I'd just say
that the exposure draft you've given us,
Yeah,
and your opening statement today is not about preventing injuries, it's about your bottom line, isn't it, Treasurer?
no, Mr. Tudor-Hope, because I go back to the same point, which is it's not like these resources are being expended particularly well. It's not like this is a system that is working and we are taking money out of a system that is succeeding. What is happening here is that a system that was built predominantly to treat physical injury is now having to respond to psychological. Yes, it's going to need to adapt. Yes, it's going to need to modernise. But I think we have to all acknowledge the existing system is doing a terrible job. and that is failing businesses.
And this bill is the solution, is it, Treasurer?
Well, it's certainly part of it, Mr. Tudor-Hope, is what I would put forward. And I would simply reflect on this, that other states have had to modernise their systems too. They did it from a position that is far more financially precarious than our system is, albeit our system is very financially precarious. The reason why, even under these changes, this will remain the only system in the nation that is prepared to offer lifetime income support for injured workers is because we are responding at a time where the finances permit us to think about it as a task of modernisation, not as a pure task of crisis intervention. When other states, including other Labor states, have had to reform this, in places like Victoria, South Australia and Queensland, when you find yourself in a situation in which the finances deteriorate even further, you end up in a scenario in which the changes need to be more dramatic. We accept the fact that these are hard changes that are involved, but I'm here to say to the Parliament, doing nothing is not an option. Doing nothing is to lock in a system we know is failing. Doing nothing is to condemn even more workers to a system that's not succeeding and to ask businesses to pay more and more, knowing full well that those resources are not being well expended. That is the reason why we say, yes, these changes are hard. But the broader change that New South Wales needs to make is to break this set and forget mentality, which means that we ignore these problems for 10 years, we find a system that is under pressure, and then we have to change it rapidly. I would prefer a scenario in which we are regularly making adjustments to reflect the conditions that are emerging at the time. That can't be achieved in any one set of reforms, but I say that right now, that in the absence of reform, we are running the risk of an entire system collapse, and I don't think that's acceptable.
My turn?
That's the time. Oh, sorry. Come on.
Thank you. Good morning, Treasurer. Good morning, Minister.
I'm sorry.
Treasurer, you have said a number of times already that you're open to changing from what you've presented in this draft. But you've come here this morning and given quite a brazen ultimatum as well, where you've said to us that if you, and as reported in the SMH, that if we don't pass reforms, that you aren't going to pay what is owed by your government into the TMF for the next year. Is that correct? How do those two
I won't
things...
be putting cash injections. So just to be clear, that doesn't affect claims. What it does mean is that over time, liabilities exceed assets. And I would simply say that I've also made it clear that reform is needed. I didn't say these reforms, I said reform. And I simply make the point that we are open to change, but we are absolutely upfront about the fact that continually having to borrow money to put into a system is getting more expensive. It's not sustainable. And we cannot continue to borrow money and cash inject because it absolutely is crowding out our capacity to respond to so many of the other states' pressing needs.
Can we just come back to that, though? Because you've shown your hand this morning where we finally have heard that this is about the TMF and not the nominal insurer, which is what we had suspected all along and what is borne out by the nominal insurer liability valuations that were finally released.
No, the nominal insurer, I don't agree with that premise, Ms. Boyd. The nominal insurer is under equal distress. It's just that distress doesn't belong to the state.
Okay, well, let's just talk about the TMF then, because the TMF is effectively where you put in premiums, effectively, to cover the workers' compensation for public sector workers.
Yes.
Right. So you're basically saying this morning then that just like we had the discussion with so many other stakeholders who don't want to pay their bills, like the private health insurers last year, you don't want to pay.
No, that's an incorrect rendering of the way it works, Ms. Boyd. Bear in mind that the budget position in the TMF is affected by three dimensions. The first is premiums. The second is the liability record, which impacts the operating result. And the third is the cash position. Just to be very clear here, the premiums aren't affected by any change position I made this morning. In fact, my expectation is that premiums are going to go up for every public sector agency year on year on year, and that absolutely is going to crowd out their other forms of spending. As it is, if you simply pick up the annual report of every agency in the New South Wales government over the last 5 years, you will see the biggest increase in employee expenses is not wages, it's premiums. That's going to continue. There is absolutely no doubt that that's going up. So the view that's being put forward that somehow the premiums are not going to be paid, that's not correct.
Okay,
The second
but as
dimension
the
is the
employer-
$2.6 billion liability will be booked in the budget, and that will be booked on the operating result. The third part is the cash position of the TMF, and that is the money that is required to keep assets equal to liabilities in cash terms. That I'm absolutely is crowding out our capacity to invest in schools, to invest in hospitals, and meet the other states' pressing needs. Because when we
let
borrow
me just
money,
stop you there because my time is limited. How exactly are we going to have well-functioning hospitals and schools and everything else if we have public sector workers with psychological injuries that aren't supported by the state under its workers' compensation system?
It's a great question. That's why we have to have a culture of prevention. But right now, not $1 that I'm injecting into TMF, not one, is going to any preventative measure in the public sector.
Do you think
The
that
IRA
these
sorry, Ms.
workers,
Boyd.
though...
Order.
Sorry, Ms. Boyd.
Treasurer's answering the question.
Not $1. In fact, because we're having to put so much money into the TMF, it's stalling our ability to fund preventative measures in the broader public sector. And I made this point in March. I would much prefer to put the money up front and invest earlier in the prevention cycle. That is not happening when every 6 months we're booking a $2.6 billion deterioration. That is just the reality.
Can I
of it.
just ask the
Sure.
Minister then, there have been so many great initiatives that have been initiated under your department in relation to improving prevention measures. All of those things that you have set in train, do you expect them to actually have an impact on reducing psychological injuries?
Miss Boyd, it's a good question, and I think that you need to look at it. You need to look at this holistically. What is the cause? And as I said in my opening statement, that we've seen a large volume of psychological claims.
Yes.
The issue is that it's not it's a lot of these claims, unfortunately, are the interwork relationships, and we don't have their industrial relations matters.
Okay.
And we don't have a system to deal with those.
But the question
And
was, do you think your prevention measures are going to work? Is that why you've put them in place?
Well, I believe so.
Right.
I mean, we're
So-
working with the Black Dog Institute. We're working with
exactly.
with renowned organisations that are helping the government and helping support agencies, and we're also investing in our strategy.
So apologies for interrupting because my
Sorry.
time is
No,
so
I
limited.
understand.
But Treasurer, given that all of these things have now been put in place, why on earth wouldn't you let those prevention measures play out before cutting people out of the system and making them sicker?
Yeah, look, Ms. Boyd, I very much understand the point you're making. And I absolutely would like to say to you and to the committee that should we found ourselves in a situation in which parallel reform had the prospects of working, we absolutely would have. We have been doing it for 2 years.
Can I ask, sorry,
Ms.
just
Boyd, I
one-
need to finish. You asked a very good question.
Sorry, it's just...
But I'd simply say that the rate of improvement of a result of the preventative ideally should have started in 2018. That's when the claim numbers went from 5,000 to 6,000 to 12. Had that investment taken place in 2018, we would have been in a very different scenario today. But the rate of improvement that the Minister's excellent initiatives are engendering have a reasonable prospect of working, but not at the rate in which it's deteriorating. And that's the issue. And Ms. Boyd, I
almost like
accept
this
the
isn't
point that
about
it's a
prevention
hard
then, isn't it?
reform. I
The
accept
Honourable
the
Mark
fact
Latham,
that's
your
hard.
time.
That is the answer.
Thanks, Chair, and thank you to the two ministers who've attended. Treasurer, you've given us a 43-page exposure draft to analyse in 1 day of hearings, and I've got a big pile of submissions that have lobbed on my desk as the hearing began, and they're from serious organisations. I think it would help the committee in the various elements of the exposure draft. Have you got costings of their
Yes.
net benefit and impact on
do.
both the TMF and the nominal insurer?
I do. Do you wish to ask about any specific component?
Yeah. What you've got them tabulated, have you?
I do.
Okay. Well, perhaps for saving time, if you could table those for the benefit of the
I
committee,
might be
because
able
I
to
don't think they've
provide-
been otherwise available.
Yeah, we can provide you
Have they?
some information. To
No,
that.
no, all information about the cost impact and savings of each of the elements of the bill.
Yes. I
Okay.
think we can
So,
provide you
so
some of
following
that
from that,
information.
Treasurer, is it possible, given your emphasis on this as exposure draft, that this is in some way an ambit claim in the lingo of the union movement, that you're going to find out what you can get through in terms of union consultation, the caucus, this committee, and then trim it back to what you need to do in the aggregate of those savings?
Well,
Or do you need it all? Can you tell the committee you need it all?
Well, I'd simply point out that the reform as contemplated in the exposure draft will only return the scheme to solvent. It will not return the scheme to surplus. There's no margin being put into this.
Return it to solvent, is that the word you use? Solvent.
Solvent. It will return
Not
it to
surplus.
solvent,
Right.
not to surplus.
Okay, so you need it all.
Well,
it's not an amber claim.
Yes, but I would just simply say, be very upfront, we are getting very good suggestions from the trade union movement. We're getting very good suggestions from the business community. We're getting very good suggestions from members of parliament about ways in which the same problem could be solved through alternative remedies. And we're contemplating that. But I would say that certainly the exposure draft would put us back to a position of stability. But I want to be very clear here, the need for reform will have to continue. And one of the points that is being made to me and the Minister, certainly by the business community and by the trade union movement, but especially by the trade union movement, that again, more reform is going to be needed. And if we're serious about engendering a change to prevention, and we're taking those suggestions very seriously.
Okay, well, thank you for clarifying the rules of financial engagement that we get out of this bill. And congratulations on your ballsy approach of threatening the Parliament not to top up the TMF unless we pass your reforms. But do you think your credibility in that area is absolutely shattered by the fact that the government in other areas is contemplating and indeed encouraging the most lavish, opulent public outlays you could possibly imagine, and indeed it's an insult to the workers, the injured workers of New South Wales, that you make that threat while entertaining those other outlays that are off the radar in terms of their lack of public interest and dimension of spending?
Well, I will leave it to others to judge my credibility, but I don't know which initiatives you're referring to as being lavish.
Well, your Premier, through his Labor colleague Steve McMahon, is actively facilitating a gross expenditure to buy a racetrack of $8 to $9 billion, $5 billion net. And in that context, to buy a racetrack, including a $100 million subsidy, $8,000 for the high-income earners of the ATC, I think it absolutely shatters your credibility in making this threat to the Parliament and the committee today. So if you can rule it out on the TMF, you're not going to put any more money in. Don't you think your credibility would restore if you rule out other areas that are off the radar, opulent and lavish, including the $8,000 subsidy to ATC members, people living in mansions, millionaires, getting $8,000 subsidy from a Labor government, when you say you can't put more money in for injured workers in the public sector?
Mr. Latham, I just simply respond to that by going, the government is not at this point in a position to make a decision on that because no proposal has come forward. But I take your point about the need for us to be very careful on every dollar we're spending, and I take your point about you certainly will reflect on my credibility depending according to the position we take.
Okay, well, what about your Premier?
Well, again, I can't. I would simply refer you to what the Premier has said, which is that the government will, when it comes to the matter of the ATC and the Rose Hill submission, that should there be a submission that is made, at first instance, the ATC membership needs to decide whether or not they are interested in making a proposal.
Well, he said more than that. He said he's entertaining and he's quite encouraged by the proposal. But anyway, we'll set that aside. Treasurer, overall, isn't this a case of chickens coming home to roost? In that for a generation, the left of centre politics has encouraged a snowflake society of hurt feelings, worrying too much, things like trigger warnings, microaggression. And now isn't this just a quantification in money terms of what all that nonsense means?
Well, Mr. Latham, I think workers are psychologically capable of being injured at work and psychologically. I do believe that workers who are entitled to a system that can respond to them. And whether you wish to attribute it to broader changes in culture and whether you wish to attribute it to one side of politics over another, I can't comment on. I can only deal with the situation that's in front of me, and I would simply say we want a workers' compensation system that is responsive to this modern workforce.
Yeah, but essentially the snowflake society's gone too far. You or your office have briefed the Daily Telegraph today on a case of a fellow claiming up to $1 million because he was targeted at work and micro managed at work. Isn't this
My office
indicative of
hasn't
the thing
briefed
that I'm
anyone
talking?
like that. We don't do
Well,
that.
where do you think the Telegraph got that case study from?
But all I would simply
I
say,
mean,
Mr.
old poison
Latham,
dwarf could barely spell
Order.
his name, let alone do his research.
Order.
Mr. Latham, the only point I would observe is that I'm hearing and meeting lots of workers, and there's lots of case studies of workers coming forward who've had terrible experiences with the workers' compensation scheme. And I'm also hearing lots of businesses that are coming forward with terrible experiences with the workers' compensation
Well, why are you doing
scheme.
this?
Order.
Because
It's all
but
terrible. Why are you doing this?
The
Well, because I'm
questioning
making the
moves
point
after the answer to
is
the
that it's
government
failing. Sorry, just on that, why we're doing it is my only point is when you have businesses coming forward with case studies and you have workers coming, unions coming forward with case studies of workers being terribly treated, it just shows the point I'm making, which is the system is failing workers, it's failing businesses, and it's failing the state.
Honourable Bob Nampa.
Thank you, Chair. Treasurer and Minister, thank you for your time today. You've both indicated your concerns about the poor underwriting position of the scheme and the risk to the solvency and the sustainability of the scheme without reform. Do you have any indicative figures of the deterioration that might be attributable to the scheme without the reforms being proposed through the exposure draft?
Yes. The best way of me being able to answer that is to simply say, when it comes to the nominal insurer, and I just go back, the nominal insurer is the predominant insurer. It is covering 3.6 million workers and roughly 340,000 businesses pay into it. And just by way of reference, there's only 52,000-ish businesses that pay payroll tax. In the absence of reform on the NI, we expect at the next valuation for its assets its liabilities to exceed its assets by more than 20 cents. That is, we expect the funding ratio to be dropping to below 80. Of course, the final determination needs to be made, but that's what our expectation is. I would say that I previously said to the Parliament the consequence of that is that the businesses will certainly face premium increases of 12% if they have no claims, but it's entirely possible it may well be more in the event the scheme deteriorates further. There are other experts that are coming today from iCare and from Treasury, and they will be able to provide you with some more information on that.
So the risk without reform, so presumably the premiums are currently set at levels that will cover the cost of the scheme,
Currently the premiums, what the technical term is the break-even premium. And the break-even premium is what's required for claims that are coming in today and the cost of those claims. Currently, premiums have to meet the cost of expected future claims, but in effect have to collect the previous claims that weren't funded. Actually, it's likely to be higher. And so the break-even premium is got to be required to effectively mean that anyone who joins the scheme today, their claim can be funded. But we still have this backlog of underfunding in the scheme, and that is still going to remain.
The funding ratio of the scheme is obviously a mixture of what's happening in the current financial year and what has been happening over the long term to the scheme. What are the other, I suppose, financial risks that have been posed to the sustainability of the scheme? Obviously, the increase in psychological injury is one component of the risk of financial sustainability. What are the other components of pressures that are faced by
Fraud. Fraud is definitely one. The second is, of course, the investment performance. It obviously does affect the financial sustainability of the scheme. And taking one step back, because the investment performance has been good, it's actually bought us more time, not less, but it's really at max capacity in terms of its ability to function. And then, of course, the third dimension is that the costs of the scheme itself is another risk the Minister's already been acting on in terms of reforming and lowering its cost. And the final component of that is really it all turns on how quickly we get people back to work. Ultimately, though, I would just stress again on financial sustainability, the best thing we can do to protect the financial sustainability of the scheme is to prevent people from being injured. And the big macro change we need to do is to engender a change in the culture towards prevention. I'm not going to sit here and go that there's any one scheme structure you can put up to that will permanently protect the workers' comp scheme. Actually, the WHS laws and our capacity to use our workplace health and safety laws to stop people being injured is the long-term solution, medium-term solution and short-term solution to a lot of these problems.
In terms of the principal risks of financial sustainability of the schemes that you've just sort of run through, I suppose in descending order of financial significance, what are they?
In macro terms, it's definitely the return to work rates. We have to get people back faster. Right now, we're asking a workers' compensation system that was really determined there for physical injury to now make very complex decisions around psychological injury. Just to take one step back, a workers' compensation system has to do two things. It has to determine whether you're injured, but it also has to determine whether your injury was caused by work. That causal element is, the first part is actually the least contentious as to whether you're injured. The second part is the most, is whether or not you've been injured by work. What we are seeing is, of course, when it comes to physical injury, that's just a clearer cut for its fact pattern in general. That is, if you trips and falls are still the most common form of injury that the system deals with. If you trip at work, if you sprain your ankle, if you cut yourself, they are easy to determine, frankly, that you are injured and the injury was caused by work. That is what the system was designed to determine. Obviously, when it comes to issues like psychological, it's just more complex. I'll say that in terms of the category of psychological injury claims, we are in the exposure draft drawing special attention to the fact of bullying and harassment. Bullying and harassment is interpersonal workplace conflict, is the other way it's been described. And obviously, in order for a claim to be established for bullying and harassment, someone has to be deemed to effectively have been the bully. Often that's another worker. Often that's what leads to contest. And that's often what is slowing down the system from making any liability determination whatsoever. And that is why a large part why psychological injury is half the rate of return to work or physical, because frankly the system has to respond to a set of questions it wasn't built to answer fast. That is part of the reasons why we do want to use expertise in the industrial relations system to help that task. The IR system has been built more to help answer that question than the workers' compensation system. But ultimately, it's I would just remind the committee, it's an insurance scheme. It's designed to determine whether or not care should be provided through this scheme, which requires the causal element to be met. And that is what often creates the conflict when it comes to psychological injury, which delays treatment.
If we're to assume these reforms do pass through the Parliament, how long would you expect for, I suppose, the impacts to flow through to the system with respect to securing the financial sustainability of the scheme?
Well, again, I said to Mr. Latham, these changes would respectively restore solvency is my expectation, and that would be clear from the point of next valuation. But that's why there's an urgency to the matter. The next scheme is valued, the next valuation is in 6 weeks' time, and that will determine the extent of its technical insolvency. And the further it falls into insolvency, then the more changes the Parliament will need to contemplate to restore it. Part of the reasons why I'm making a case for why change is needed now is not because of things to do with the budget, albeit, I'm not going to lie, that avoiding the cost is determined if will be reflected in the budget. Actually, it's the valuation cycle, which then determines the premium cycle, which then determines the state of the scheme's finances and the state of the scheme's sustainability. And right now, our issue is in large part, it's actually not that the system is poorly defined, it's that the system contains no definitions whatsoever. And this is why I say it's a task of modernisation. Other states have had to put down the basic ground rules of what is a psychological injury, what treatment do you get, how is the system going to assess it. Our system doesn't do that. And that's why I've said in respect to Mr. Latham and to Mr. Boyd's questions, which we're pretty clear about, and to Mr. Tudhope's, which is the exposure draft is designed to show us meeting that first task of actually the rules need to be written in law. Yes, we should contest what the rules should be. Yes, we should contest whether they're the right forms of rules. Yep, that's why we're here. But at this point, the New South Wales system provides no guidance to this, which is why there is so much litigation, which then creates further psychological injury. Again, as I think most of this committee would already know, the biggest cause of psychological injury that the workers' compensation system treats is the workers' compensation system. Yeah. It creates more injury. Secondary psychological injury. That's why we want less people in it. And that's why we want to shift towards prevention. But that is also why we are saying that the need to act is urgent, and the need to act prior to July 1, frankly, means that we are making these decisions with a better set of finances than we would be on July 2.
Just a final question from me, again assuming these reforms pass through to Parliament, has the government given some consideration to some specific services that may be rolled out to workers who may drop off the scheme as a result of the reforms?
Yes, we are contemplating that. And I think it's a very fair point that people have raised, which is if care can't be provided through the workers' compensation system, where can care be provided? We would absolutely be looking to see what we can do on that question as well. We'd be open to it as well. The other point I should just make is that we are also mindful of the fact that when it comes to the law, there's the earlier question you asked Mr. Nanvo, which is when do we expect impact, there's two dimensions to that. There's the financial, but then there's the practical. On the practical aspects, yeah, we are very eager to hear feedback from this committee, from the witnesses to this committee today, and from all the other consultations about what is the right time to activate each part of the system. Certainly, this system would have to commence, various changes would have to commence at different points in time. We do want to hear from the experts to make sure that that is being calibrated correctly and built appropriately, because we are wanting to understand as well that the system obviously is dealing with people. We take that very seriously. So we are certainly open to feedback on that question too.
Could I just intervene? Got 1 minute and 33 seconds. Treasurer and Minister, are there any final comments you'd like to make before the bell goes?
No, other than we are very grateful to the committee, we're very grateful for the questions, and we're very eager to continue working with you in this forum and elsewhere in the Parliament to see if we can resolve a solution to these problems.
Chair, have those costings been tabled so we can access them?
I will get a version sent to you, probably on notice, I suspect. I just have to double check that we'll provide the information, but we are looking to provide more
Treasurer,
information.
can I ask you when you expect a bill to be available?
Well, we've got to respect, obviously, this process, but yes, I expect the bill to be available actually after we hear from this committee, the witnesses today, and further consultation, but my expectation is that the bill will be available when Parliament resumes.
So by the time we get back to Parliament in 2 weeks' time, a bill should be available for consultation?
Well, the government will make a decision as to whether or not we're introducing the bill at that point in time.
In respect of the NI, of course...
Order. We're not... I sought to give the two witnesses an opportunity to make any final comments so we could keep things on track today. I wasn't intended to open up again for a round, okay? I was trying to give deference to the Treasurer and the Minister just to make any concluding comments. That's what was intention.
Excuse me, Chair. I just wanted to... Can I just make a final comment?
Yes, that was my intention, yes.
Yes, thank you, Chair. I just wanted to let the committee know as well that one of the other things is that when people do go on a psychological claim, when they have to wait on average 76 days to see a psychologist. So just to make that point, that where we're trying to help people, at the same time, the system is making them worse. Because as we know from research, if there is no intervention in the first 4 weeks while you're on workers' compensation, and if there is no intervention, no contact, you're going through a system that you're being re-traumatised because you keep retelling the same story, but nobody is assisting you. By the time you reach that 76 days to see a psychologist, you're at a point of no return. And this is what we're trying to avoid, and this is why the government is putting in serious and actively doing everything it possibly can at the front end, and this is why we're looking at this holistically.
Thank you, Minister. On behalf of the committee, thank you, Treasurer, and thank you, Minister. We'll move to our next panel. Panel of witnesses, and welcome to Mr. Mark Murray and Mr. Tasha Flores. Just to pass through, I think rapidly and quickly, the formalities, which is, of course, the formal by yourselves introduction of yourself by name, your position, title, swear either an oath or affirmation, whichever you prefer, the words of which are before you. Mr. Murray.
Thank you, Chair. Mark Morey, Secretary, Unions, New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Moray. Ms. Flores.
Thank you, Chair. Natasha Flores, Industrial Officer, Work Health Safety and Workers' Compensation Unions, New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, and welcome, and thank you for your submissions.
Thank you, Chair.
Submission rather has been processed and stands as submission number 20 to this inquiry. First questions to the opposition.
Do they want to make an opening statement?
Sorry, I'm moving too quickly. I apologise. Go back. Would you like to make an opening statement?
If I could, Chair, thank you. Throughout its history, the union movement has campaigned to preserve basic rights to compensation for injured workers, ensuring that workplaces are safe and that work is meaningful and can support financially the needs of workers. In my time in the movement, this is the third time we have had to stand up to attempts to slash support for injured workers. When a Treasurer has looked at the budget and decided that cuts must be made ahead of a broadly unspecific pending financial crisis. But what is different this time is it is happening at a time when we are all just beginning to understand and accept injuries to our mental health well-being require equal standing to an injury of a leg or an arm. Psychological injury is not a new phenomenon. We just know now, for the sake of our society, it should not be ignored as it was in the past. It is in this new context, recognising the link between mental health and work, that we must do more, not less, to support workers injured at work. There is ample of room for reform if we all work together to achieve this. But what this government is proposing is not reform. It is dragging us back to a time where we ignored psychological injury and mental health well-being. In March this year, the Treasurer delivered a ministerial statement calling for reform to the system with a new focus on prevention, interstate alignment and ensuring financial viability. Last week, the government released its exposure bill and a hastily pulled together bill and an inquiry. It is our view the bill is in direct opposition to the very principles outlined by the Treasurer. The new requirement to use either the federal or as yet to be legislated New South Wales bullying and harassment jurisdiction will only create a culture of litigation amongst workers and employers and undermine doctor-led care. We're turning the system into an adversarial lawyer's picnic. The proposed definitions of psychological injury and reasonable management actions will undermine existing work to prevent injuries and deny thousands of legitimate claims from receiving the support and care they deserve. The proposition to align the whole person impairment threshold for psychological injury with that of South Australia is a myth. We have been repeatedly advised by practitioners, due to the different diagnostic guidelines underpinning the system, our WPI are effectively already aligned. That is, if New South Wales was to increase its WPI to 30% for the equivalency to remain in South Australia, they would have to increase theirs to 60%. We are not, as they say, comparing apples with apples. Beyond this, the bill is riddled with legal loopholes to prevent workers receiving care and support. It is both a lawyer's picnic and a roadblock to workers getting the help so desperately needed. Most workers will struggle to get through the door of this new system. When they do, if that is even possible, they will enter a world of barriers, hurdles and further trauma. It seems this bill is less about preventing injuries and more about preventing claims. The New South Wales workers' compensation system is broken. There is no doubt about it. It fails workers and employers through poor claims management, needless bureaucracy and falling return to work rates. But the blunt instrument approach taken by this exposure bill will only see further cracks for injured workers to fall through, repeating the mistakes of previous Labor governments and the Coalition in 2012. Now in 2025, we advocate a new approach. Please, delay this bill. Establish a real review to consider all the options on the table. Bring in the experts. Hear directly from workers and employers. Give the range of the currently underway programs for prevention and whole of government return to work program a chance to have impact. When we run our campaigns, we usually have workers speak out. Unfortunately, many of the workers we wish to speak out cannot. We've released a report today of 10,000 responses from workers. And I just want to read one of the comments that came through that I think typifies why this system is so important. And the quote is, "The workers' compensation system is the only reason I am still alive. I had suicide attempts as a result of my workplace culture and psychological injury. without being able to access essential mental health services and receive diagnosis, treatment, education and support to begin my recovery, I have certainly taken my own life. My whole person impairment is 24%, which is very significant injury. If the threshold was increased to 30%, and that affected me by taking away my entitlements again, I would be destitute and would have no hope of survival or recovery. I think in the Treasurer's submissions and public statements, he's failed to focus on one person, and that is the injured person, and that is the problem with this system. Thank you, Chair.
Thank you, Mr. Murray, and apologise for jumping over the opening
No,
statement.
it's okay, Chair.
The Honourable David Shinto.
Thank you, Chair. Mr. Murray, you sit on the board of ICARE, don't you?
I do, but I've taken a leave of absence.
No, I accept that,
Yep.
and I'm not suggesting that you are acting inappropriately, but in that capacity, has ICARE considered partnering in relation to prevention activities in relation to psychological injuries?
My understanding, there is partnerships going on and projects going on in relation
And there is
to that.
research being done in conjunction with ICARE in relation to that?
That is my understanding, yes.
And the Black Dog Institute is involved in providing some
I'm
of
not
that?
completely sure, but I know a number of institutions are.
And ICARE's funding for research by the Black Dog Institute, when does that due to finish?
Can I take a point of order?
Soon, I think, but not across that in
There has
detail.
been a point of order taken, so we just need to hear that.
These questions are more appropriately directed to ICARE, which is appearing later on today.
Well, he's the director of ICARE.
He's on the board.
He's on the board of ICARE.
Yes, I think
In terms of operational questions of ICARE, I think it's more appropriate.
I won't rule against the questions for the moment, but
Well, if he
we are
doesn't
focused-
know, if you don't know,
I'm just
Mr.
saying,
we
Murray,
know
I'm
this is
happy-
an
I'm
inquiry
here
into
as
the exposure
New
draft
South Wales
institute.
Secretary,
Yep.
not as an ICARE board director.
Well, but let me ask you this. Are you aware of any injured workers who have been assessed for a psychological injury with a whole person impairment of 31% or more?
I'm not directly aware of any workers over 31%, but we have spoken to a number of experts. A couple of them are appearing here today. There are a few that are over 31%, very small amount, minute. The vast majority are between 15 to 20%. Some of the most severe ones that I've heard of are of 24, 25%, and they are very, very... Workers have been both physically and psychologically injured terribly, but no, that threshold of 31%, my understanding with talking to doctors, psychiatrists, is that 99% of claims will never get over that threshold.
And if I could ask you this, is in relation to the provisions contained in the exposure draft for a requirement for a finding by a court, being the industrial relations or a new commission or tribunal, before an initial notification of a workplace psychological injury relating to bullying and harassment can be made. What are your observations in relation to that as a process for an injured worker?
So, firstly, our position is we're opposed to that proposed jurisdiction. Secondly, that proposal will only re-traumatise workers who have to appear. Thirdly, it actually says to those workers that we don't believe you, and you have to jump additional hurdles. We think that jurisdiction will become a lawyer's picnic, and it will reintroduce lawyers to the system. And as we know, lawyers are paid by the hour, not the outcome. And so we think this will become a very litigious area and very problematic for injured workers. And finally, the claims have to be dealt with within 8 weeks under this proposal. Firstly, we don't think the Commission's got the resources to do it within 8 weeks. And for workers to be without support or payments in that 8-week period only compounds their psychological injury.
Was there any consultation done with you prior to this exposure draft?
We have been meeting with the government in relation to broad topics based on the Treasurer's statement. We have put a series of proposals to the government on the problems we see with what they had articulated to us, and nothing's really moved since then.
So have you identified improvements to prevention measures that the government could be looking at as the correct model for dealing with these sort of claims?
Yes, we have.
and on the face of this document, they're not on the exposure draft. There is nothing in this exposure draft which seems to address that issue.
Which has been one of our greatest concerns, is that these reforms would go through. We haven't seen any articulation of funding provided to preventative programs. There are programs that are being initiated, I know, in health, that's in its infancy, in the police service. In education, it's in its infancy. The police service are doing a similar thing around wellbeing and keeping people at work. But for example, an institution like the health department has no programs in place that we believe are effective.
And that could be all addressed by a different model than this one.
Our preferred position is that we should be looking at a preventative approach, that the government should articulate and fund a preventative approach over the next couple of years. We're happy for there to be an expert panel that is picked that oversees those as trials to see what happens. And I think, as the Treasurer said, he talks about these cases staying in the system. The preventative approach would assist in ensuring that people don't enter the system at all. If you finish a shift in the health system and you've had people dying on you during that shift, no one at the end of the shift says, how you going, are you all right, checking in. I don't believe there's enough, whether you're in education, you've been threatened in the classroom, those sorts of things. There's not a process to debrief people and support them to continue to do the jobs. Some of these jobs, like some of the unions will be on after me, but child protection workers, 20% shortage of staff, overworked, removing children from their parents, sobbing and crying. That's not an easy job, not a job I'd want to do, and I don't think there's appropriate support mechanisms in place for those workers.
Prior to the election, did the Treasurer or the Premier or the Minister for Industrial Relations Workers ever suggest to the Union New South Wales or to Injured Workers Network that their pledge of support for injured workers excluded workers with psychological injuries?
No, and I think you would have seen the story in the Herald last week where we had photos of 20 of the 22 current ministers signing the pledge, and there's a number of backbenchers who have also signed the pledge.
Well, so what commitments were given to you at that meeting? I think it was on the 14th of March last year, in 2023. What commitments were made? Were they actually commitments that there would be no change?
No, there were commitments that they were going to work to improve the system. They signed on to look at the provisions that cut people off after 5 years from their payments, and then 2 years later their medical. There was a commitment to look at the system and try and improve return to work rates. There were commitments to make it a better system where it wasn't just simply about cutting benefits and cutting people off the system.
So is it your assessment of this exposure draft that is completely contrary to the pledge which they had made?
I think the ad that I'm currently running on television and radio is a testament to answer that as yes.
In respect of the bullying and harassment division of the IRC, do you expect that that will have the effect of deterring people from actually making claims in circumstances where they have a legitimate claim?
I think it will be a deterrent. It legalises a process that should be dealt with medically. I note the comment of Ian Hickey yesterday, who will be appearing today, where he said he was concerned that this reform was being dealt with by a treasurer from a financial perspective, not from a health perspective. And I think that is a significant issue, that that process will re-traumatise workers. And as a result of that, it will be a deterrent to workers coming forward and making claims.
I just returned to the position that you're a director, a board member of iCare. The Treasurer has told us today that iCare would be insolvent in circumstances where this legislation or a variation of it was not adopted in terms of dealing with psychological injury. Is that your understanding?
My understanding that there has been an ongoing problem with the financial sustainability of the system. For us, one of the biggest problems is, and there's a number of problems, but firstly, return to work rates. Yep. Getting people to get the help they need when they are injured. As the Minister for Industrial Relations says, there's a massive wait to get in to see a psychologist or a psychiatrist. People sit at home, there's problems there. There's also problems with the medical profession in the way in which they talk about when you're actually performing an operation or dealing with it, you can charge up to the certain amount. The full amount is always charged. I think there's a number of providers who are supposed to manage claims and return people to work who are not doing that effectively. I think there is a lot of waste and inefficiency in the system itself that doesn't return workers to work, and it's problematic. And I think we need to reform the system to ensure that it is solvent and it is delivering not just for workers and unions but also for employers.
The Treasurer also made reference to the fact that iCare was part of the sustainability was also impacted by fraud. Is that your understanding?
Yes, I believe there is fraud, and I don't believe it's just injured workers. I believe the medical profession, there is fraud going on there. I believe there's fraud going on with the way in which claims are dealt with. And one of the big frustrations is in this bill, although it touches on large businesses and small business underinsuring for the number of workers they have, many of the large corporations...
But that impacts on the NI, not the TMF.
Yeah, but it's still a scheme. That is a drag on the system as well. And not in that context, I'm talking about when people say fraud, people always jump to the injured worker. There are a lot of other people in the system who are perpetrating fraud, who underinsure. They put it in as a cost of doing business because the fine is so minimal that what do they care? And that is, I would say, a great example of if you find an employer doing that, then you'll find an employer that doesn't have safe work practices in its organisation, and that's what's contributing to injured workers, and that's why these workers are in this scheme.
So, I just would you summarise this exposure draft as a betrayal of what was put to you prior to the election by the Treasurer and the Minister in relation to amendment of this work?
A poorly
this act
drafted piece of legislation, or whatever it's proposed legislation. I am, to say, angry, disappointed, very frustrated with commitments that were given about protecting injured workers, and very frustrated about the process that this government has taken, given the commitments it had given prior to the last election.
Move questions out to Honourable Abigail Boyd.
Thank you, Chair, and good morning to both of you. This is not the first time that you've appeared before an inquiry in relation to workers' compensation, and you have contributed on many, many occasions to reports of or inquiries of this committee, but also of a number of other inquiries that have been conducted. Given all of the recommendations that have been made over the body of all of that work over all of those years, were you surprised to see these recommendations being put forward by the government?
Yes, I was.
Do you think that this, given that these set of reforms don't appear to be based on any sort of evidence of prior reviews, do you think that this is a reform primarily driven by the government's budget bottom line and not by the interests of workers of the state?
Yes, I do. And I'd also say, Deputy Chair, that there have been a number of reports done, probably enough to keep my front door open forever. McDougall, except for one recommendation we disagree with, has a series of recommendations on how to fix this. Recommendations in relation to the WPI shouldn't be used to assess the psychological health or injuries of workers. It's not a good diagnostic tool. We've been here so many times, as you say, with recommendations of how to make the system better to return workers back to work. And the fundamental question remains, how do you get a worker back to work quickly? Because we know once they get back to work quickly, they're more likely to stay in the job and continue to be there. There are some areas where return to work and making the workplace suitable for workers returning to work, where I think we need to do more work. There needs to be more support. And I'll even say there needs to be more support for small business to enable them to be able to do this and manage this. That's where the preventative stuff comes in. That's where we reduce the number of people on the system, and that's where we return the system to solvency. But just simply cutting workers off, I've seen this 3 times over the last 20 odd years. They keep cutting workers off, they keep cutting premiums, and yet the scheme remains in deficit. There is a fundamental problem with the scheme and the way in which this system operates, and a government needs to address that as the underlying cause, not cutting people off the system.
So the previous recommendations have looked at things like the problems with claims processing, with the adversarial nature of the system, but it's made clear recommendations that psychological injury is injury in the same way as physical injury, and that they should be treated the same on that basis.
Yes.
But also, they've talked about the problems with delaying the response to psychological injury and the extra cost that has on the system over time. Given that you've seen this before, and in your submission you talk about the impacts that these sort of changes have had, like the ones in 2012, are you concerned about the unintended consequences of untested, non-evidence-based reforms like this leading to even further damage to people who are already on the scheme?
I think one of the reforms that's in there is around provisional liability and people not getting that. The reason that provisional liability is in the scheme is no matter who you are, when you make a claim, that claim should be assessed quickly and you should be given the assistance you need at that point. Removing that means that, again, people will have to go into an adversarial process to get a claim recognised. And the provisional liability is important because the vast majority of people are not trying to rip the system off. They need that support. And I would say where there are problems with people trying to get money out of the system, not for real injury, that should be dealt with harshly because that's making it worse for everyone else who's there. But the system doesn't do that. The system just lets people through and there aren't those accountabilities for those areas. Now, I'm not saying that's a massive problem, but certainly using that as a basis to remove the provisional liability will disadvantage hundreds of workers who are coming into this system if this legislation is passed, who will not get any treatment, who will end up destitute, and it is not a way to address mental health problems in a modern society.
There's obviously a difference in reducing the numbers of people coming into the scheme by preventing them getting injured in the first place versus just saying, no, you can't come into this scheme. What will happen to people who are left out of the scheme, who have suffered, as we say, a genuine psychological injury? Where will those people go? What will happen?
I've spoken to my counterpart in Victoria where similar sort of legislation was proposed and implemented. They are now seeing people who are unable to hold down a job, often leads to family breakup, then leads to people taking out their superannuation and spending that, losing their houses, become destitute and on the streets. What this government is doing in New South Wales is shifting the problem from being a New South Wales government problem to be a federal government problem, to push people onto the federal health system, to push people onto the welfare system and not deal with the fundamental problem, which is this system isn't working and the system needs to be changed.
Thank you. Sorry to cut you off. Moving to the next question, the Honourable Mark Latham.
Thank you, Chair, and thank you and good morning to the two witnesses. What we're looking at here in the exposure draft is a fairly long and complex proposed bill, probably with about 20 different aspects to it, initiatives. Are there any of those that you support?
A couple.
Yeah.
A couple, but they're
A couple?
pretty
What are
minor.
they, Natasha, if I can ask, please?
So there is one provision in here around the right to privacy in medical examinations, and we support that. That is a right anyway that exists, but it's been abused over time. I think the information and about death benefits, that's sort of okay, and the PRE provisions are okay.
What are those other two? The indexation provisions
Yeah,
and what was the second?
PRE and death benefits.
Right, okay. Thank you. Mr Morrie, you're running these ads and it's a fairly stark demonstration of what appears to be a significant broken promise, the 20 ministers with the pledge held up for theatrical effect. Do you think there's any excuse for the breach of promise, broken promise, because of changed circumstances over the past 2 years?
I take the approach that workers' compensation is not a sexy industrial issue. It's never going to get on the front page. It's not about it's not about changing workplace rights. It's an issue where the union movement is fundamentally obliged to advocate for these workers. Because if we don't do it, nobody will.
Yeah, sure, but that's not what I'm asking. I'm asking, over the past 2 years, are there changed circumstances which, in your eyes, justify this sort of legislation in defiance of what was promised at election time?
As I said before, this is the third time I've gone through this. This is the third time I've heard the same arguments. They're tired old arguments about the system being in deficit, and workers are the ones who lose out. And I don't think there's any justification for cutting injured workers off the workers' compensation system.
I'll take that as a no. You mentioned earlier on in your opening statement fraud within the medical profession. Can you elaborate on that, please, as to what that involves in detail?
So we believe that there is doctor shopping that goes on with different companies. These are the things that we hear from our injured workers, their experiences, where one doctor doesn't give the right diagnosis, the person is sent to another doctor. They go round and round in circles in doctors. That is additional costs upon additional costs.
I can provide a bit of an example if you'd like. Something that sometimes happens is companies will send people or injured people to a preferred doctor. Injured workers not realising that they can choose their own doctor, and there has been in some cases a history of poor outcomes in that experience, where perhaps someone's, and I'm referring to a physical injury here, but workers were not diagnosed correctly and sent straight back to work, and when that occurred, the injury worsened over time. Eventually they got back to their own doctor only to find that there had been a broken bone, etc., and that had worsened in the 2 weeks that they'd been back at work. That's a physical example, so it doesn't necessarily help here, but there are problems in the scheme.
Yeah, well, thank you. Obviously, we need to get those doctors out of the system, because just because you've got a medical degree doesn't mean you're not money hungry and open to this sort of abuse. In the second sentence of your conclusion, Mr. Murray, in your submission, you state the first step the New South Wales government should take is to focus on preventing injuries before they occur. Mm-hmm. But in one of the morning newspapers, you give the example, I don't know if it's hypothetical or not, but students corralling a young, presumably female teacher in the school education system and barking at her Andrew Tate quotes.
Yes.
Which is what you've said. Isn't that an example, though, of something that shouldn't be happening in any workplace? And there are schools, of course, in New South Wales where it doesn't happen. They have very strong evidence-based behavioural standards and practices that ensure that there's no disciplinary problems, whereas other schools are a jungle. Isn't it the onus on the government to stop this from happening, even if you accept the proposition that anyone talks about Andrew Tate anymore?
This occurs in public and private sector schools. Both the unions have said that to us, and one of the reasons that young female teachers are leaving the profession is because of this sort of behaviour in the classroom.
But isn't it easily preventable? There are schools where this doesn't happen. Why don't we employ their policies to ensure that your sort of example is just not feasible? Like there's an evidence-based, the thing about school education, it's been studied all around the world. Mm-hmm. There's no argument left or right. We know what works, we know what doesn't. Mm-hmm. Why don't we just have the behavioural standards and practices that ensure we don't have psychological injuries for teachers in these circumstances? That it's a controlled, orderly, well-behaved school environment.
Speaking as an ex-teacher myself, and having a partner who is currently a teacher, who has actually experienced what you've just commented on, it's not necessarily that simple. You're dealing with parents who don't want to necessarily do what they need to do, and that's a problem in schools. So, you can be as harsh as you like with the pupils, but if you've got very difficult parents, and unfortunately we're living in a society which is very customer focused, and at the moment schools behave very much in that way. The parents are the customers and we want to make them happy.
Thank you.
Well, it's your choice to make them happy.
Thank you. We now move to the government question time.
They're unhappy.
The Honourable.
Yeah, I'd like to ask a question. I wanted particularly, I think earlier you said in your evidence that there was one recommendation of McDougall that you disagreed with?
Mm-hmm. Reasonable and necessary.
Can you perhaps
the inclusion of the and. Well, the inclusion of and creates a higher barrier to getting the services and treatment that you might need. So it basically, and we, as I said, we don't necessarily agree with all of McDougall's findings in everything that was done over the time that it was done. Reasonable and necessary could, for an example, the case, and I think it's Good versus New South Wales Racing. You've got a jockey who's been injured. He's a paraplegic, and in that case, it was determined that it was reasonably necessary to provide the payment for him to go home to England, where his family was, as part of his compensation, and other things that were necessary for him on that flight medically to make it comfortable for him as a paraplegic. That could maybe not occur under this example, where reasonable and necessary creates a higher barrier, and you're looking at what is a lower, we're only giving you the basics here. We're not going to look at things like your comfort on a flight that is a long, prolonged thing as a person with that sort of injury. Sorry, there was also an injured worker that we dealt with many, many years ago who was undergoing a specific sort of therapy for his psychological injury, which was a water-type therapy. I'm not an expert on these things, but he was a worker that came out and spoke actually on Four Corners about his experience with the Treasurer, who supported him at that time, and he spoke about this therapy being very beneficial for his psychological injury, which was quite severe. It was an unusual therapy, but in this circumstance it might not be covered. But that was helping him.
So ostensibly, is it correct to say that this change enhances or detracts from the principle of an injured worker's care being directed by their treating doctor?
I would say it detracts from that.
Right, okay. Can I ask about the underinsuring issue? I think the proposed section 173AA only applies to large employers.
Yes.
Can you explain?
That is very unusual, because you would expect that large employers would probably be more likely to do the right thing, or they would also be outsourcing a lot of their business. So, they might only have a small number of employees on the books, but a large number because there is a supply chain, so to speak. So I don't know why you would only go after large employers when there's very likely middle-sized, and I'm not picking on small business here, but, they should be wearing the cost as well if they're not doing the right thing.
The other problem with that is the regulators don't regulate. There's just no regulation going on.
I've got one more question that I'll hand to my colleague, Mr. Namva. Can you perhaps talk about one of the issues, obviously, with psychological injuries is the poor return to work rates. Can you perhaps talk about the elements in the proposed bill that will improve the return to work rates?
Nothing.
We don't think there is anything in there. I mean, as I said before, one of the biggest problems is getting access to psychologists or psychiatrists. I think the minister said there was 76 weeks wait to get in. That is one of the biggest problems, is that people, when they are identified as having injury, are not getting treatment at that point. They're having to wait. They're having to wait at home. It compounds the injury and it frustrates them being able to get back to work.
So Section 8A here says, defines a psychological injury, and from my understanding that needs a diagnosis from a psychiatrist. Now the injury also has to be of significant behavioural, cognitive or psychological dysfunction. So this is suggesting that before you even get through the door to get a diagnosis, you have to be extremely impaired. So someone who's at the beginning of breaking, for lack of a better word, is not included in this bill. So this delays treatment significantly, and then at that point too it requires a diagnosis from a psychiatrist. Now, treatment is not covered for that. So the worker, I would assume, has to cover that cost themselves. So at the outset, there's a big closed sign on the door of psychological injuries, closed for business, no access. You as a worker have to fund that diagnosis yourself, and that's not an easy thing. And then to be allowed through the door, you need to be extremely significantly behaviourally, cognitively and physically, psychologically dysfunctional. So by the time you even get through the door, you've got to be in a really bad state. So I don't see what that does for prevention, return to work. That's actually very, very, at this stage, you're not going to get someone back to work. So it's just preventing injuries, really. Preventing compensation for psychological injuries. That's where I see this bill. It just stops you walking through the door at the very outset. And if you do get through that door, the hurdles are enormous. The hazards are defined. So, in a bizarre situation where we've got a piece of legislation here that says only these hazards apply. If you trip, it's like saying if you trip over a chair and break your arm, we'll compensate that. But if you trip over the carpet and break your arm, we're not going to compensate that. So it's quite strange.
Just in the time left, Mr. Moore, I'm just interested in your public comments that iCare is the insurer of last resort. Obviously, the sustainability of any insurance product or scheme is predicated on the ability to spread risk across the class insured. What impact does the rise of self-insurance have on the sustainability, do you think, of the nominal insurer?
We believe it has a dramatic effect, because what you're doing is self-insurers are taking the best bits of the scheme out, the most profitable parts of the scheme out, and often they are the businesses as well that are self-insurers are ones that actually provide safe workplaces. So what you're actually doing is you're no longer spreading risk evenly across everyone. You're concentrating all the risk in iCare. That's why it's constantly under financial pressure. We think that self-insurers should be gotten rid of. Everyone should be brought back into the scheme so that the risk is spread across all groups, all employers. Having said that, there were changes in 2012 where employers previously got incentives and their premiums were reduced where they weren't making claims. We think that is something that should be brought back in, because we should be rewarding good employers who provide safe workplaces as part of the scheme. But taking out all the good bits, you're basically setting up, a Fannie Mac, Fannie Mae sort of scheme where all the risk is concentrated in one place, and it just can't continue to maintain that risk, and that's why we see the scheme collapsing.
Thank you. Thank you, Mr. Morrow, Ms. Fraser. Thank you for what's been a very rapid response, but, describe it that way, for your submission and also making it available today. It's much appreciated. So, thank you very much.
Just thank you, Chair, for your work, and the committee for taking the time to get this done so quickly. It's good to be able to present. Thank you.
That's our appreciation. Thank you. So we'll dismiss the witnesses we've just had and bring forward our next panel of witnesses, if we could, please. very much sincerely for making yourself available at what is, I accept, short notice with respect to this inquiry. And can I also at the same time thank you for what's been an equally rapid response, if I could use that phrase, to put together what are very comprehensive submissions that have been received to the inquiry and are being processed, or have been processed or will be processed as submissions, and indeed obviously written evidence to the inquiry. So just make those opening remarks if I could, please. I might also say, just so we're clear up front, there was a delay. First of all, the committee was 15 minutes late in starting. We've lost some further time as witnesses have progressed this morning through no fault of anyone. I don't intend to crimp the time of the organisations represented here at the table. So I will be proposing when we get through the rest of the formalities, whether or not, and you can consider this, it's in very much your hands, that with respect to your opening statements, if led to read them all, would obviously, in aggregate, cut into the time significantly. So my proposition is for you to consider, and you can answer it collectively in a moment if you wish to think about it, is that you table those opening statements, and if they're not typed, they can be typed after and got to us. They will be received as evidence, so that's aggregate evidence of your opening statements, which obviously would be helpful and provide them more time, effectively the better part of the time allocated to you, to be able to deal with questions and answers from the committee members. Does that make sense? If people want to make an opening statement, obviously you're entitled to do so, but I'm trying to maximise the time. So think about that as I go through the rest of the formalities, which does need to be done, which is to require each one of you, and once again thank you for coming, to identify obviously your name, your position title, swear either an oath or affirmation, whichever you prefer, and then we can get on with the formal part of the questioning. So perhaps if I start with my left and move across. So thank you.
Troy Wright, Acting General Secretary of the Public Service Association of New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Wright. Mr. Fallon.
Angus McFarlane, Secretary of the Australian Services Union, New South Wales ACT. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Fallon. Mr. Madu.
Jack Ayub from the Australian Workers Union.
Thank you.
I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Mr. Haynes.
Gerard Hayes, Secretary of the Health Services Union. I swear that the evidence now about to be given by me shall be the truth, the whole truth, nothing but the truth, so help me God.
Mr. Waits.
Michael Waits, Acting General Secretary for the New South Wales Nurses and Midwives Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr.
Amber Floam, Deputy President, New South Wales Teachers Federation.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Smith.
Bernie Smith, Branch Secretary, Shop Distributor of Allied Employees Association, New South Wales Branch. And I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Now just going back to the point I raised just before that formality. So as I said, your opening statements through the mechanism I've described, or the avenue, will be fully incorporated as evidence to the inquiry in its totality. So is there a consensus that is a way that proceed, or does anyone particularly like to make an opening statement? With that then, thank you for that. We'll then move to the opposition, the Honourable Damien Trudeau.
You'll excuse me that there are a lot of you. Some of these questions may refer to all of you or some of you, and if I don't ask you specifically and you want to contribute, feel free to contribute. But
just quick, not cutting it out, we have, including the Honourable Damien Trudeau, all your submissions in front of us, okay, if that helps. So you've got your submissions, we've all got the submissions, in case there's reference.
Mr. Wait, since you're in the middle, I'll start with you. When did you first get a copy of the exposure draft?
We received that at some stage last week.
And have you made an assessment of the exposure draft in general terms?
The team at the association has had an assessment of that, yes.
So from your perspective, and this can be contributed to by others, in respect of the proposals which are contained in the exposure draft and the impact in relation to psychological injury, do you anticipate that that would have an imbalance in relation to gender in terms of that cohort which are impacted mostly by the proposals contained in this exposure draft?
Our understanding is yes, 85% of people who suffer a psychological injury at work are women. We see the proposed changes as quite frankly abhorrent. There are systems of work within health, whether it is New South Wales Health or other healthcare providers, that are injuring nurses, midwives and carers who are predominantly women. And this proposed legislation will exclude them from compensation.
And I take it would you agree with that, Ms. Flynn?
Perhaps yes, if I could almost supplement with a workforce 80% also who are women. We see this as a significantly gendered issue for our membership, and if I may outline just a couple of case studies that relate specifically to the matters of sexual harassment and sexual assault, and how these examples highlight the risks that are before us all should this proposed draft bill proceed. Two recent and ongoing cases that we have, and unfortunately there are many, but they actually illustrate the concerns of the Federation and the impacts that that's going to have on our members. Both of these teachers that I will refer to work in schools that already have unfilled vacancies for their staffing entitlement. The first is a teacher in her 30s who was repeatedly sexually harassed at work and has an accepted workers' compensation claim for a psychological injury. She continues to access treatment and engage with mental health professionals, but is significantly injured and currently has no capacity to work. The other teacher that I'll refer to is in her 40s, and she was sexually assaulted at work. Her accepted workers' compensation claim enabled her to access urgent, and I repeat, urgent and immediate psychological services. Her injury, however, is very severe, and it is unlikely that she will ever return to the teaching profession. Without ongoing support, she may never return to any type of work at all. Both of these teachers really illustrate the need to access financial support and medical treatment while they engage in that recovery process, with the consistent aim, I think, of all parties, which is to return the teacher to work when they are well. They also would not have been able to use the government's proposed bullying and harassment jurisdiction to resolve these matters, because they are just not well enough, and we will not drag members like that through the courts to get an assessment of their injury.
Mr. Smith, I think you've made a submission or case studies along similar lines in relation to your members, and I think you have also, have you not, Mr. Waits?
Yes.
Can I ask you about this? Well, one of the principles you raised, Mr. Waits, is in relation to psychological injuries caused by excessive workloads. Would you like to comment on what this would particularly mean for nurses?
So we provided the New South Wales Health a copy of a report that we had commissioned in 2023 out of South Australia, and it showed that of the participants in that survey, 15% just had indications of PTSD. A significant other amount had indications of burnout. And this was related in the post-COVID setting to workloads generated by being short-staffed, poor skill mix, and increasing activity through those hospitals and aged care facilities. So we provided that to government. Health representatives dismissed it out of hand. We prosecuted, or attempted to prosecute, New South Wales Health for chronic understaffing at the Central Coast LHD. Rather than accept that, they argued a creative line that said they didn't have to provide staffing on the day, they just had to roster it. So it didn't matter what turned up, and they won on that technicality. We know that the thing that will fix the workload issues for our members is restoration from the wage suppression that they've experienced over the last 10 years and more nurses and midwives on the floor. But we see through the government's actions that they don't actually value nurses and midwives because they are fighting the pay rise that will fix the issue. And with the changes to this legislation, we see that they just don't care. Those workloads are injuring our members. They will not be compensable injuries under the proposed legislation. They will just be left to the social security services and no longer work. It's appalling.
Both the Treasurer and the Minister have indicated that this is a complete package and they want to talk about preventative measures. What discussions have you had, and this is open to all to either take on notice and potentially provide a response to, what discussions have you had, in addition to what you've just outlined, about preventative measures for psychological injuries? Has the government actually engaged with you about a system of preventative measures to reduce the number of psychological injuries?
The government has agreed to introduce the safe staffing levels. That will go some way once it is implemented, but the rollout of that is being hampered by a lack of accountability in the proposed clauses that will go with that. We see the healthcare system occasionally try to address the well-being of our members. Post-COVID, we saw one significantly large hospital in New South Wales offer staff to come down and listen to some jazz and have some pizza during lunch break. Nurses and midwives don't get a lunch break. So sometimes the attempts at addressing well-being may be well intended, but appear to me to be tone deaf.
Could I just add, in terms of the issue of workload, people may not appreciate it, but the retail industry is an industry under extreme pressure at the moment, both labour shortages and also what we would call the Audi Amazon effect, where both of those international global players are squeezing our industry and leading to chronic understaffing, chronic workload pressures inside workplaces. And just this March, I caught up with a bloke I've known for 15 years up on the mid-north coast, Wayne. I would have normally described him as relaxed, even laconic, and a really person who enjoyed his life. I saw him in March this year, and he's off work at the moment because of extreme workload pressures in his particular workplace. And I would describe him, the man I saw in March was a man who was heavily medicated, unresponsive, and couldn't get out of the house to enjoy life. That's the impact that these things have on people. And so we do need preventative measures. And in our submission, we would call for the Industrial Relations Commission to be empowered, like in other states, to actually deal with some of these issues to prevent the systemic understaffing of stores, so that we can avoid people like Wayne end up in that situation, and we can return him, and he can be in. So he doesn't get injured in the first place, but if he is injured, we need a system that looks after him in the long term.
Just, Mr. Tudor, if I may, we heard a lot of language this morning from the Treasurer about cultural change and all these things, and yes, that has to take place, but we've also got to acknowledge, particularly as it concerns our members, that there are some psychological injuries that aren't preventable, that will occur. I mean, I've got many case studies here, but our members more often than not are dealing with dead bodies and body parts, in tragic incidences. Work that is not often acknowledged because there is not red and blue lights. The government saw fit to make our members first responder status, and then they turn around in a sort of dark alley abacus stabbing with this bill, that really has the moral integrity of a King's Cross rubbish bin, and expect us to cop it. I mean, our members will not be covered for psychological.
It won't be a relevant event.
Won't be a relevant event. They won't have a close personal connection to the person who's committed suicide in the national park. I mean, they won't witness They won't witness the multi-car accident that happened near their work site that they were the first responders to. You know, so I mean, really, Section 8 is trash. I mean, that's the underlying point. But we've got to acknowledge that we can't prevent all psychological injury.
But have you, though, in terms of with your members, engaged in putting together a submission about not so much limiting their ability to make claims, but to, in fact, change workplaces?
We have actively in workplaces tried to get those supports in place. It was part of why we pursued the first responder status. We've been doing that for a decade, and it took us a decade to get there. So we have taken those active steps. We've also taken active steps, and I can tell you what, you get a hell of a lot of resistance from bureaucracy. You know, if it just takes changing a shift to get someone out of a difficult bullying situation. They'd much rather have them, you know, out of their hair. But, you know, we have taken active steps. What hasn't occurred, and I think it's to great insult to the sort of heavy people we've got in this committee, is this hasn't gone through a proper process. You know, that's why it's the dark alley abacus stabbing, you know, because we've just had this copped on us in the last few days, expected to turn up and have a reasonable contribution when we are starting from a point of consensus that we want to make the system sustainable, you know.
Can I just
Mr. Wright, you made an observation which I put to the Minister, that these proposed changes will not improve workers' health, but will instead exacerbate their injuries and cause further harm. Would you like to elaborate on that?
I would, thank you. I'd go to your first question though as well and add that, you know, whilst the Treasurer may talk and specifically about return to work programs and putting a greater onus on getting people back to work, we have, to their credit, to the government's credit, worked closely with them around a mobility process where displaced workers through redundancy are able to find jobs in other departments. We have advocated for years to that be extended to the return to work system, that people who are injured in one department cannot return to that organisation, are found a job in another department.
That was a recommendation, if I recall it.
That's yet to materialise. It's still in discussions, and well, the Treasurer may well wish that such a program is rolled out in the private sector and responsibilities are placed on private sector employers. But if they cannot organise that in their own departments, then what hope is there for that to occur? In respect to further injuring workers, I think our union's experience with our members is similar to everyone else here at the table, that it is a system where the delays, the poor case management, the poor resourcing of treatment lead an injured worker often to feel worse to having been exposed to the system than had they not gone into it in the first place. We agree with the Treasurer's remarks in that respect, but we do not believe that the solution to that problem is locking people out of the system. It's improving the system.
Thank you very much. Sorry to cut you off, just moving quickly. I might just rotate back to Abigail, but we'll deal with Mark later because you've had the first two calls. So Mark...
that's good because I've got a meeting in 10 minutes.
Okay, well, it's back to Abigail Boyd then.
You're a man of great... Well, I'll tell the important person I'm meeting with that you've dudded me.
Okay, well, it's back to you then.
But I was about to praise you, say you've got the powers of mind reading. But we'll set that aside.
You've lost 10 seconds already.
Mr Hayes, you haven't said anything yet, and you work in the health services space. Have we got an issue here in the whole nature of medical science and its understanding of the human brain? I think it's broadly acknowledged medical science, a wonderful thing and so many breakthroughs of use to humanity, knows less about the brain than any other part of the human body or indeed the natural world. It's often said about mental illness, we know everything about it except two things, what causes it and how to solve it. So if we've got an issue there that, particularly with doctor fraud, diagnosis fraud in this space, that it's such a poorly formed area of medical science as to what is actually a psychological injury.
Absolutely. I think we're in a situation at the moment that we're working with a system which really is designed for physical injury, and we're trying to deal with psychological injury. And psychological injury can be manifest in a whole range of matters, whether it's a personal matter or it's a professional matter. So we are trying to do the best with what we have, and what we have is just not enough. Recently, in the last 18 months, there's been the Special Commission of Inquiry into health expenditure. That's taken 18 months, and it's dissected to see where wastage is, and we're going so fast at this at the moment. My point is the system needs to change. There is no doubt about that. My concern very seriously is that people who are seriously affected, who have major problems, who become suicidal, what we do at the moment, we take them from work, we let them go and sit in their home by themselves and percolate further and further. At a point in time, we may try to get them to return to work. That is an incredibly frustrating process in itself. You may try to see a psychiatrist, which will take you at least 3 to 4 months. There will be people defrauding the system. Where there's a pot of money, there will be a lot of people who want to get into it. I don't see going so fast at the moment resolving this system the way we need to have it resolved. I do not want to see many of our members, and I think the nurses and the teachers have said it's very correctly, 70% of their members, something equivalent with us, or it's a gender issue. We need to be able to engage and get this right, because it's not going to stop now. Society has changed, and I think that was raised previously. The way teachers are treated, and your point is right, there should well be a way of accepting acceptable behaviour. Unfortunately, you go out in the street today, that doesn't happen anymore. We're in a changed culture, and we need to come to terms with that culture. At the front face of that culture is, whether it's teachers, nurses, certainly paramedics, a whole range of our health workers, allied health professionals, all these people are confronting it, and they're taking the load home with them. So my concern here at the moment is if we go too fast on this, we'll tick a few boxes, but we're going to kick this problem down, and the next 5-10 years it's going to get worse.
Yeah, I agree. It needs a lot more analysis and thought put into it, and certainly parliamentary deliberation what we're dealing with. But do you think, Mr Hayes, there's been an evolution of what is a psychological injury? I think it's established in medical science that some conditions are debilitating and severe, clinical depression, schizophrenia, those sorts of conditions, it's pretty well established. But we seem to have dropped down into what I would probably think of as social injuries, hurt feelings, worrying too much, breakdown in resilience, I'm feeling tired from the workload, and that obviously, once it's included in these schemes, is massively expensive. So I don't think there's an argument here about thinking about a tighter, more realistic definition of what's a psychological injury in the workplace?
Look, I think it's difficult to get to that point because what you say is correct. There is a whole range of different levels of how many layers to this onion are there? And going back to your first point, we don't understand the brain as much as we could. So this is a rapidly evolving area. If you go back into the 60s and the 70s, this wasn't even spoken about.
Of course.
This has really come into over the past 10 to 15 years, and so we're rapidly trying to catch up with it. So you're absolutely correct. Some of these injuries could be facilitated elsewhere, but they manifest in the workplace. But I'm not certainly a professional who's going to be able to deal with that. And sadly, given that post-COVID and the resourcing issues of health professionals, there's not enough of them out there to be able to actually get ahead of this at the moment.
Well, there's sort of a dark joke on the streets that if you don't plead mental illness in the courts or schools or at a doctor or in the workplace, you're the one that's mentally ill. It's sort of like Yazarian in Catch-22. But in terms of the medical profession, how do we weed out the doctors who are taking advantage of these loose definitions and opportunities to diagnose people as having a psychological injury when that's not the case, and they do it for financial reasons with our open-ended health system in terms of their own charging practices? How do we identify them and get them out and make sure that the real resources go to the workers who need it most?
I think compliance is just so important, and compliance with teeth is really important. There would be a whole range of issues that could occur at the moment. Nobody does anything about it. So the more you walk past it, the more you accept it. And I think that is what has got to take effect here. There could well be the situation which I argued in the SCOE. The money is there. It is being spent inappropriately. Redistribute that to where it needs to be spent. And maybe you don't need to talk about 30% or 25% or even 20% WPI. It's making sure the money that is spent appropriately as opposed to inappropriately.
Okay, thank you very much. Thank you, Chair.
Move to Deputy Chair.
Thank you, Chair, and thank you to all of you. We've talked a lot this morning about prevention and the need for prevention, and we heard from the government about changing workplace culture. But of course, when it comes to public sector employees, the employer is the government itself. If I could start with you, Mr. Waits, Beasley Special Commission of Inquiry into healthcare funding made very damning comments about the failure of the government to justly compensate workers within the health system for labour and services, and also focused on this concept of burnout for workers in the medical profession, due to a bunch of different things, and actually made the comment, some might regard this as a work topic. It is not. Workforce stress, fatigue and burnout are serious issues, and particularly so in a public health system. What does it say to your workers that they have an employer who is not only not going to pay them properly and is not going to take actions required to attract and retain workers, but is now going to turn their backs on them when the result of that is burnout?
As I said earlier, the only summation we can make is that through both the previous government and the current government, their actions demonstrate that they don't value nurses and midwives. And if the draft legislation goes through as it is now written, it will prove that they don't care.
Mm.
The injuries that our members suffer, I take umbrage at Mr. Latham's approach to the questioning there. Our members watch people die every day. They deal with extreme circumstances every day. But they also know every day they could be providing a better level of care than they are. They know that the person in that bed should be getting attention straight away when the buzzer goes, but they're with this patient here. That is a moral injury. This is not someone feeling tired at work. This is a workforce that is burnt out, crying out for help, and this proposal simply takes away the safety net.
If the government was serious about prevention, would they just instead fund properly the workers in the health system to begin with?
More funding for more staff, more funding for better paid staff, but also within health we don't have the safety and support services around us that other public sector workers do. So there is a paucity within health that is contributing to this. So there's a lot that can and should be done in the preventative way. What must not happen is take away the safety net before those preventative measures are put in place and able to work.
Thank you. Mr. Smith, this Parliament has in recent times taken action to better support retail workers when they are facing abuse from customers, for instance. We know that retail can be an incredibly hostile environment, as you have laid out. What is your view on where these changes would leave workers in retail?
Well, the concern we have is sort of multifaceted. We had a member, for example, in April this year who came across a body of somebody who suicided at Westfield Parramatta, jumping off the 5th floor of the shopping centre there. They probably fall outside the event requirements of this Act. We have members every day facing abuse and violence in the workplace. Now, sometimes they would be covered because it's an indictable offence. But if I was a worker, look, I went out to Bondi Junction the day we reopened the centre out there. And a lot of our members who had finished their shift before the event occurred were just as deeply affected as everybody else. They would fall outside the definition of the event because the people who sadly died on that day were not their work colleagues.
Yeah.
They're deeply affected. Some of them can't go back to work at that workplace. Some of them are likely to return to other workplaces, but it's deeply affected people. So, again, people don't often think of what our members see every day. And we welcomed the government's changes in relation to the offences, and we've seen some impact of those. There's more to be done. And again, in our submissions, we've called for more measures, again, to be preventative measures, to prevent that happening in the first place, things like workplace protection orders that we've seen effective in the ACT at the moment. But how do we prevent these things in the first place? We're all up for that. But we're up for things that prevent injuries rather than prevent claims.
Thank you. Mr. Ayub, it's not necessarily well known across society, but construction workers have some of the highest rates of suicide in Australia and in the state. What do you think these changes will mean for workers getting the help they need before they suicide?
Well, not only construction workers. I mean, our members across national parks, roads and transport, and Forestry Corp, just about every organiser you talk to has a member who has attempted suicide or who has committed suicide. Now, these people are being dropped by helicopter into fires, right? They're not captured. We had an incident on the Sturt Highway, I think last week or the week before, where our members were sealing a road. They're about 500 metres away from where a rear of queue crash happens, multiple fatalities. One of our members is holding a driver of a truck who's hanging out the front of a truck, severely lacerated. I mean, you can imagine the scene. He's not captured, he didn't witness it. He's just the first to arrive. Our national parks workers are often responsible for search and rescue in concert with emergency services. They often find people who have jumped off cliffs, who've fallen, who've committed suicide. So, I've had many members break down in tears when you just give them that safe space to use that language and say to them, are you okay? One of our members in transport, 83 bodies. None of those instances are captured under this trashy bill.
Thank you.
Thank you. Excuse me, so a couple of questions. I might jump in with one up front. The case studies that have been presented this morning, which are either picked up in your respective submissions or additional, are very powerful and significant, I think, in framing thinking around the proposed legislation. But in terms of taking an example, perhaps, Mr. Smith, can I just take you to page 8 of your submission, or the organisation's submission, about case study, de-identified obviously as number 1 case study CW. And I just, 2 parts to the question. One is that in light of some of the questions already responded to, and particularly Mr. Hayes, about the cultural issue and attitudes of the population at large, tragically and sadly, with respect for people, particularly where they are dealing face to face with the public at large. Could you elucidate on Mr. Hayes's point that he made, if you'd be prepared to do so, and perhaps, if you're able to do so, make some specific comments about this individual case study, of course de-identified, and its implications of the new legislation as proposed under the exposure draft, and how that would affect this person, or not, as the case may be.
Yes, definitely. Look, and sadly, these are everyday events, and it's not. This person was in regional New South Wales. I can take you to outer suburbs, I can take you to inner suburbs. I can take you everywhere across this state, and these are everyday occurrences that happen to our members. This case study probably illustrates 2 things. Firstly, this was effectively the straw that broke the camel's back for this worker, this particular incident where she'd been abused in the workplace by a heavily tattooed individual. She comes from a small community, she's known in the community, this person knows who she is. So she's got nowhere to go in relation to it. The person wasn't banned from the workplace, and they kept coming back to the workplace, and they kept abusing her in the workplace. But it may not have got to the level where she could have, where you'd say this is an indictable offence against this particular individual. The person then identified her, started abusing her on Facebook, but then identified who the person was and kept abusing her online. And again, may not have reached the level of being an indictable offence. So she may not reach the first hurdle of the relevant event for a psychological injury. But let's say she does make it to that first hurdle. She's been off work for 4 years now. The extent of damage, she rarely leaves home. She has to leave home with a member of the family or with a carer when she does, if it's outside her immediate area. Her personal hygiene and personal care is severely compromised. She's been assessed by an independent medical examiner, and our solicitor who dealt with this matter made the point that this was a truly independent medical examiner, and she comes up at 19% whole person impairment. Now, under the proposed exposure draft, she would have lost income support 18 months ago, and she would have lost her medical support 6 months ago. She still needs those things. It just means that we further stretch other public resources to try to look after her, or she gets more damaged in the process. And the solicitor who does a lot of our work in regional New South Wales, who gave us this example, I asked him to review all his cases for the last 20 years, and he came up with one case that got over the 30% threshold. One case in 20 years, and he specialises solely in workers' compensation across many industries. And that particular case wasn't in our industry as well.
Just one quick follow-up question before I pass on to one of my colleagues. Does this case study also provide some insight into what may be as a result of either neglect or indifference or systemic failure or organisational failure, whatever the case may be, of employers with respect to dealing with matters and intervening in a timely fashion to dare I say, get on top of them and protect an employee in this case?
Yes, it does. On two levels. Firstly, the person should not be back in the store, for one thing, and they haven't taken the steps to protect them from preventing them from being in the store. But can I say that the traditional methods available in New South Wales of a banning notice have no effect? I'll use the example again of the ACT. The first person who had a workplace protection order issued against them in the ACT had previously had 7 banning notices, traditional banning notices issued against them. They've breached every one of them. They put a security guard in hospital, received a $50 fine. They had no effect whatsoever. So we need to have reform to prevent these things. Once the workplace protection order was put in place, yes, that person is no longer in the workplace. But it's not just that. It's the staffing levels. It's the intensity of work that we see. We need a means to properly address this. Traditionally, staffing levels have been seen as an industrial matter. If you go down, managerial prerogative matter. You go to an industrial tribunal, they say, we can't deal with this. It's a matter of managerial prerogative. But it's not. It's a health and safety issue. And that's why we need to empower the Industrial Relations Commission to properly deal with these sorts of disputes. Because if you've got enough people on the floor, you minimise this sort of behaviour as well. Sometimes the, inverted commas, heroes in our shops who abuse our members wouldn't do it if there was more people around.
Thank you. Passing on now to
thanks, Chair.
Honourable Stephen Lawrence.
I've got a question for you, Mr Hades, in the first instance. The Treasurer this morning talked about the workers' compensation system being one originally designed for physical injury and now being used for psychological injury, and you said something similar. It seems that the bill, and particularly Section 8E in its definition of relevant event, seeks to respond to that issue by basically excluding certain people from the scheme. And I'm interested in what alternatives you see, and not so much in terms of prevention, because we've heard evidence on that, but I'm wondering what alternatives you see to dealing with that issue, apart from simply excluding people from the scheme. And I've been thinking about things like, is there a case for maybe a higher standard of proof in respect of psychological injury, or is there a case for maybe a lower payment for psychological injury? Are they more appropriate ways of, in a more fair way, responding to this quite complex issue about causation, and also what actually contributes to the injury? Is it exclusively the workplace, or is it a range of factors more inherent to the person?
I think one of the concerns I've got here is we talk about dollars all the time, but dollars aren't going to resolve this matter. There's plenty of people in my experience and my history that have been subject to these matters, and you can get $500,000, you become an alcoholic or a drug addict, and we put you, in isolation, and we don't care about you anymore. So not so much the process of being proactive, which is very important, but looking at when you are injured, what are we doing? And what we are doing is sending you home. And if you're not covered by it, well, we're barely doing anything at all then. But the reality is, if we actively intervene, actively have, for want of a better idea, a commission of rehabilitation as opposed to compensation in just as it is, then we go some way to actually resolving the problem. Whereas the easiest thing in the world, albeit the government sort of says they don't have the money, we'll just throw money at this, we'll move you on, and that's the way it settles. But where my view is that a injured worker should be rehabilitated, and money should be going into the rehabilitation, so to ensure that they have a life after that injury, whether it be at the same workplace or any other workplace, but we rehabilitate them. I think that goes somewhat to the holistic approach to what we're talking about, as opposed to somewhat punitive approach to say that you're in and you're out. And as Jack indicated, many of our members who are virtually exempt from the paramedic sphere, we can see that a tragedy can occur where they deal with every day. Jack's people do the same thing, maybe not every day. And so what's the difference there? And I think it's really important. I never want to get into career elitism or anything along those lines, but everybody has a focus in terms of what they are confronted with and how they deal with that. Some people are more resilient than others, but we can't let the others fall through the gaps. And so my view is that a longer review of what we're doing, a holistic review of what we're doing, rehabilitation has to be front of mind. Compensation is there, but if we're just focusing on compensation, people will fall through the cracks.
Yeah. In terms of the definition of relevant event and this requirement that a person actually witness an event, I'm specifically interested in Mr. Waits, Mr. Hayes and you, Mr. Ayub, your thoughts about how that particular part of proposed Section 8E could be amended. And I'm particularly concerned about this idea that people witness death, and they might witness death on a regular basis, but it doesn't fall within those terms in 8E. So is there a way to broaden that definition that includes people who, according to a certain percentage of them, are probably invariably going to suffer illnesses as a consequence of certain work?
I don't have an immediate answer for you today. The rush with which this legislation is being proposed, the rush of this inquiry, yes, there has to be alternatives to that. When our members are on a shift and there is an adverse event, that affects the whole shift. Everyone contributes because of the teamwork approach. So these things have to be taken into consideration. I think one of the risks with the draft legislation is that it proposes to try and define what is a psychological injury. There are trained healthcare professionals who do that. There is evidence-based literature that does that. Not a piece of legislation that says whether or not a nurse, a paramedic or a shoppie or a teacher is suffering an injury because of their workloads. That's for the realms of the healthcare professionals.
Yeah. Have you got any thoughts on that, Mr.
I'd take that on notice if you don't mind.
Sure.
I think it's a very serious question, and I'd like to give it a little bit more thought.
Sure. You got any thoughts on that, Mr. Hayes?
I think just broadly, I mean, a bit of context on it. You think about the Hunter bus crash was widely publicised. Our members were both there. Our members were responsible for the aftermath. They had to roll the bus back up, get rid of it, and clean off intestine and blood from guard railings. Now, they didn't witness the event. They didn't have a close personal connection, nor did the AMBOs who arrived there. So, I mean, there's no way that is workable. As for another set of words, it just goes to the point that we've not actually had from the officialdom the sort of honour and decency to consider this thing properly, and that's really what's hamstringing us here. We've come from there's a starting point of consensus, which is we all want the system to work better, all of us collectively, business, everyone, but that's been blown up by this exposure draft coming out, which we were never consulted on, for example. So I mean, the only way forward, I think, is for members of the legislature and certainly this committee to ask themselves, can you seriously lay your conscience on this draft bill that has no policy rationale, no moral integrity, and no heart?
So just to be clear, it's
final.
Yeah, if you don't mind, Chair.
Yeah.
Yeah, thank you. So just to be clear, your contention is that the words in 8E see that a person must witness an incident that leads to death or serious injury, end quote, wouldn't bring within it a person, for example, who turns up in the aftermath and is responsible for removing corpses?
Look, the people are better on interpretation than me, but I think as a fair reading, the emergency services who respond and our members who respond after that, they're not witnessing the event. Yep. They're not going to be captured by that. But even if they do witness the event, how do they fall within 8H2? Because they don't have a close work connection. I mean, how are these things interacting? I don't know.
Chair, I'm going to take a point of order. Mr. McFarlane has been invited to this committee to give evidence. He hasn't been given a question. He wasn't afforded an opportunity to make an opening statement. I think we should give him at least some opportunity to say something. If he's got,
I did foreshadow that if any of the questions applied to him, they could be assumed to take them on notice.
Well, I'm in the hands of the committee, but
I'm
in the hands of the committee.
I mean, obviously, if people want to object, then they can. But I think it's appropriate. It's discourteous to a witness.
Indeed. Well, I just want to make a point. I don't think that's intentional, Mr. McFarlane. Mr. McFarlane is a highly regarded union official in the state of some standing. So I was going to, in fact, make a comment at the end about any omission in terms of an opportunity. So I think we need to make that point. It's not deliberate, and nor would it ever be deliberate. So with that sort of caveat, would someone, perhaps Mr. Deadam would like to ask the question?
Mr. McFarlane, you have
I just wanted to say two things. One,
Thank you.
on the I think 8H is another example of this bill being rushed and not the advice I've sought from experts in vicarious trauma and family domestic violence services, that definition is going to cause more harm. And I guess in summary, on behalf of I think everyone here, I can say that gets to the crux of this, is that this reform will cause more harm. This reform will leave people behind. This is not about prevention, it's about punishment. This is about lawyers making decisions about people's health, not doctors. And that's why we urge you to not support this legislation and take, I think, as we've all said, the time to get reform right. We are all up for reform. We are not saying the current system is perfect, but we want to be part of a proper conversation so no one is left behind.
Thank you very much. Did you have a follow-up you like, or that sort of?
No, look, I think...
No, that was very comprehensive, and thank you, Angus. Thank you very much. Well, on that note, can I just make a couple of points? With respect to the return of questions taken on notice, we have the time set. Now, this is currently the case. It may or may not change over the course of the day, I don't know, but we've got 5 p.m. next Wednesday, which is the 21st of May, so should be shooting to that with any responses. If that changes, you'll be told, but that's the date and time for the cut-off with respect to questions taken on notice. With respect to opening statements, can I invite you, if you've got them in presumably type form, to hand them over to one of the members of the Secretariat staff. So we've got them before you leave, but if you don't have them in a form that you're completely happy with, and I don't mean changing the words, but it hasn't been typed up for whatever reason, get that done, and with that individual or individuals, and indeed all of you, can you email those opening statements to the Committee Secretariat? So I've got the hard copy that comes today, plus the electronic, and that will just make the whole facilitative of the development of the report helpful. And finally, and I made the point at the start, thank you all around the table here, and I might say there are other union officials who I'm sure would have clearly loved to have joined this panel, because it does affect all workers covered by the trade union movement in the state in all industries, but we could not practically invite everyone for obvious reasons, but we have amongst the most senior trade union officials in the state at least the General Secretary level. Thank you all very much, and your evidence has been most helpful. Thank you. Now, We return after our short break, and thank you for the patience of everyone for allowing that. We move on to our next witnesses, and welcome to both of you, Mr Hunter and Mr Morton. There needs to be the formality of being swear or affirmed in for your evidence, which requires you both of you name, position, title, swear either oath or affirmation, whichever you prefer, the oath of which should be before you. So we'll start with Mr Hunter.
Thank you. My name is Daniel Hunter. I'm the CEO of Business New South Wales. I take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. And Mr Morton.
Thank you, Chair. My name is Sam Morton, and I'm the General Manager of Government Corporate Affairs at Business New South Wales.
Thank
I
you.
also take the oath, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much, Mr Morton. We'll move now to the next element, which is to provide you with the opportunity, I should say, to make an opening statement. Sorry, we've been going like lightning speed this morning to keep on time. An opening statement, so take your time, make your opening statement, and once that's done, we'll move to questioning by committee members. So, Mr Hunter.
Thank you, Chair. New South Wales has always been the engine room of the Australian economy, and it's businesses that drive that economy. When we talk about business, we're talking about people and communities right across New South Wales. And we know that for businesses to thrive, they need employees who are healthy, motivated and engaged. That's why Business New South Wales, it's the peak business organisation for 199 years, fully supports workers' rights for care, rehabilitation and to fair compensation for workplace injuries. In fact, we were instrumental in establishing the state's workers' compensation scheme over a century ago. We also support a reasonable mechanism to hold managers to account when they are not doing the right thing by legitimately injured workers. However, we have a workers' compensation scheme in New South Wales that is broken. It is broken because not-for-profit disability providers are seeing their premiums go up by over 400% in 5 years. It is broken because 50% of our members tell us that once a person goes off on a psychological injury claim, they never return. 50%. 90% of businesses we surveyed last week also said that the system needs urgent reform. It's broken because legitimate performance management issues are being wrongly turned into workers' compensation claims. It's broken because it is not sustainable. For the private sector workers' compensation scheme, the nominal insurer, current premiums are already rising by 8% each year, while the funding ratio falls by about 5% per year. So in dollar terms, the scheme went backwards by $1.8 billion last year, all while premiums went up by more than double CPI. To bring the scheme funding ratio back to what is considered a healthy level of 110%, it's currently, I believe, as of this morning, at 82%, would require huge premium increases under the settings of the current system. We fear the increases required to achieve this are actually far higher than the 36% over 3 years already quoted. Adding to the problem is that the degradation of the scheme is getting exponentially worse each year. It has gone down 3% in the last 6 months. If we do nothing, then the scheme costs will send some businesses bankrupt. There is also a human cost to this. Ironically, it is the pressure and stress it places on business owners struggling to survive. New South Wales has a once-in-a-generation opportunity to reform the workers' compensation system and ensure that genuinely injured workers get the help they need, and that businesses can survive and ensure a safe workplace for their employees. Without significant changes, the weight of the scheme will crush businesses, leaving workers and the communities they serve for good. Thank you, Chair.
Thank you very much, Mr Hunter. I take that, Mr. That's part of the on behalf of the organisation. Thank you. So I'll move to questioning, and first to have opposition Crossbench government. So we'll start with the Honourable Damien Shoothope.
Thanks, and thanks, Dan. Thanks, Sam, for being here today. I just want to start with urgency. Why is this urgent? We've got when did you first see this exposure draft of this bill, and why is it so urgent that we actually implement it this year?
I think it's the speed the scheme is degrading by. I mean, we heard from the Treasurer this morning around the TMF, that's still up over 100%, and he's not going to tip in any more money into saving that public sector scheme.
Yeah, but
this scheme's degrading by 3%.
Is it important, though, to get it right?
Yeah, it is important to get it right.
And is this the right model for getting it right?
Look, I think that this model picks up on a lot of things that have been done successfully in other states, particularly in South Australia. South Australia at the moment is considered the business-friendly state. And New South Wales has always been a state that has attracted investment to Australia. As I said in my opening statement, it is the engine room. We need investment, we need successful businesses, and we are losing them. We're losing the default, business defaults are higher than they have been year on year. I can get you the stats on that if you need to. Yeah. But in short, an answer to your question, Rome is burning. So, the degradation of the scheme is really problematic. It will likely be by the end of this financial year under 80%.
Well, just in relation to South Australia, part of the evidence we also heard this morning was that the diagnostic tools in relation to psychological injury and the determination of a 30% cut-off was if you applied the same test in South Australia as you're applying in New South Wales, effectively their test is 60% and not 30%. So it's not really comparing apples with apples, is it?
I think it's. I'd like to see the facts behind that before commenting on it. I think, though, to go to your point about getting those medical assessments right, and that is needed, and the detail is needed on that for the WPI threshold to raise to 30%. We need very clear, assessment protocols and medical assessments on that. I don't purport to know what those assessments are, and I wouldn't comment on whether it's 30% in one state equals 60% in another, because I haven't seen any facts behind
just putting to the submission, if that was true though, that would make this a very draconian scheme, because it would eliminate most people who had psychological injury from making claims, whereas if the South Australian model was being applied, you wouldn't have the same number excluded from making claims, if that is true.
What you have at the moment, though, is that you have a very low threshold, and you have psychological injury claims that have doubled in cost and have gone up by 65% in terms of volume in the last 2 years. So something needs to be done, and I agree. There's work to be done in the detail of this, right? Okay. So I totally acknowledge that the consultation needs to happen. The time frame, I actually wouldn't put a time frame on it. I would suggest, I'm saying urgent because it's a really big problem, and it's dragging our state down.
Well, premium increases have been fixed for next year, haven't they?
Yep.
At 8%, so it's not urgent in terms of pending premium increase.
But that funding ratio, every day that goes past, that scheme goes backwards by 5%, and that's with 8% premium increases.
Well, let me ask you about that, because one of the things which was put to us this morning is the problem of the self-insurer.
Yeah.
Would the NI be under as much pressure if, in fact, the safer, potentially, workplaces were not able to opt out and become the self-insurers?
I don't know the answer to that question because I've never seen any analysis done on it.
Well, should you?
And I don't know that would be the case. And, business needs they need the right to choose. They
Yeah, but
should be able to choose, and I think that self-insurance question needs to be looked at a bit more carefully before we can comment.
Well, if in fact this draft bill became law, what would you say would be the saving available in premiums for small business?
We're unable to model that at the moment because we would need to see actuarial calculations. I'm not here to purport to be an insurance actuary, but the scheme, as I understand it, would be revalued and the future liabilities would be revalued, and we could see a pretty immediate uplift on the funding ratio, which should put downward pressure on premiums. And more to the point, I think it should put it should help to fix the problem of illegitimate claims, psychological claims going through the system.
Well, what do you say are the illegitimate claims that are going through at the moment?
So there's a few. There's one here where a worker claims a psychological injury after a heat stroke incident. And that person had a history of psychiatric illness and substance abuse, and the PIC, the Personal Injury Commission, found a whole of person impairment of 23%, and they only applied a 10% deduction due to pre-existing conditions. So this person had pre-existing conditions, psychiatric illness conditions and substance abuse conditions. So at 23%, they qualified for a WPI under the current system. And so in that example, that's equated to around $250,000 so far. And what's happening in this case is a great example of some societal issues being lumped in together and becoming the responsibility of the workers' compensation system.
So how would you resolve that?
Well,
if that was the case study, and Business New South Wales is involved in a preventative regime, what would be the tools for resolving that?
Well, I think you've got to prevent them in the first place. So, I'm a firm believer, and there's some interesting examples given just earlier, which I support, and the definition of trauma will still be in there and things like that. And I think it was the Hunter Valley bus crash incident.
Yeah, but if it doesn't get to 30%,
that was measured, that was used. Sorry, you need prevention programs which are contemplated in these reforms. You need prevention programs and training, and you need workplace disputes that are solved quickly. And you need a mechanism for that, because what's happening at the moment is there's workplace disputes by default just being accepted into a workers' compensation system that it's not designed for. So, and I'll go back to that example. If you will indulge me, I used to sit in a previous life on the board of Ambulance New South Wales, and I've got a pretty good understanding of those traumatic events and the PTSD associated with them. When you talk to well-credentialed people, the people that run those organisations and have been at that front line, the answer is training and resilience. And then when things like that happen, getting around people so that they don't create issues. The other point I would add is when people are off work and funneled through this workers' compensation system, it makes the problem exponentially worse. People need meaning in their life. I think we could probably all agree on that. People need to go to work and need to feel valued. And what we're doing at the moment, as Mr. Hayes said in his previous evidence, is we're sending people home. And I don't think that's a good outcome.
Well,
Chair, to the point of urgency we were mentioning earlier, and Mr. Hunter mentioned some figures. I'll just give them to you now. Not just for the businesses don't need certainty just for the next 12 months, but as Mr. Tudor would be aware, for in 2, 3, 4 years for their planning and solvency. In March alone, we had 575 businesses entered administration in New South Wales, up from 478 in the equivalent period a year ago. And year on year, 4,236, up from 3,292. So, yes, wouldn't
You're not
necessarily be
suggesting though that
solved
they're all
by...
caused by... You're not suggesting
No, I'm not,
for
I'm
one
not
moment,
drawing a
eh?
causation line directly to that, but the broader business environment we're talking about, with the sector that employs 6 out of 7 workers in the state, or close to 86%, figures you're obviously very familiar with, are in the private sector and are doing it tough at the moment. That's the context.
Yeah, but there is a range of cost of doing business measures,
Indeed.
which I'm sure you're very aware of, which impact on their ability to remain
true.
solvent.
Absolutely.
So it isn't
And
just
insurance is at the top of that list.
And insurance is a big one. But I want to put this to you. COSBOA, in their submission, said this. COSBOA supports the objectives of preventing workplace psychological injuries and ensuring appropriate compensation for affected workers. However, we are concerned that the proposed amendments in their current form will disproportionately impact small businesses through increased costs, compliance burdens and complexity. What do you say in relation to that?
I think, and Sam, you might jump in here, I think what COSBOA is referring to there, and I spoke to a couple of other business organisations yesterday, and it is something that concerns us as well, is the detail around the new IRC jurisdiction. So,
well, where's that? Have you seen that?
No, we want to see it. Yeah. We want to see it. Don't mistake my need for urgency as a way of not consulting and getting into the detail. I fully agree with you that we need to get into the detail of this, and we need to take some time to go through that detail. What I don't want to do is be sitting here in a year's time without workers' compensation reforms, with a scheme, with pricing about to be handed down, and a scheme, a funding ratio that's in the 70% sort of range, or late 70%, that's targeting to get back to a healthy level of 110%, because those bill increases are not going to be 36% over 3 years. They're going to be higher because it's spiralling.
Which industries do you say will be impacted the most?
By the price increases?
Yeah.
I think anything, it's pretty well documented, but I'd say a lot of family businesses, a lot of small to medium businesses, the 50 to 100 range. Any industry, manufacturing is a great example. Any industry that we're trying to hold on to here in Australia, a great example, manufacturing. We were up in the Hunter region recently, visiting some members up there, and at Tomago there's still quite a lot of Australian manufacturing going on, high-end stuff, vehicle fit-outs, all those sorts of things. Their work, and they're in high-risk areas, so they have some claims experience. Like if you're running, and some of them are multi-generational businesses, if your workers' compensation bill is already a pretty big chunk of your P&L and it's going to double in the next 3 years, that could put you pretty close to the edge, or help you make a decision to move offshore or anything.
And therefore, prevention should be a bigger. You're on the board of iCare and the CEO of Business New South Wales.
Yes.
What preventative programs are you promoting in either capacity for, in fact, getting people back to work or reducing psychological injury in the workplaces?
Yeah. iCare, I've only had one board meeting, so I'm just sort of getting my head around that stuff. The preventative programs that we run out are mainly training, prevention type programs, how to have an appropriate performance management conversation, things like that. We need to do more of that, and I think it's a bit like the health system in general. The more effort you put into prevention and up front, the more dividends it pays at the back end, and you avoid these situations. So I think that's one thing, and I think the other one is having a very quick mechanism to solve these sorts of disputes or bullying harassment claims in a fast and efficient way, so people can stay in the workplace. Our ultimate goal here is not to deny people, claims that they're due. It's to keep people at work and keep businesses humming. Anything to add to that?
Chair, look, in a knowledge-based workforce in particular, these are key issues for employers and particularly challenging for the smaller end of employers. You asked about what we do at Business New South Wales. I think it's a matter of record that we work with a number of providers, in particular EML, on better ways to get injured workers back to work. And the general principles there are really around, as has been said by both sides today, well, not sides, unions and employers, that work improves health and recovery, that delays of returning to work can worsen mental health. We know that early return to work improves outcomes, depending on obviously the environment, particularly which you're in, and that good work is better than no work. So these are well-known principles in the space that we're talking about. These are the general principles we work towards with practical programs on how to, we want to avoid these injuries in the first place. And it's not just about large corporations, it's also about the vast majority of firms in this state who are SMEs, who are often family businesses, where the person running the business is also effectively labour in the business and working in the business. So the more we can get from the broad principles down to the practical day-to-day support for owners and managers of enterprises across New South Wales, that's where we seek to go, and to avoid people being off on psychological injury when they could be better cared for or better looked after through the reforms that are proposed.
Move the questions now to Deputy Chair.
Thank you. And thank you to both of you for coming along today. I just wanted to pick up on that comment about small business and the submission we've received from COSBOA. We've also received a submission from the Self-Insurers Association. Both of them talk about the increased costs that some of these reforms would have. To what extent are you here representing, I guess, the whole of business as opposed to the larger businesses that have the HR function that maybe can afford to go through this system a bit easier?
We're a very broad church at Business New South Wales. We have 50,000 members that we represent across the state, from micro businesses and one-person businesses right up to larger businesses here in the CBD. So we run under our brand Business Sydney, Business Western Sydney, Hunter and Illawarra, and they represent medium to larger businesses. And then we have grassroots membership as well. So we represent all regions as well. We have regional offices right across New South Wales.
So informing your opinion on this set of proposed reforms, did you consult with small business, with self-insurers, all the rest of them, or was there a what was the process then within Business New South Wales?
We consult mainly via a business conditions survey and by talking to our members. We run around 300 events a year where we engage with our members, and we run business conditions surveys quarterly where we ask our members what they think in particular workers' comp. So, last week, for example, we ran a survey where 90% of businesses told us that the survey needed urgent reform. So that's where we mainly get our information from.
Sorry to jump in.
Please.
Further answer to that question, we've just kicked off an extensive 3-year program. So it's very much targeted at businesses that, like you said, don't necessarily have a fully fledged legal or HR department. And we're kicking off that project. That's the AML project. To provide the kind of, it's an information loop, but it's also practical workshops and information.
So I guess there's widespread agreement that across, I think, everybody who's made a submission, that there are serious problems with the workers' compensation system, and that a lot of aspects of it are actually making workers sicker when they go through that process. Where the disagreement is, though, is in relation to how we reform the system. When it comes to making your submission that appears to be broadly in favour, and apologies, we only just received it, but broadly in favour of these reforms, I guess how did you get informed that this was something that would benefit most businesses then?
So again, I'd go back to the detail part. We see there's more benefit in this than downside. We do see some downside. We are concerned about that new IRC jurisdiction, as has been written up by others, about that layering in more red tape and cost. However, we do support a mechanism and a need to examine bullying and harassment disputes in the workplace outside of the workers' compensation system. So I would say in that respect, and I think that's what most people are driving at, is the cost associated, what most business groups are driving at, is the cost associated with that new IRC jurisdiction. So again, in that respect, we would need to see the detail of that. We have given feedback that we would like a system that is fast and where urgent claims can be expedited, and that's to look after injured workers as well, and that there be an appeals mechanism. But we would need to see the detail on that before we can form a view. But we do see some downside risk to what's proposed. Yes.
Have you done any independent or seen any actual modelling to identify what the impact of these reforms would be on future premiums? Or are you relying very much on what is being said to you from the government?
No, we haven't seen modelling on it. We would like to see modelling on it. I think everyone would. But anecdotally, there's enough evidence there on those reforms to show that they would put downward pressure on premiums.
When you look at, for example, the nominal insurer statements that came out from iCare just this week, they do talk about a small increase coming from psychological injuries in the nominal insurer, but they also talk about huge increases from things like inflation, wages increases, quite a large rise, a much larger rise when it comes in dollar terms when it comes to physical injury claims. Are you convinced that the way to make the scheme more viable is to pick just one aspect of that, being psychological claims, and then saying, well, that's the one that we're going to deal with and exclude?
Yeah, I think that's a really good question. There's no silver bullet to solve this issue in answer to your question. This is a step forward, but I think we would all agree that claims management needs to be continually looked at and part of a continuous improvement program. But my point would be that you're not gonna fix a funding ratio that's going backwards at 5+% per year by just addressing claims management and efficiency. Like, the settings of the system at the moment are such that you cannot get ahead.
If given that these reforms could have significant unintended consequences, which could lead to more people going without the help they need and creating a less productive workforce, but also could lead to significant increased costs for small business that far outweigh any premium gains, do you recommend or acknowledge that rushing this legislation through in the next month is perhaps not the best way forward?
Look, I think we need more detail. I'm not going to comment on or put a time frame around it because, again, we need to take as long as we need to take to get this right. I don't think it would put increased costs on small business from what they're experiencing now. I think the overall outcome of these reforms would to put overall downward pressure on costs for small and medium businesses. And so, I would go back to the urgency. We need to take the time that we need to get this right, but it needs to be done urgently. We can't be sitting here in 12 months with a scheme that has a funding ratio in the same. Every day that goes past is a day that we need to recover. Like, you cannot have funded liabilities at 75%. The scheme always has to recover. If it was at 100% and we had time, then sure, but we simply don't have the time. The scheme needs to recover.
Can I ask you, as someone who I assume has background knowledge in business and finance and other things, I have some background. I'm by no means an expert. I'm looking at some reforms that have just come through in relation to the Australian Accounting Standards Board Rule 17, I don't know if you're aware of this one, but it talks about the valuation of premiums and liabilities within publicly sort of run insurance and compensation schemes. And back in 2022, I'm not sure if you're on the board of iCare at that point.
No, I've only
No.
just-
Back in June 2022, the iCare board made a submission to the Accounting Standards Board that said that if these changes come through, which they have now, I think from the beginning of the next financial year, they said it would result in a $3.64 billion hit to both sides, the TMF and the nominal insurer. I think it was roughly half-half from memory. And they go on to say that obviously that $3.64 billion could be used for essential services instead of complying with an accounting standard. Are you aware of what has happened to that accounting standard? And is any of this accounting revaluation, in your view, leading to this supposed pressure on the scheme?
I'd need to take the accounting standard one on notice. I am an accountant, but I'm not. I don't really practice anymore, so accounting standards aren't really. I'm not reading a lot of them at the moment. It will be around valuations of liabilities and the provision mechanisms around that. They can have an impact because they need to be funded properly.
Yeah.
Those accounting standard changes, and so I think that submission was probably accurate, because what I know about publicly funded schemes, and again in my former life when I worked in government, is that the government spending is about choice. So if you're having to top up a TMF scheme on a regular basis, you don't have it to spend somewhere else. And knowing the budget position at the moment for the state government, there's some pretty hard decisions to be made. So anything that pushes up any sort of top up that the Treasurer needs to make is money that can't be spent elsewhere.
Could I ask, I'll just ask this and then one more question I'll throw over to my colleague, but just on that, if you're taking that on notice, if you come back also with what the impact would be on the accounting standards and the treatment, where the government sort of wholeheartedly supports and backs the scheme, whereas one where it does not. I understand that there is a difference between states and territories on the treatment under this standard based on how much of a guarantee the government is giving behind the scheme, just in light of the ultimatum this morning that the Treasurer made.
Yeah, we can have a look at that. I think the organisation, and I know you have them this afternoon, but it's probably best placed to answer that and has a deep expertise on it as iCare themselves, because they will have that expertise around those accounting standards and the actuarial sort of assessments on
Just
those.
one final...
Sorry. I just, in fairness, I want Latham, please.
Well, thank you, Chair. I've just had the one and come back hopefully enough
just to get that in.
time
Back to
for Ms Boyd. And I'm sorry I wasn't here for your opening statement due to a prior commitment.
That's okay.
But I just had one question along the lines of, in the galaxy of material and this hefty bill we're analysing in just one day, obviously they're setting up a new jurisdiction through the industrial relations system by this gateway process. There seems to be also in the material a assumption that if the gateway system makes a ruling against a business that you're guilty of having created this psychological injury, the business will now pay the compensation rather than the schemes. Is that your understanding? Will pay directly in a civil liability payout.
I would need to see the detail on that.
I mean, we've engaged in good faith around things like public accountability for employers. I'm not sure that premise is one that we've gone into the details of.
Right. What would your reaction be to that? That through your own insurance, business would have to pay rather than the schemes?
We'd have to have a good look at the detail on that. But I mean, that in my mind should become an insurable event. if that is the case. And
You
go
can
through
take
the
that on
workers'
notice and
compensation system.
provide any
Yeah.
information.
Yeah, I think.
Thank you. Back to Ms. Boyd. Sorry.
Sorry. Yeah. There's obviously a lot of interplay between employment law and the scheme
Okay.
as it stands
Right,
at the
thank
moment.
you.
Yeah.
I just want to ask a question. We talk about this having a disproportionate impact on women, but also the data shows that there's actually a far greater percentage of regional workers with psychological injuries than metropolitan.
Yep.
How do you think that sort of rate of injury, if left untreated, would then impact on regional businesses and the ability to get more employees in?
Look, I think that I'm not sure of the gender weighting and the basis for that. I presume that's an industry analysis of some sort in female-dominated industries that have high psychological claims. I'm not sure. In terms of the regions, I think what would be driving that is access to specialists, to be honest. And again, knowing what I know about health systems, it's very challenging to find psychiatrists and allied health professionals once you get out of the metropolitan regions. So I would say that is what is more driving that. And that is of concern because it impacts. I mean, when we talk about business, we can often sit here in a room like this in suits and ties and imagine we're talking about large, tall buildings with glass down the road. We're actually talking about often people's life work, multi-generational family businesses, businesses that support their community and employ people. I think we're all almost on the same team here when we talk about that. So, yeah, I think that the regions do need to be looked at and have the appropriate support in place to keep people in the workplace.
Thank you very much. We'll move to government questions now. The Honourable Bob Nampa.
Thank you, Chair. Thank you, Mr. Hunter and Mr. Morton, for your evidence this morning. Look, I'm just going to take you to a quote from the last time this reform was pursued in a similar nature with respect to the eligibility for claims and the quantum of claims, and it was Minister Dominello who said, and I quote, "We have a system now that is sustainable. You have to remember we inherited a system that was fundamentally broken. It was $4 million in deficit. We're having suboptimal return to work rates. The premiums were going up by 28%. It was unsustainable." Here we are 7 years later having the same debate and tackling the same nature of reform. What confidence do you have that this time round in tackling the eligibility of workers to make claims and the quantum of those claims, we are going to finally resolve this issue without making more structural changes?
I think I'm an optimist. So, yeah, I think it will be addressed because I think there is broad agreement in a room like this that we have to do something. And, yeah, it might surprise you, but we actually, at Business New South Wales, do work in a tripartite way. We have ongoing conversations with business and unions, and we're on several tripartite committees. The best example of that, which was mentioned, is the Board of Eye Care, where myself and Unions New South Wales both now occupy a seat on that. And I think that is the way through this. It's the way through this is collaboration from both government and opposition and independents and all parties in order to recognise the problem and make some changes. And I think that is the job of good government, and I look forward to the outcome.
I suppose I asked that question because the McDougall review into eye care and the State Insurance and Care Governance Act stated, and I quote, that the principal risks to the financial stability of the nominal insurer was, in descending order of the following financial significance: the amount of premiums that are collected, the investment return on financial assets, claim costs of both existing claims and future underwriting, and other expenses of the nominal insurer, noting that claim costs was further down that descending order of financial significance. So I suppose I'm wondering that wouldn't it be, in terms of pursuing reform, wouldn't it be worthwhile looking at the impacts of self-insurance, the impacts of psychological claims, return to work rates, medical interventions and treatments and other costs, looking at those things and what impact they have on the capital adequacy of the fund before embarking on the review of, reform of this nature?
I think with some of the stats that we've got coming through at the moment on volume of claims and cost of claims, we can see quite plainly that there's a problem with the settings of the system, if you like. So, going back to my earlier comments, we could and should always look to improve claims management, how we handle that, and get return to work rates and all those sorts of things. But fundamentally, we have to stop what's happening upstream through prevention and through the right legislative settings. So we need to get that right. In answer to your question on the self-insurance, look, that's, I think, a matter that needs to be looked at, but I'm not convinced that is the answer either, because again, you're forcing people down a certain path if you make changes to that system, and we don't want to penalise anyone in current settings either, I don't think.
And through the chair, I think the quote from McDougall, the hierarchy of needs, if you like, in insurance, just a general observation, that's a pretty standard hierarchy of inputs for insurance categories globally. I think often people underestimate the importance of the investment structures behind it for sustaining insurance, and then of course claims handling and so on is a key lever that people can actually pull.
McDougall, before I hand over to my colleague, McDougall's report also stated that changes to benefits, and I quote, changes to benefits should only be considered if they are seen to create perverse disincentives to recovery, or if, even if properly controlled, they are placing an unmanageable burden on the scheme. Mm-hmm. We've received a number of submissions to suggest that we should perhaps look at reform to improving return to work rates, improving claims management, going through a first phase of reforms in that space before we pursue reforms to the eligibility of workers to seek claims. Do you agree with that assessment?
I think you need to do both. I think it has gotten so dire that unfortunately benefits need to be looked at and access to those. It happens fairly regularly in a workers' compensation system that these things need to be re-looked at and modernised. But I mean, we've got examples of people in there, and it's not just about cost; it's about the human cost. We've got examples of individuals in their 20s that are never to work again because of psych injuries. Now they may or may not be legitimate, but when you've got a lot of those coming through, that can't be good for society. It can't be good for the individual. We've got examples here of, people who are clearly, like in one case, a worker was doing half the workload of others, measurable workload. They got a performance management conversation, and they put in a psych claim. They logged off and put in a psych claim for bullying and stress. That's cost $500,000 so far. So, I think access to claims has become too easy. It's become a soft entry point for workplace disputes, essentially, the workers' compensation system, and it's not designed for that. It was originally designed for physical injuries, and I think these things need to be revisited from time to time. And I think with the numbers we see in front of us, the number of psych claims going up, the cost of those psych claims going up, the degradation of the scheme by the day, I think it's an and, not an or.
I wanted to ask about, there's a quote in the iCare submission. They say that scheme sustainability requires incentives for employers that reflect the risk. Do you agree with that proposition?
I don't really follow the context of that, I've got to say.
Okay, well, I mean, the proposition is that the scheme has to be structured in a way so that employers mitigate their risks.
Yeah.
Right, that's the incentives.
Yep.
And premiums are supposed to encompass the risk in the scheme. That's correct?
Yes.
Yes. So surely if, irrespective of what happens, the workers are going to continue to be injured, right?
Yeah.
Those injuries incur costs.
Yes.
At the moment, those costs are being incurred through the scheme. Shouldn't employers pay for that risk? I mean, those injuries are occurring through work. Isn't the responsibility of ultimately for employers to bear that risk? Or do you think that employers should be able to shift that risk to other sectors of society?
Well, I think what we're seeing now, and I haven't heard anyone disagree with this, is that we are seeing a lot of illegitimate claims coming through that system, and a system that is unsustainable. So what's happening at the moment, and it's not there's victims in this, right? So you're seeing sometimes societal issues, sometimes illegitimate claims going through the workers' compensation system. That cost of that getting passed back to businesses, that can put pressure on businesses, can send them bankrupt, etc., all the things we've talked about. Ultimately, they pass on that cost as well. So if we're sort of wondering why we're going to be paying $7 for a cup of coffee in the next 18 months, then I know that's a long bow to draw, but these are the things that are adding to that. And there's other mechanisms in Australia, lots of good mechanisms in the wonderful country we live in to look after people, and to look after those societal issues that are happening around psych and things like that, and mental health. Those are real. I don't debate that they are, but I don't know that the burden for that should be going through a workers' compensation system.
I'll give you an example. So the proposition is to effectively eliminate occupational stress as a compensable injury. Doesn't that create a perverse incentive? Like, effectively, employees can then ignore the factors that are contributing to occupational stress, and obviously that cost is then borne by society. If those workers are injured as a consequence of that, and employers are incentivised to address occupational stress, then ultimately that's a cost shift to somewhere else the business really should be paying.
That's working out. I don't know. I don't quite agree with the logic, because I don't think any business or business owner wants to put stress on their employees. And I think there's a natural stress in life that we all have. I'm sure everyone in this room has pretty stressful days. But I think the premise that businesses are going to use this to put more stress on their employees is wrong. We have one of the lowest unemployment rates in history.
That's not exactly what I'm saying. I'm saying that currently, because the occupational stress can give rise to a workers' compensation claim, businesses are incentivised to avoid those kind of claims by addressing the hazards in the workplace that are causing the injuries. If you take that compensable incentive out, then they'll perhaps have less of an incentive to address those drivers.
My point would be that they are still incentivised to provide a safe and happy workplace, and a good workplace for so many other reasons. If you look at the best performing businesses, they do the right thing because it's good for business. They don't do it because they want to avoid workers' compensation bills.
Can I ask about, so one of the major issues in terms of the cost of the scheme around psychological injuries is weekly benefits and the poor return to work rates for psych injuries. What do you say we can do to, in the private sector, to improve those return to work rates?
Just a point of clarification, Chair, and generally good discussion that you're raising. Poorly managing or not managing workplace stress is still something that has to be dealt with under WHS law. I'm not
it's
sure
an
if
offence. It's still a WHS
I'm not sure if you're still...
I mean, the prosecution,
sure,
the enforcement regime is not
in
equipped to actually enforce that across the
Sorry
system.
to jump in. In the context of the draft exposure bill before us today, I'm not sure if you're heading into the sort of discussion of, what we do with 11A, what we might call 11B, if we had a chance to redraft. But these protections, the intent, broadly speaking, and we've had broad discussions, is to maintain protections for workers, but to shift, as people said previously, the emphasis towards prevention. So it's not an either-or in quite the way it's just been described. There is more nuance there. Yes, there need to be very clear definitional discussions. I think from observing the committee's hearing earlier today, people are even asking questions about the very first definitions in 8A. So, there's legitimate questions and discussions to be had. We'd certainly like to work through those details with our own best take on how to prevent these issues in the first place. I mean, we don't want to get into stress as just being in life. It's obviously, if it's not managed properly in the workplace, particularly in a knowledge-based workplace, then these are genuine issues.
Thank you very much,
So
John.
can I just clarify, did you want to take that second question of mine about
I can take it
return
now.
to work? Or if you
Um,
can address it now, if you like.
Yeah, so the question is around how to improve return to work rates.
For psych injuries in the private system, yeah.
So return to work rates on psych injuries are really challenging because it's hard to get see a medical professional in a required time frame. It's hard to get a diagnosis, and they're not. Psychological injuries are much harder to see than a physical injury, for example. So I think that the return to work needs probably focused programs like they're doing in claims management. So, as I've all continually said, claims management for these psych claims needs to be continually improved and continually looked at to help that return to work,
I mean, the same issue phrased another way is time away from work, which is just a huge concern and hugely costly to employers, particularly in smaller firms. So, definitely an issue of key concern, time away from work.
On that note, I'm sure if we had time there'd be many more questions. Gentlemen, both your expertise is greatly appreciated. So, Mr. Hunter and Mr. Mott, thank you so much for coming along. I think there may have been some plural questions on notice. I'm not sure how many. But the committee secretary will liaise with you about what is a more rapid return than normally with respect to those questions.
We'll get on to that. Yep.
Thank you very much.
No, thanks for having us.
Thanks very much. Thanks, gentlemen.
Thank you.
We'll now move to our next set of witnesses, and just whilst they're coming forward, and welcome to them. To you all, and I was going to say good morning, but just gone 12. Good afternoon. Thank you all for coming along this afternoon now and making yourself available to provide evidence to this important inquiry. Deal with the formality first, which is to have you formally sworn or affirmed in to give your evidence. So starting from my left, if you don't mind, we'll go across the table, and if you could please state your name, your position title, take an oath or an affirmation, whichever you prefer, and then we'll roll across the table. So, thank you.
Andre Wheeler, Executive Director, State Insurance Schemes, New South Wales Treasury. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
Sonia Campbell, Deputy Secretary Commercial, New South Wales Treasury. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much.
Daily General Manager, Actuarial Services, iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
Tony Wesling, Group Executive, Workers' Compensation at iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. So we're grateful for the receipt of a submission that stands in the name of Insurance and Care New South Wales iCare, which is submission number 36 to this inquiry. It's been processed, uploaded onto the inquiry website, and is obviously considered evidence to this inquiry. So the opportunity that's provided essentially this morning is for members across opposition, government, crossbench to ask you questions in regards to this matter before it, in terms of reference. But you can take as read by all committee members your submission. So in terms of an opening statement, or statements plural, how many opening statements are there, can I ask?
Yes.
The one?
And Treasury as well.
Treasury. Can I invite you both to, and I don't know how long they are, but nice and tight, if I could put it that way, because, and obviously I'm not forcing you to do this, but nice and tight, so we can have sufficient time for committee members to ask you questions. Thank you.
Thank you. Good afternoon to the committee. Thank you for the opportunity to contribute to the committee's proceedings today. My name is Tony Wesling and I'm privileged to lead the Workers' Compensation team at iCare. iCare's role is to administer the Workers' Compensation Scheme to the legislation that is in place. We do that alongside policymakers and regulators, including the likes of CIRA. I lead a team that are on the front line of serving the injured workers and employers who rely on the schemes we operate. Like my team at iCare, I joined iCare to fulfil the purpose of supporting injured workers to return to health and work. We all have a genuine commitment and passion to prevent injuries and support workers and employers in the recovery process when an injury occurs. iCare has been in the spotlight over recent years. It's clear that we don't always get things right, but I can assure you that is our goal. As iCare has expressed in the submission that you have, the workers' compensation system, as it was first introduced 100 years ago, was designed to support people with work-related injuries, at that time predominantly resulting from manual labour. The establishment of workers' comp in the early 1900s made insurance compulsory for all employers. It widened the definition of worker, increased benefits, set premium rates, and legislated a more secure way of life for those unfortunately incapacitated due to work. The workers' comp system has been periodically reformed to respond to changing workplace risk and practices. We've seen many iterations of the legislation since that time, emphasising prevention of accidents, rehabilitation of workers and fair compensation. The legislative framework that is currently in place, as well as our operations, need to reflect the current nature of work and workplace injuries. We know that we need to further modernise ourselves. For both psychological and physical injuries, a greater proportion of injured workers are now being assessed with higher whole person impairments, and the number of psychological injuries does continue to increase. These factors are greatly impacting the scheme we operate within, and that includes the increasing cost of injuries, the poorer return to work outcomes that we're seeing, the greater demands on our frontline claims managers, and ultimately all of this is impacting the scheme's financial sustainability for the generations to come. As evidence of this, the funding ratio for the NI has been declining over several years. As you heard this morning, at December of last year, the nominal insurer had a funding ratio of 82%. Increases in psych injury are not unique to New South Wales, nor isolated to a particular injury. Psychological claims are complex, which can require or result in people needing longer periods off work and higher cost per claim, covering both the medical requirements as well as weekly benefits. On top of this, we know there are increasing challenges in finding early treatment options with mental health service providers. We all agree that returning to work soon, as safely as possible, is good for health and well-being, and research has consistently found a correlation between early return to work and improved health outcomes. An early return to work also improves the opportunity for financial independence and social inclusion. The challenges of returning to work can be even greater for those experiencing psychological injury and for those unable to return to their pre-injury role. iCare would agree that the issues associated with increasing psychological claims numbers will persist in the absence of both reforms and actions to modernise the scheme. The changed work environment, increasingly demanding work and declining community mental health is going to require employers to make similar mindset shifts, similar to what occurred in 1970s and 80s in relation to reducing physical injuries in the workplace. These issues require a holistic response. iCare continues to play our role working with a range of stakeholders across government and the private sector. In response to recommendations from this committee and other inquiries, iCare is continuing to work on improvements to the claims model to emphasise specialised psychological claims management, enhance case manager capability and raise professional standards, and we're focused on improving return to work and other claims outcomes. We are also reviewing pathways to expand suitable work opportunities across government agencies and are looking at opportunities for injury prevention through the reduction of workplace risk and staff engagement as part of the work we've worked on with the New South Wales Government's whole of government return to work strategy. But despite all of the extensive work underway today, the issues associated with increasing psychological claim numbers will persist. In the absence of both further concerted management action and reform, iCare stands ready to help. A sustainable workers' comp scheme is one that's affordable, focuses on prevention, provides the best possible recovery support for those injured at work, and enables support to those that may be injured well into the future. And today we'll do our best to provide full responses to help inform your work and then to respond to any further questions you have.
Thank you, Mr. Wesley. Welcome back.
Thank
I
you.
say back because you've been before committees before.
Indeed.
Budget estimates reminds me. Yeah.
Yes, indeed. Chair and committee members, thank you for the opportunity to contribute to the committee's inquiry today. I'm going to provide an overview and some context of Treasury's evolving role in managing the state's workers' compensation schemes. As a system steward of the state's insurance scheme, Treasury has an eye to maintaining community confidence in the nominal insurer to protect workers now and in the future, reducing disputation to essential services and businesses. Our workforce is the state's most valuable asset, and most importantly, alleviating the personal cost to workers when they suffer an injury. The financial consequences of not properly achieving these outcomes have been summarised by Mr. Wesling. From the outset, the government has sought to lift return to work outcomes and put the system on notice that it would be verifying premiums were being spent wisely. Treasury has been on a journey to identify and understand the underlying risks in workers' compensation schemes and the challenges of how to pivot a large, complex system to effectively respond to new and emerging risks. In July 2023, we met with this standing committee ahead of the finalisation of the committee's 2023 review of the workers' compensation scheme. At that time, our focus was on governance arrangements in place for the nominal insurer and Treasury managed fund workers' compensation schemes. This was in step with the government's immediate priorities early on in its term, which were to establish statutory objectives for iCare, change the composition of the iCare board to include employer and employee representation, establish a whole-of-government plan to improve return-to-work outcomes for New South Wales public sector workers, and to scrutinise iCare's operational expenditure and performance. Through developing the whole of government return to work strategy, many stakeholders were consulted, including workers with lived experience of workplace injury, return to work officers across government, claims managers, agency representatives and public sector unions. A recurring theme was the importance of return to work in promoting a worker's recovery. Workers who kept in touch and connected to work recovered quicker and experienced improved health outcomes in the longer term. This operational experience is consistent with research published by experts. Return to work rates is lower amongst those with psychological injury claims. Return to work rates for psychological injury are 51% within a year, compared to physical injury, which is 95% who return to work within a year. This suggests we are not as effective as we could be in providing return to work pathways for workers with psychological injury claims. Other emerging themes include how the complexity of existing scheme settings can impede return to work. We've now completed our review, operational expenditure review of iCare, and that review highlighted that operational efficiency and non-legislative reforms to support workers to rehabilitate and return to work are likely insufficient to address the financial challenges of the schemes. There is an opportunity for a sharper focus on the growth in the state's insurance liabilities and financial sustainability and the performance of the nominal insurer. The complexity of our workers' compensation system and the difficulty of measuring and holding the system accountable for outcomes. Effecting change across the entire system will require a sustained, concerted effort across government. As this was all happening, the Committee's review of the Workers' Compensation Scheme and the Auditor General's report into the Workers' Compensation claims management were released. The reports made findings for stronger New South Wales government involvement and Treasury involvement to improve workers' compensation scheme outcomes. The government committed to action in its formal response to the Committee's report, which was tabled in March 2024. The Committee's review has deeply influenced how we in Treasury view the financial sustainability challenges of our workers' compensation schemes. In particular, workers' compensation has difficulty helping those with psychological injuries. The legislative framework treats psychological injury like a physical injury, and the financially sustainable workers' compensation system is focused on workers' recovery and safe return to work. We're hesitant to tell any person who is injured that the system has no expectation that they will recover. We acknowledge there is a small cohort of workers who are profoundly injured such that they may struggle to socially connect with and participate in their community. The government's proposed reforms preserve protections for these workers. All other workers should be encouraged and supported to recover and return to work. At a system level, workers and employers need greater certainty on their obligations and what is reasonable behaviour. We need to set the right incentives for the system to promote the right behaviours, recovery and connection to work. A key part in providing early intervention that gives people the right help at the right time to shift the trajectory of their recovery. The best outcome for workers does not equate to more time on scheme, but a safe and supported exit. Reform is urgently needed to stabilise the scheme costs. At the June 2024 valuation, the nominal insurer only had 85 cents to every dollar it expected to pay in compensation. And as you've heard, at December, the scheme now holds 82 cents in assets for every dollar. Premiums follow scheme costs. If growth in scheme costs do not stabilise, employing people in New South Wales will increasingly become less affordable. Getting people back to work faster after an injury is not just about premiums and the sustainability of the schemes, but about the impact on real people. Positioning the state's workplace systems to prevent and better respond to new and emerging risks of modern ways of working requires a multi-pronged approach. The draft bill under consideration by this committee is part of a broader package of interventions to shift workplace health and safety laws and workers' compensation law towards prevention against psychosocial harm. Thank you.
Thank you, Ms. Counsel. I'm wondering, with respect to your opening statements, if you've got them in hard copy.
Yes, I have hard copies
It would be
here,
great.
Chair.
The committee secretariat will take it
Yep.
just to facilitate and make it helpful for a Hansard in preparing the
Yes.
accurate transcript. That would be appreciated. So we'll open now to questions from the members. There's members of opposition, government and Crossbench, and I'll pass it to the Honourable Damien Tudhope.
So, Ms Campbell, thank you for being here. You might be able to answer this question, or alternatively Mr Wheeler might be able to answer it. I take it the amount of modelling has been done in relation to the proposal which we are now considering.
That's correct.
If in fact the claims model of 30% whole of body impairment was imposed, how many claims does that modelling show for psychological injury would be maintainable?
I might refer that question to either Ms Wheeler or Mr Liu.
Based on the current data we have, we believe it is 27 injured workers will make it past the WPI threshold.
70, did you say?
27.
27. 27? And you agree with that, do you, Ms Smith?
Yeah, that's the modelling that we have been provided.
So how many claims are there at the moment?
In terms of claims, there are about 350 odd claims, psychological claims, that get a WPI threshold of 21 plus. And for the TMF non-emergency services, there are around 200, these are all per annum numbers, 200 psychological claims per annum that get psychological, WPI assessments above 21 and above.
So that number, all those people who would currently have claims, they would not be covered by this new 30% model, except for the 27.
It's not that straightforward, I must admit. Part of it is there will be behavioural changes as the kind of bars change. So there will be behavioural changes in that. So these are the data that I can provide that we know of. How it will play out, there's a bit more complexity to that, especially around the behavioural changes.
But the modelling must show, the modelling must indicate to you the reduction in claims on the scheme, if this is put in place.
It does.
And what you say, that'll be reduced by what percentage?
Those are the numbers I've just talked through. I've got the numbers. I don't have the percentages. I can calculate them if you like.
Mr Tudhope, I believe the Treasurer agreed this morning that we would provide modelling to this committee, and I think that's being worked on currently to provide.
Costings.
Yeah, the costings.
Well, you had them in front of him, but you're working on them separately.
No, the
There's a
costings.
sanitised model we're going to get, is it?
Order.
It's not what I've said.
Order.
Well, you had
Hang
it in
on,
front of
hold
him
it.
in folder.
Can we just pause for a minute? I think we just deal with one witness at a time. No, hang on. Firstly, and secondly, the opportunity to put the question in very clear terms and an answer to be returned. That's the way we do it, and that's the way we've always done it. So, the Honourable Damien Tudhope.
So the modelling in relation to premiums, has that been done? Premium reductions or premium increases, if in fact this modelling was put in place? If this model was put in place?
Maybe if I could take that question.
For
Mr.
the NI, I'm obviously talking about.
Yeah, so for the NI, I mean, as you're aware, we go through a premium review process every year. The challenge we have at the moment is that our current premiums are below the break-even rate for the scheme. So at this stage, our view is that and there's a deficit that needs to be recouped. So we would go through a process to look at the needs of the scheme, both in terms of the operational break-even rate as well as the deficit that exists. So that work would have to happen through our regular annual premium setting process. What these reforms would help contribute to is further deterioration in that operational break-even premium rate.
So there may be no reduction in premiums, is what you're telling me?
We'd have to go through a process, that's right.
And that modelling hasn't been done?
Well, I mean, our current premiums are set upon a journey over the next several years to close that deficit. So at the moment, with the funding ratio of 82%, our target funding ratio sits at 130%. We will need to charge premiums to get back to that target ratio. So these reforms help to address the ongoing deterioration of that operational break-even premium, but it will still take many years to close the deficit that exists.
Well, if in fact we adopted a preventative approach in relation to claims, we could in fact achieve the same result, could we not?
Well, I think if you look at what's proposed in the exposure draft, it talks a lot to modernising the scheme, both in terms of the benefits, but also greater prevention activities. So yes, you're right.
Well, what we've heard is that in fact a 30% WPI is going to reduce the number of psychological claims down to 27.
I think the modelling that Mr. Liu has done in that regards is in relation to looking at existing whole person impairment thresholds. The behaviours will change as the scheme changes, and in the exposure draft there's a number of different measures that will change the number of injuries through greater prevention activities that work through the system.
So tell me about what behavioural changes do you anticipate?
Well, from prior experience, we've seen that the way the scheme is set up will change the behaviour of the scheme as it progresses.
What does that mean?
Well, I mean, since the reforms were introduced in 2012, we've seen the number of claims reaching higher whole person impairments at much greater rates than when the legislation was introduced back in 2012, as by example.
Can I clarify an earlier answer, please?
Yeah.
So the numbers given are for ongoing benefits past the entitlement period, not the total number of psychological injury claim numbers. The other thing to note in terms of behavioural impacts around thresholds is we often observe that wherever you set thresholds, you have a bulk of injured workers who just pass the threshold. When that is reasonable, because once past that point, your entitlements are the same. So if you set new thresholds, we think some of these assessments and how they turn out would be different, because all of a sudden the bar's higher. People would do more around to get to obtain the higher WPI assessments.
Ms Campbell, the Treasurer threatened this morning to make no further contributions to the TMF. What would be the impact of that?
So, Mr Tudor Hope, as you know, the NAHLP policy is no longer in place, and the new contributions and transfer framework is operating. We are continuing to monitor the liability valuations for the TMF, together with investment returns, to provide advice around whether contributions would be required. But as the Treasurer said this morning, he is not proposing to make a cash injection into the TMF until the reforms are considered before Parliament.
What will the impact on the TMF be if he in fact does that?
Well, at the moment, Mr Tudor Hope, the ratio is in excess of 100%. So in terms of assets to liabilities, so you know that there are various factors that will influence that, and that would be a decision for the Treasurer under the new framework as to whether any contributions would be made.
But what's the impact of not making any further contributions?
Well, at the moment there is no impact, because iCare has sufficient assets to meet its liabilities under the ratio.
And what you'd be saying is then the threat this morning was an idle threat. Is that what you're telling me?
Well, that's
Can I just intervene here? Because this is for the benefit of the witness. The language being used is threat. And that's okay, I understand the language you're using, but I don't think it's fair on the witnesses, who are not politicians, to be led into answers where the word threat is placed. I mean, the Premier was here today, and he announced and
Treasurer.
explained
No,
the
he
position.
wasn't.
But I just simply make the point that the witness just ought not be presumed to have accepted that word you're using. That's the only point I make.
Thank you, Chair. Obviously, I can't speak to opinions of the Treasurer, Mr Tudor-Hope, but, you know, the position I'm stating is around the short term, and what we're looking at, or what we're talking about as part of these reforms is the long-term sustainability.
Yeah, but the TMF is a self-insurer, is it not?
Yes,
So it insures government workplaces,
correct.
and in those circumstances, there would be no reduction in the ability to make claims on the TMF.
I'm not sure I understand the question
Would
that
there
you're
be
asking.
The current claims model remains in place, and you'd be able to continue to make claims on the TMF, and the self-insurer would be responsible for those claims, would they not?
Correct.
So the decision, not if that was the Treasurer's decision, not to make the payment in accordance with the current guidelines relating to the net asset holding policy, in effect would not have any impact in relation to the ability to make claims.
Yeah, I think that's correct, Mr Tudor-Hope.
And the liability of the government for those claims would remain the same. It'd just be a
that's correct.
different manner of which you would enter that potential liability on your balance sheet.
Well, the reflection on, you know, the liability valuations are reflected in the budget and the balance sheet on an annual basis.
Yep. So, but the scheme at the moment requires the government to, in fact, transfer money to the TMF to make sure that it reaches a particular percentage relating to the net asset holding policy, does it not?
No, well, the net asset holding policy no longer applies. The contribution and transfer framework has taken its place, and there are various principles in there that will determine whether a contribution should be made in the context of the whole one fund.
So there is, what you have indicated is that there is a new contributions and transfer policy.
Correct.
Is that in a document?
It is in a document.
Can we have a copy of that document?
It's not published. It's a Treasury internal document. I'd have to take that on notice and come back to you, Mr Tudor-Hope.
It's been taken on notice. The Honourable Mark Latham.
Thank you, Chair, and thank you to the witnesses. Just following up there, Ms Campbell, what would be the medium-term impact if the Treasurer's quasi-threat was carried out?
Well, I
I think
can't
that's slightly
speak for
cavalier
the
than what I said earlier, but anyway.
Treasurer,
Well,
Mr
we can use
Latham.
plain English here, can't we? What are we, the sort of...
I mean, our job in
PC
Treasury is
society.
to provide advice, and we will monitor the asset to liability ratios, and the Treasurer will make decisions on whether
But
contributions
what's your
would be
projected
made.
impact? No further contributions to the
I
top-ups?
can't speak to that. There's a
Why
range
can't you
of
speak to
varying
that?
factors, Mr Latham, that would make that determination.
Has Treasury got any forecasts that it's provided to the Treasurer?
Well, we receive forecasts on, we received the liability valuations from iCare. In relation to the TMF, we also monitor the investment returns, and there's a combination of those that determines, the position of the TMF at any particular point in time.
And what do those forecasts show 3 years from now if there's no top-up?
I don't have those numbers, Mr Latham.
Can you take that on notice and
I
provide
can,
it?
yes.
Okay. The Treasurer painted in his evidence quite a dire picture of the position of the TMF. He said that there's been a $2.6 billion write-down to be reported in the next state budget, which is next month. And sans reform, that is 2.6 down, and that's just 6 months after the last write-down. Is that a correct assessment of the write-downs?
Well, the budget will be released next month, and those numbers I don't think have been finalised, but that's the advice that has been given to the Treasurer based off the valuations from
they're
iCare.
your numbers that he's repeated
based
today
off the
about the
valuations
valuation of the write-down?
from iCare.
Right, and is it 6 months after the last write-down?
Well, iCare undertake their liability valuations on a 6-monthly basis.
Right, Mr Liu, is that right?
That is correct.
Yeah, and what was the previous write-down amount 6 months ago?
6 months ago.
Please, if you can take that on notice
Can I
we'll-
please take
Maybe
it on
give us
notice?
the write-downs for the last couple of years and any projections you've got
We will
for
have
the
that
future
information,
forecast?
Mr.
Yeah,
Latham.
okay.
Just give us a moment.
Yeah, we'll just take it on notice. We're not going to solve the problems of the world here today or this bill, you know. But if you can just provide it at your convenience, that'd be helpful. And Ms. Campbell, what are the origins of this exposure draft? To the best of your knowledge, where did the process start and what was the input of Treasury?
I might actually hand to my colleague, Miss Wheeler,
Ms.
if
Wheeler,
you'd like
yeah,
to
please.
answer that.
Certainly, Mr. Tudor-Hope. So
No,
in
I'm
terms
better looking
He's
than
a
him.
lot
Come on,
better
mate.
looking than
Don't tell me that.
Mr.
jeez.
Latham, my
No,
apologies.
I've got a psychological injury now. I'm buggered.
So the exposure draft is the result of a series of advice that has been provided to government, with Treasury working in collaboration with the Department of Customer Service, CIRA and iCare, and a task force that was formed from 10 March this year.
You say 10 March?
Correct.
Right, and what was the origins of the task force that was to deal with this looming financial crisis?
So there has been preceding advice provided to government, both from ourselves as well as from iCare and CIRA, in relation to the financial positions of each of the schemes and the growing trends in relation to psychological injury.
Could you take on notice the membership of the task force for the benefit of the committee, please?
Certainly.
And who set up the task force?
I believe I did, Mr.
Did you?
Latham, at the request of the
Congratulations.
Treasurer. Yes.
With the...
At the request of the
At the request
At
of the
the
Treasurer?
request of the Treasurer,
Right, and what was the
yes.
nature of that request?
Well, I think, you know, there are various different agencies and ministers across government that, you know, have responsibility for aspects of the scheme. And the task force was a request to co-locate everybody in one place so that we could have a focus on developing the options and advice to government that have informed the bill.
Right, and Mr. Liu or Wesling, is the first you heard of the development of this sort of legislation is when they put you on the task force?
Well, since this government came to power, we've had ongoing, frequent discussions with ministers' offices, with CIRA, with Treasury around the challenges that we're facing. We've been working with those same parties around areas like whole of government, return to work. We've been discussing for over 2 years the need for some sort of reform. So it's been a very long, ongoing discussion.
Right, so ongoing, and as soon as the Treasurer came into office, knowing how much he's loved and taken an interest in iCare over the years, you briefed him on the financial difficulty and the need for these kind of reforms.
We've been providing regular briefings to the Minister's office, yeah.
Right, and did you suggest at any time in this process the type of reforms that are in the bill?
That's not a role for iCare. We've been providing advice on the experience
Okay.
we're seeing in this scheme.
Okay. Just on those, to the Treasury representatives, have you been involved in the drafting of the bill as such? The different provisions, like 8E is particularly contentious, meaning a relevant event, and some of these things sort of contradict each other, or they're open-ended, defined. Who actually put these provisions together?
I would say it's a combination of the task force. So
The task force did?
Department of Customer Service led on the drafting instructions, but the task force together, you know, debated different aspects of the policy positions to give advice to government, and ultimately government direction has informed the bill.
Thank you.
Move now to Abigail White.
Thank you. When you say you've done modelling to work out the impact of this, have you done modelling based on every single aspect of this discussion paper that's been given to us today, or just on the obvious things like the WPI and those things? As in, have you looked and gone, each claim, if it was to jump through all of these hoops, how many would be excluded?
I should probably explain the nature of actuarial work.
Don't take very long though, please. Sorry.
I will try to be short. I will try to be short.
Hold it. You answer the question as required, okay?
So we look at how the claims will go through the various entitlements and thresholds and barriers, but we then actually look at it at a portfolio level. It is not an assessment of every individual, but at a portfolio level, cut up to the dimensions required depending on what we're looking at. We've provided a lot of actual advice to government regularly on things that impact our scheme.
Apologies, if I could just, if it's okay with you, just interrupt you there because I have a very short period of time. If I could just ask instead, if I could go to Mr. Wesling, the impact of AASB 17, which takes effect from the beginning of the next financial year, so in just a month and a bit, what is the impact on the bottom line for iCare, and would that change if the Treasurer didn't put money in, as he's threatening to do?
Ms. Boyd, I might ask Mr. Liu to give you the proper answer to that.
I'll be quick. The AASB 17 does not apply to the TMF. The TMF is a self-insurance scheme, so that accounting standard does not apply.
Yes.
The accounting standard does apply for the nominal insurer as it issues insurance policies. It is a brand new insurance reporting standard. There are two kind of larger financial pieces. One is around the concept of risk adjustment.
Sorry to interrupt again, if I could just redirect.
Yep.
In iCare's submission in June 2022 in relation to the TMF, it talked about a $3.68 billion hit to iCare. Would the accounting treatment that you're talking about where it's not applying apply if the Treasurer did not put in the money required to run the scheme?
We've done more work since AASB 17 won't apply to the TMF.
Okay, could you provide on notice perhaps the analysis of how that works?
Of course.
Thank you. I just want to move on. Does iCare still collect data on the number of injured workers who suicide as a result of Section 39 and Section 59A?
Thanks for the question, Ms. Boyd. So I think at the budget estimates you asked me that question. We had stopped reporting to CIRA through the midpoint of last year. We do continue to collect information on injured workers who self-harm and suicide. Yes.
Given that, so I've spoken to a lot of people. My office comes into contact with a lot of injured workers, and I've spoken now to multiple injured workers who have psychological injuries above the 20% threshold, who tell me that if they were to have been cut off at 2.5 years, for instance, because they wouldn't have met this new threshold of 31%, that would have been just at the point where they, were particularly at risk of suicide, or that they would have been needing to sell their house, for example. Have you modelled the potential number of suicides that these reforms would likely result in?
No, we haven't.
Is that a concern for you?
Clearly we take self-harm and suicide very seriously. Over the last years, we've set up a team to deal with that. We've set up programs and processes to help manage, with the introduction of Section 39, the exit of injured workers off the scheme. That is very central to us. We obviously maintain the statistics around that, and we have a team who's continuing to focus on ensuring the well-being of those injured workers.
Given the evidence that the performance of the claims managers has been responsible for some of the return to work problems, and I'm talking about the inquiries we had before where we've talked at length about the involvement of lawyers and people surveilling workers and all of these other issues that have led people to not only delay their payments and actually getting to the point of being given a claim or being given compensation, but then the high rates of when those claims actually make it through the system to actually have been found to be valid all along. What work has iCare done to actually hold those claims managers to account for their involvement in stopping people getting better and getting back to work?
Perhaps I could just outline that since I've been in this role, certainly we've had a significant focus on lifting the empathy and the way in which claims managers work with injured workers. As you're aware, we've rolled out professional standards, which does deal with that as well. We've rolled out guidelines in areas around managing sensitive claims. In regards to claim service providers, we have our contract has a minimum standard of service. There are quality measures that we track. As you know, we've introduced our complaints process over the last few years, where we have a standard complaint system, a standard way of tracking complaints and escalating complaints.
Apologies for interrupting. If you could just put on, take on notice in this last second, if you could give me numbers for workers in the NI and workers in the TMF who are over 15%, over 20% and over 30% WPI. That would be very useful. Thank you. Sorry, this timing is ridiculous.
Thank you. The Honourable Bob Nambar.
Thank you, Chair. If I could just follow up on a question from Ms. Boyd a little bit earlier, just around the projections of the numbers of workers that might be affected by the reforms. I'm just going to quote from a submission that the committee has received by Ms. Rochelle May, where she states, if the exempt workers, that is workers that were exempt from the 2012 reforms, are not affected by the bill, then the number of workers with psychological injury claims within the public sector government TMF to whom the bill is addressed is significantly reduced due to the fact that the largest number of psychological injury claims arise in public administration and safety. Do you agree with that observation?
I haven't read the submission that you're referencing, but my understanding of the exposure draft is that a lot of the psychological injury claims that we see in the TMF today, and a large part of that is the emergency services exempt portfolio, would not be subject to, many of these reforms would not impact those claims. So yes.
Okay, thank you. Might just move to, just very briefly, the Cumston Sargent Independent Review of iCare Financial Sustainability report. Now, albeit it was a few years ago, it identified the principal risks to the financial stability of the nominal insurer as follows, in descending order of financial significance: the amount of premiums that will be collected, the investment return on financial assets, claims costs and other expenses of the nominal insurer. Has there been an assessment made as to the deterioration of the scheme that is attributable to each of those principal risks if there are significant changes to them?
I don't think I can pull something for you right now on that over time, Mr. Namva, but I probably would add that of those four things that you just called out, premiums are obviously extremely important. We collect premiums to pay for claims to pay for claims for the lifetime of a claim, and we have clearly been over a long period of time underpricing premiums, and we're in a process of closing that. So a large chunk of the deficit has been as a result of the under-collection of premiums against that break-even premium that I spoke about. The second one you mentioned is claims. Through the valuation, you can see the deterioration over time of claims, which is a large part to do with the volume of psychological claims and the numbers of claims reaching higher whole person impairment thresholds. There's many other drivers, but those are certainly two big drivers, and that has been a very big driver of the funding ratio decline over time. The third is investments. I mean, generally our investments portfolio has worked quite well. There's a volatility at the moment, but that has generally met the targets that we've set. And the fourth one being the operational expenses make up a very small proportion of the costs of the scheme. So it's really those first two, the premium deficit and the claims experience over time.
Do you agree with the conclusion from that report that the principal risks to the financial stability of the nominal insurer are those risks in that order?
Yes.
Has an assessment been made with respect to the deterioration of the scheme with respect to the rising number of self-insurers and the reduced return to work rates over time?
Well, that would be a matter for CIRO, who sort of regulates the scheme at that level. You probably would see in the Cumston Sargent report a reference to the nature of that risk to the nominal insurer, but I think that's a question for CIRO.
If I could just turn to other expenses, if my numbers are right, approximately 67% of benefits paid under workers' compensation is paid directly to workers, and approximately 30% are indirect benefits paid to rehabilitation services and medical specialists. If that's the case, can we be sure that we're getting value for money from the 30-odd% that's spent on rehabilitation and medical expenses, particularly medical fees?
Look, that's something that we have work to do over time to make sure that we do get the best outcomes for the services that are provided to injured workers, whether they're medical services, rehabilitation services.
It's not an insignificant amount of money, and it's not an insignificant impost on the scheme. Obviously, one way of ensuring the financial sustainability and the solvency of the scheme is access to benefits and the quantum of benefits, but surely a significant 30% impost on the scheme warrants a fair bit of attention, doesn't it?
It does, and through our day-to-day management action, we are looking at the effectiveness of that spend. We're looking at reducing leakage, and you've heard about fraud, and we're looking at managing where we can the quality of service to injured workers.
Have the costs been tracked over time and benchmarked against other schemes in other jurisdictions?
Well, we certainly track all of those expenses over time. I'm not sure about. Maybe you could ask about benchmarking.
Maybe I'll start with one of the kind of primary purposes of the workers' compensation scheme is to support injured workers and their recovery to work, and medical treatments is a very key part of that.
I suppose I'm talking about the cost and the scheduled fees of the medical treatment.
I think I just want to kind of say, well, a huge cut to a medical treatment may look good, but it could actually potentially increase the cost of the scheme.
I'm certainly not talking about a cut in medical treatment.
And yes, the medical costs are tracked. Yes. So on the medical costs front, the medical costs are tracked. For the recent years, they have been reasonably stable. Quite a time period back, we had a period where medical costs increased quite significantly, but that's since stabilised for the last 3 years or so. We're monitoring that. We pretty much monitor it every quarter. The most recent quarters, there have been some increases in medical costs that we have seen. We're analysing it and trying to work out what's actually happening and providing feedback to the business and responding to it appropriately.
If I may add, CIRA has a regulatory function in respect of this, and those questions you may wish to ask when they appear this afternoon.
Okay. Might just change tack very briefly before I pass to my colleague, but just in terms of return to work rates by insurer for non-physical injuries, there seems to be a significant differential between the return to work rates for psychological injuries between the nominal insurer and self-insurers. I suppose, do you have any observations on why there might be such a difference in those return to work rates? That the numbers I've got as of February 2025, at 4 weeks, the return to work rates for the nominal insurer was 19%, 33%. For self-insurers, at 26 weeks, 47% versus 65. At 52 weeks, 57% versus 68. Is there an obvious explanation to that?
Yeah, maybe if I could start, and Mr. Liu might jump in as well. There are, I think, approximately 70 self-insurers, and they tend to be the very large organisations that have a greater scope for provision of suitable duties to return injured workers to the workplace, whereas the nominal insurer is made up of, out of the 380,000 employers, the vast majority of those are small employers. So they're structurally quite different in terms of the opportunities of returning to work. And if you overlay that then psychological injuries, and we've heard the growth of psychological injuries has been work conflict type claims. There's larger organisations, larger corporations have a great opportunity to move people around and find suitable duties than small businesses that might only have a handful of people working for them. So that's the primary explanation for that quite substantial difference that you see. I mean, in the nominal insurer, we can see differences in return to work between our smallest businesses and our largest businesses that reflect that as well.
I mean, whatever the merits of the situation, then doesn't that just mere fact alone just suggest that the rise of self-insurers and the inability of nominal insurer to spread risk does have a substantial impact on the sustainability of the nominal insurer scheme?
That would be a consideration for CIRA.
Can I just take you to your submission on page 6? There's a graph there with the TMF claims indicating a increase from 18% in 2022-23 to 21%. So, and then it gives the raw numbers. So of that 4,555 in the 2023-2024, how many of those would be emergency services employees that are not covered by these reforms?
Mr. Datum, we'll just see if we've got that.
We don't readily have it. We might just take that on notice. It's roughly half, but maybe we'll come back with the actual numbers.
So we're talking about maybe in the order of 150 more claims than the previous in terms of the ones that would be affected by these reforms. Is that correct?
So can you outline your maths again for me?
Oh, because you're saying that half the difference between 443 to 550, 250 of those would be claims that are covered by the reform proposal.
Perhaps we could come back to you on notice to answer your question.
Okay, so I suppose I wanted to come back to this question around the long-term trajectory of the schemes, both nominal insurer and the TMF. We had an inquiry from this committee in 2022. iCare appeared. There was no warning of catastrophic collapse of the scheme back then. The increases don't seem like huge numbers in relation to TMF. Certainly nominal insurer, similar. You know, the numbers don't seem huge. Is it sort of being over-egged that this is a impending crisis? I mean, the Treasurer was talking about insolvency earlier today. How long has the scheme, nominal insurer got before it's insolvent?
Well, as we shared today, the funding ratio is 82%. That means there's a deficit of funding in the nominal insurer, and that's grown over time. That funding ratio has been reducing for the best part of, for many, many years. That funding ratio has gradually declined. So as that deficit grows, that burden needs to be borne by future premium payers. So the issue is, if we don't stem the ongoing growth of that deficit, the future generations of employers will have to pay a much higher.
Is that?
Well, today, I mean, or every year we publish our accounts, and the audit office reviews those accounts. We have no issue paying claims over the short term. We've got assets to cover the cost of claims for years to come. This is about the long-term sustainability of the scheme and the ability to continue to pay claims well into the future and for the next generations.
So not insolvency.
So just conscious of the time, so that gets us to 12:59, but noting we're returning after a 15-minute break at 1:15 sharp. So we're going off at 1:15 sharp, but we've got important which after lunch, so I'd ask members about promptly. Can I thank you all very much for coming along to provide answers to questions both technical and more broad. Appreciate that very much.
Thank you,
So
Chair.
questions are noticed, and the Secretariat will liaise with you. Thank you. We return at 1:15 sharp. Well, we'll return back now after the lunch break, and thank you for the cooperation, members, to get back on time. We have our next tranche of witnesses. Just the procedural part, of course, which you're well familiar with, and that's the swearing of the affirmation, whichever you prefer. So perhaps it's easier if you start my left and work across, and if we do, first of all, name, position, title, oath or affirmation, whichever you prefer, the words of which should be before you. Thank you. Please, yes.
My name is Shane Butcher. I'm a member of the Injury Compensation Committee of the Law Society of New South Wales.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Butcher. Next witness.
Thank you. My name's Tim Concannon. I'm the chair of the Injury Compensation Committee of the Law Society. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Concannon.
My name's Dominic Toomey. I'm the Senior Vice President of the New South Wales Bar Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Toomey.
Mr. Chair, my name is Tony Bowen. I'm a barrister. I'm a member of the New South Wales Bar Association's Common Law Committee. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, gentlemen. Confirmation, both the organisation's submissions have been received, and we're grateful for that. The submission from the New South Wales Bar Association is submission number 41. It's been processed, uploaded to the inquiry's webpage, and obviously stands as submission to this inquiry and evidence. And with respect to the Law Society, the same. Your submission is number 34, stands now formally processed as a submission to the inquiry, uploaded to the webpage, and stands as evidence to the inquiry. So now a chance for some oral evidence from yourselves. We have we have committee members from government, crossbench and opposition. We're sharing it equally with the time available, but we'll first invite both organisations, if you wish to do so, to make an opening statement. So perhaps if we start with flip a coin, does it matter? Who would you like to start?
I'm happy to commence.
Please, that would be great.
Thank you, Mr. Chair. We would like to make some brief opening remarks.
Thank you.
The Bar Association thanks the committee for the opportunity to address it. At the outset, we wish to say that the consultation in respect of these undoubtedly wide-ranging proposed changes, potentially affecting millions of workers and their families, has, in the Association's view, been unduly rushed, meaning, among other things, that the Association has been denied the ability to offer all the assistance it would otherwise have wished to, particularly if we had been granted access to the latest financial data and actuarial modelling. It is, with respect, unsatisfactory that we should be asked to address this important inquiry blindfolded, and that this committee should be asked to report, perhaps from a similarly disadvantaged position. That said, we can address the effect of the proposed changes on workers who suffer mental health disorders which have arisen out of or in the course of their employment. The impact on many would be quite devastating. At the most fundamental level, there will be workers who have an undisputed, ongoing and very serious psychological injury who will be denied access to both medical treatment and income replacement compensation. Moreover, the requirement that there be a relevant event as defined in the proposed Section 8E before any compensation will be payable represents a very significant narrowing of eligibility for compensation. It removes, for one, the right to recover for workers who have suffered psychological injury by reason of the inherent pressures and stresses of their work. For many, those pressures are real, and the psychological effect debilitating. The fig leaf offered to workers with a work pressure disorder in the form of the payment of medical expenses is quite inadequate and unfairly places the obligation on employers personally to pay those expenses even though they've taken out compulsory insurance. Even more concerning is that Section 8E would, on one reading, indeed perhaps on a plain reading, not even afford compensation to those who witness the immediate aftermath of catastrophic accidents, either in their workplace or in the case of frontline workers in the community which they serve. The definition refers only to witnessing an incident that leads to death or serious injury or the threat of death or serious injury. If that is the intended effect, it is radical. I wish to make one correction to our written submission. Paragraph 70 in our submission is in error, and we, with respect, withdraw it.
Thank you. That is noted and will be done. Thank you.
Thank you. The requirement in respect of cases involving workplace bullying and harassment that a finding be obtained, presumably from an IRC with expanded jurisdiction, before a claim can even be notified, flies in the face of the accepted wisdom that the earlier a person receives treatment for their condition, the more likely they are to recover and to return to work. The combined effect of the proposed Section 8E, E to G, 8F and the existing Section 254(1) of the WIM Act will be to deny genuinely injured workers the compensation they are entitled to, even under the more stringent injury definition proposed, perhaps for many months, and to subject vulnerable workers to the additional stress of adversarial proceedings. In many cases, that will effectively kill any prospect of an early recovery and return to work, and in the long term add to rather than contain the cost to the scheme. Such an outcome is not only self-evidently anathema to the most fundamental objectives of a functioning workers' compensation scheme, but is indeed contrary to the stated objectives of these amendments. Briefly addressing the proposed 31% whole person impairment requirement, the threshold of 31% affects numerous entitlements. It is a threshold which will be met in a mere handful of cases. I understand that the committee has already heard evidence today as to those numbers, and to use the term handful based upon my understanding of the evidence that has been given is apposite. Many of our members, that is, members of the Bar Association, indeed an overwhelming majority, have never seen a case involving such a high assessment. An assessment of that magnitude would necessarily involve profound occupational and domestic dysfunction, and almost certainly hospitalisation, perhaps for multiple and extended periods. Assessments below 21%, let alone 31%, will almost inevitably involve incapacity for work, often for a prolonged period, and the requirement for medical treatment, again often for extended periods, many as inpatients. The proposed change in the threshold operates against injured employees in three respects. First, it removes the entitlement to lump sum compensation for all but the most extreme cases. Secondly, it caps at 2.5 years the entitlement to any income replacement payments. And thirdly, it prevents a claim for damages even where there is plain negligence on the employer's part and the worker is profoundly and chronically debilitated by psychiatric injury. We are asked to comment on all these proposed changes and more. The driver for these changes is said to be an increase in the number of claims for psychological injury and a corresponding increase in the cost to the scheme. As I said earlier, we do not have the most recent financial data or access to any of the actuarial modelling. Though there is publicly available data on the CIRA and iCare websites, that data concerns the 2023-2024 financial years. An analysis of that data has helpfully been undertaken by Mr. Kim Garling in his submission, and given the time constraints, we would simply commend Mr. Garling's submission to this committee. He has debunked some of the hyperbolic language and unfounded assertions that have been made from some quarters. Mr. Garling's analysis of the data calls into question the assertion that there has in fact been a dramatic increase in psychological injury claims. So far as actuarial modelling is concerned, there will be undoubted savings to the scheme in the proposed amendments to the provisions concerning the commutation of entitlements and the ability to resolve by compromise those death claims where there is a dispute as to liability. They are both changes that have been supported by the Bar Association for some time. Without access to the modelling concerning the savings that will inevitably be made from those sensible amendments, we're being asked to comment on other radical changes to workers' rights. The Bar Association wishes to urge the government to hasten slowly. Savings can undoubtedly be achieved without drastic effects on the rights of the psychologically injured. We have suggested some ways in which that can occur in our written submission. A sober analysis of the data and projections is called for. All stakeholders, workers and employers alike, are entitled to expect it. Just two further matters, if I may. There are no proposed transitional provisions in the exposure draft. It is presently unclear when such changes as are proposed to be made will take effect and whether they will affect workers who have already sustained psychological injury in the workplace. And the final but by no means unimportant matter which we wish to emphasise in the time available is the extensive reliance in the draft bill on regulations or delegated legislation. This is, as we have said in our written submission, to be strongly discouraged. It makes it difficult, if not impossible in some respects, to address the true effect of the proposals. A prime example is in the resort to delegated legislation in the critical definition of the term relevant event, which affects the question of the entitlement to compensation in every primary psychological injury case. I thank you again for the opportunity to appear, and we hope to assist this committee as much as possible in the circumstances.
Thank you, Mr. Toomey. That's a very helpful and valuable opening statement, and I appreciate it. Mr. Concannon, will you be delivering the...
Yes.
So it's here, Mr. Concannon.
Thank you for inviting the Law Society to give evidence at today's hearing. I'm here in my capacity as Chair of the Law Society's Injury Compensation Committee. I'm joined by Shane Butcher, a member of the Law Society's Injury Compensation Committee. The draft bill proposes significant changes to liability and the ability of workers to commence claims to be awarded compensation for psychological injuries. Our members, who represent claimants, insurers and employers, agree that reform of the New South Wales workers' compensation system is overdue and appreciate the importance of a scheme that is financially viable and not open to abuse. We are disappointed, however, with the limited consultation process for these reforms, which will have a marked impact on the existing scheme. As set out in the Law Society's submission, the proposed changes, in particular the 31% WPI threshold, will mean that almost all claimants who experience psychological injury in New South Wales will be precluded from making a claim. We suggest, in the interests of compromise and noting the government's clearly stated intention to enact immediate savings to the scheme, that changing the WPI threshold to 21% would ensure that some workers, generally recognised by community standards as being severely impacted by mental health, would be able to make a claim, whilst easing upward pressure on workers' compensation insurance premiums. We draw the committee's attention to the way in which the combined effect of section 8E and 8G means that no compensation is payable for a primary psychological injury outside of a relevant event or events as set out in Section 8E. This would preclude injuries caused by overwork, for example nurses and doctors subject to continuous unrostered overtime, verbal aggression from customers or clients of a business, for example a person who was abused in the course of their work in the hospitality industry, exposure to emotionally distressing material in a high-stress work environment, for example persons working in child protection and with victim survivors of domestic violence, a single act of bullying or discrimination on the basis of religion, gender, sexual preference or marital status and other attributes that fail to be protected by this legislation, or attending the aftermath or treating the victims of a motor accident, natural disaster, fire or other accident, given that, arguably, this does not fall within the definition of witnessing the incident or accident. We are concerned that some of the proposals will not promote psychological safety in the workplace, nor return to work objectives, but result in compensation costs shifting to other sectors, including longer-term health care and social security. In particular, we draw the Committee's attention to our comments on the operation of the special provisions for primary psychological injuries caused by sexual or racial harassment or bullying. Our submissions have also focused on changes which are not limited to psychological injury claims, but will impact the scheme as a whole, such as the new assessment process, which we suggest will increase disputes and discourage settlement. It is in the interests of transparency, accountability and sound law reform and policy making that the government provides statistical data on psychological claims which may assist in providing a more nuanced understanding of the pressures facing the scheme. We suggest further discussion with stakeholders about the design of the scheme to ensure it achieves an appropriate balance.
Thank you, Mr. Concan. If it'd be possible with both opening statements, excuse me, if you've got it in hard copy there, if they could be provided to the Secretariat, they'll just help Hansard get the accuracy as close as possible. In fact, right on. So thank you for that. We'll now open it up for questioning and to the Honourable Damien Shoothope.
I probably don't have a lot to add, I must say, but it'd be to you, Mr. Toomey, first, and thanks to all of you for being here at such, I suppose, short notice, given the exposure draft and the short time frame. Is it paragraph 7 that you have withdrawn?
No, it was 7T.
Oh, 17. Oh.
7T, 70.
7T, oh.
70. The submission has unduly confined the effect of the provision to which it's referring and is therefore invalid for that reason.
Thank you. You didn't make, and I suppose this arises by virtue of the fact that you have not seen any exposure draft of amendments to the Industrial Relations Act about the new system of having to obtain a certificate from this forum in relation to being able to commence proceedings for the bullying and harassment allegations. Do you want to expand on potentially the defects of adding this new jurisdiction and the what the impact of this process would be on litigants with psychological injuries relating to those particular events, whether it's serious bullying or sexual harassment or racial harassment, as I understand?
Yes, I'm very happy to, and I thank you for the question. The first, one of the matters I should have mentioned in my opening remarks is that it's entirely unclear to us at this stage whether there would be the provision for paid legal representation, for example, for someone who finds themselves in the position of having to seek such a certificate. We would also observe that the person who is being required to seek the certificate is already by definition vulnerable by reason of the reasons for their having to do so, and we would expect that without legal representation, they would be greatly disadvantaged in that process, which we expect would be an adversarial process, because there would be at least one other interested party in the outcome. It is possibly also conservative, what I said in my opening, that it might delay by a matter of months the making of a notification of injury. It could go for many months, and we don't know whether there would also be provision for an appeal from any such decision. The combined effect of the proposed provisions and the existing Section 254 of the Workplace Injury Management Act is that a notification of the injury cannot even be given until that process has been undertaken. And we, with respect, think that this is a misguided reform.
And if the proposal was that there were no benefits payable until such time as that certificate had been issued, then in those circumstances the complainant would be required to rely on their own resources.
Indeed, and I might add, it's not only that no benefits are payable. All those things have to occur even before notification of the injury can be given, which sets the claim process in train. Once that happens, of course, there may well be some contest about any medical condition, its extent, the extent to which it causes incapacity, etc.
Can I ask you to comment on Section 11A and the manner in which that operates? The evidence which is often provided is that employers are never successful under the existing Section 11A. Is that your experience?
I think I might defer to Mr. Bowen on that matter.
Thanks.
If I may.
I'm happy to take that. I think there is truth to the basis of your question, but it's not unheard of. But it's actually addressed in our submission, whereby the resources that are deployed at that stage of a claim and how it's undertaken, in a sense that it may not be world's best practice. So, but I don't think it would be fair to say that it's a defence that's never made out.
But
no.
Is there a case for strengthening?
I think there's a case for discussion about it, and I suppose to give a balanced position, you would have to say that there would be some case for that, particularly in the context of these type of claims that we're discussing of psychological injury. But I mean, I don't see it as a major part of the problem, or that would need to be addressed by, or what's sought to be addressed by these amendments.
Well, the evidence often is that an employee gets placed under, say, performance review, and the first thing they do as soon as they get a performance review, they're off on stress leave. And the employer, in those sort of circumstances, even seeking to rely on 11A, is rarely successful.
Well, I think I would only say, if I may, that Section 11A covers precisely that situation, and it's really a question of the evidence that is marshalled to make out the defence, as we've said in our written submission. Having said that, I mean, we would not die in a ditch over the extension of Section 11A.
So it wasn't one of the sections you identified as being supportable, or the replacement of 11A wasn't what you identified as one of the potential sections which you would support.
It's not, that's true, but it's only on the basis that we consider that 11A is sufficient in its present terms. and that it's really a question of the evidence that's being marshalled to make out the defence.
Some other evidence we've also heard is that part of the justification for some of these changes relates to fraud.
Yes.
And often when the word fraud is used in the context of workers' compensation, everyone thinks it's the worker who's in fact defrauding the system, but in fact some of the evidence is that it's lawyers and doctors, and there's a plethora of people potentially gaming the system. What do you say in answer to that allegation?
Well, quite plainly, we would decry any instances of fraud on anyone's part. We have not approached this committee or these reforms as addressing the question of fraud. Fraud, if it exists, should always be weeded out.
Well, to the extent that there is potential doctor shopping or the like, does this legislation potentially address some of that issue relating to fraudulent claims?
I don't see how, with respect, but I would be happy to be taken to specific provisions.
Mr Concannon, do you get complaints in relation to the manner in which the workers' compensation scheme currently works in terms of potential fraudulent use or fraudulent claims? And I use the word fraudulent liberally.
I think this is the same problem you had in the CTP scheme leading up to the 2017 amendments. It's a question of how you define fraud. Fraud can be someone who decides to see one doctor rather than another. That's not fraud. It may be advantaging the system to that person's benefit, but I don't see that as being fraud. If you're asking whether I see any person, I act for workers solely. I don't act for employers. I don't think I've ever seen a worker that's come to my table who I can say is clearly a fraud, and I've been practicing for over 30 years. And frequently in this area of workers' compensation. So there are certainly claimants who sometimes exaggerate their symptoms, absolutely, but there may be a number of reasons why they do so, conscious or subconsciously.
Thank you. Excuse me, Deputy Chair.
Thank you very much, Chair, and good afternoon to all of you. Thank you very much for your submissions and turning it around in such a short period of time. I just wanted to ask, there's a lot we could talk about, but can I just ask you about the definition of psychological injury? And it's been put to us that by some people that we needed to have a definition around psychological injury in order... I don't know. I think the argument is perhaps to only capture so-called genuine psychological injury. I'm really not sure where that's come from and what that means. But from your perspective, if we were to have a definition of psychological injury, would it look like this? And if not, what could it look like instead? And should we have one?
Personally, I don't see the need for it. It's established. There's a guide called DSM-5 that psychiatrists apply when assessing psychological injury, and there's plenty of evidence there from specialists as to what is and what is not a psychological injury. Now, to require there to be a significant behavioural, cognitive or psychological dysfunction, in my view, places an extra burden on those looking to establish a psychological injury. For the most part, the workers' compensation legislation doesn't talk about psychological injury or physical injury, they just talk about injury or disease. So this reference to psychological injury, really for the most part, I don't think is required. The only references to psychological injury that I can recall in the legislation are those that restrict lump sum impairment compensation, let's say, to a threshold of, unless you get to a threshold of 15%, and those associated with that part of the legislation. But this is certainly a higher bar to jump over to require there to be significant behavioural, cognitive or psychological dysfunction.
So how does that work? If you've got a psychological you've got a diagnosis of a psychological injury, you can show that it has been that it was work related, that you incurred it at work, but then under this legislation you also have to show that it's causing significant impairment, etc., unlike you would for a physical injury. How does that then...
It's a higher bar, and it's one in... For instance, in the motor accident legislation, there's no such requirement for there to be a significant psychological injury. There just needs to be a recognised psychiatric disorder within the meaning of DSM-5. And there's no such. This is an extra bar, extra burden on top of that.
Would this leave it then so that when it comes to a physical injury, we trust a doctor to tell us whether or not someone has a physical injury, but when it comes to a psychological injury, we're putting a legal definition in rather than relying on a medical opinion? Is that the effect?
I think I would say yes to that, but I'd have to say I don't know whether this psychological injury definition is borrowed from somewhere else.
Yeah.
Given that we've only had 3 days to review it, it may come somewhere in DSM-5. I'm not sure. But
if we can return to basics, the way the Act operates is presently is first to ask whether there has been an injury, and that injury will then sound in compensation if it causes incapacity. So to some extent, the proposed definition of psychological injury is redundant, because unless there is some impairment in earning capacity by reason of the injury, no compensation flows in any event. And unless, in respect of medical expenses, unless the injury has given rise to a need, a reasonable need for medical treatment, then medical treatment will not be paid for.
Just continue.
Thank you.
I'm wary too of being invited to engage in a drafting process on the run.
Would it be fair to say though that this is just going to result in more litigation? Like these are more points then for someone to have to go to litigate these additional hurdles to sort of prove that they've got this psychological injury in the first place. How does...
That's the position that we have advanced in our written submission, and I believe that it's a sustainable submission. I mean, as I understand it also, there's some reservation amongst the medical practitioners as to how such a definition would be addressed.
How does this... There's been some suggestion that certain types of workers would be excluded as they currently are exempt from some of this scheme. So I understand, unfortunately my knowledge is patchy on what happened back in 2012, but I understand that there are exemptions provided for certain types of workers. It's unclear to me whether those exemptions will continue or not. I'm not sure if you picked it up from the draft, but to the extent they do continue in some form, how does that then interact when you've got a multi-contributor claim? You've got different WPIs, for instance, for different employers or different, for someone who's had multiple roles, with someone, in one exempt role and one non-exempt role. And then you've got this multi-contributor claim. Has that been something that you've thought through at all?
Yeah.
Mr. Roger, yeah, thank you.
So this is something that causes great confusion for everyone. We're running multiple different schemes in New South Wales for different workers. We've got coal miners as well. You're referring to emergency service workers. We're creating different classes of workers with different classes of rights. It's challenging, it's complex, and I don't know how an injured worker can easily navigate what they're entitled to if it requires, navigation of complex legislation.
So, for instance, if you were an RFS worker, which I understand is not exempt, but you're doing that on a voluntary basis, but then you were also you were in the police and there was multiple, I guess, issues that led to your injury.
At the inequity of the situation, you can have the same rescue scene, let's say, and certain people will be subject to the restrictions of this Act. Those who aren't paramedics but might be associated with the rescue performance, nurses and the like, yet some will be subject to this legislation and some will be exempted from what we understand, although I didn't see anything in this draft to confirm that those exempted under the 2012 amendments are also exempted here. The police, the paramedics and firefighters are the most obvious, and coal miners have always been exempted since 1987.
Right. Just in the time that I've got left, there's been some sort of assertions, I guess, and it comes back to what I was saying about the additional litigation if we've got lots of different hurdles. There's been assertions that will lead to effectively a cost shifting from the scheme onto individuals, particularly businesses having to then bear the cost of defending themselves in front of the bullying harassment jurisdiction or whatever. Do you have a view? Sorry, this is a bit of an ill-formed question, but as lawyers, what will happen when we lose a lot of that backing, that sort of background precedent for the existing scheme and move to a whole set of new things? So I've asked two questions really there. The impact of that litigation risk on individuals falling outside the system because of these changes, but then also the change away from established precedent around definitions, etc., into something else. What's the impact in terms of cost?
Those within that are forced to mount their argument initially in the Industrial Relations Commission will probably not see a workers' compensation lawyer at all in many instances, which is a real concern because the area is a distinct area of practice from industrial relations in my experience, and these people will just be trying to navigate a system without appropriate legal advice, and that's a real concern, quite apart from the health risk associated with the fact that they're going to remain untreated for at least 6 months whilst their industrial relations dispute is determined by the Commission.
Thank you very much. I pass to the Honourable Supervisor.
Thanks, Chair, and thanks to all the witnesses for coming along. It's much appreciated. Maybe a question for the Law Society reps. Firstly, in terms of this new jurisdiction in the IRC to determine bullying and certain types of harassment complaints, could you give us a sense of how an average worker would navigate that process in terms of what sort of applications and paperwork would they have to do if they were to retain a lawyer? How much would it cost them? And it's obviously going to depend on the type of claim, but as a sort of approximate starting point, could you give us a sense?
That's really challenging to answer when we haven't seen the bill that goes along with those provisions. There's so much we don't know about what we can expect in our jurisdiction. We don't know whether there'll be representation. We don't know whether evidence will be given orally or on the papers. We don't know whether there'll be a right of cross-examination. We don't know whether people who are accusing someone of racially harassing them will be cross-examined by the same person. We don't know whether, if a worker is accusing their employer of sexually harassing them, whether they can be cross-examined by the same person. The legal process is complex, and the emotional toll is going to be, even another layer for the injured worker. It's going to be extremely difficult.
I think it'd be fair to say, though, that we practice in the work, as I said in the answer to the last question, I think you'll generally find that workers' compensation practitioners are different from employment law practitioners. So I don't think either myself or Shane has a lot of experience in the Industrial Relations Commission. There are practitioners on my committee, though, that do have some experience of such matters. We can take that question on notice and see what we can do to find out a more accurate answer to the question you've posed, if that's acceptable too.
Oh, sure, yeah. I mean, if you were talking about a discrimination tribunal type action, which I think is one of those tribunals that is meant to operate informally to some degree, you'd certainly be talking about written applications, you'd be talking about cross-examination of witnesses, wouldn't you, in order to substantiate that sort of claim, which has a degree of seriousness to it?
My limited understanding is that I think you're dealing with two organisations, the Equal Opportunities Tribunal in New South Wales and the Human Rights Commission in the Commonwealth area. As I understand it, most of them are, in a majority of cases, they exclude legal involvement, but they can be lawyers with leave. So, other than that, I must say I'd have to defer to those on my committee with a bit more experience of such matters. So.
Sure. I might.
I'm sorry.
Yeah, I might just ask Mr. Toomey a question. We had some evidence from the Treasurer this morning to the effect that the workers' compensation system was designed for physical injuries and that it's obviously now being used for psychological injuries. And he said that, in summary, he said that there are quite complex questions in terms of assessing psychological injuries, but particularly assessing their connection to work as opposed to, I suppose, contributions by virtue of the person's inherent makeup or other problems that they might have outside of the workforce. And I think it could be said that the bill, and particularly Section 8E and the meaning of relevant event, is an attempt to sort of engage with that by excluding certain people from the scheme. And I'm just wondering if you've got any thoughts about alternatives. So maybe trying to accept the premise that there is a certain type of crisis in the scheme, accepting the premise that some form of limitation might be needed to address that. Is there a way to address it that is more fair than the exposure draft? I mean, for example, might there be issues with the standard of proof? Is that something that could be looked at? Is there maybe a case to limit payments overall in psychological cases as opposed to other cases? Is there some other way apart from wholesale excluding access to the scheme, I suppose is my question.
What immediately springs to mind is that there could be further expansion on what constitutes bullying. It has to be accepted that in workplaces around the state that there are undoubtedly tense interpersonal relationships between workers and employers, etc. I think that those claims could be further confined by proper definition. That's what immediately springs to mind. I don't have all the statistics available to me, but going from the 23-24 annual report from iCare, in respect of the claims that fall to be indemnified by the nominal insurer, it is said in that report that the drivers for psychological claims are 70% in respect of harassment and work pressure. So that is one obvious point where further definition could achieve confinement in the scheme if it be necessary. I would like to take the question on notice if it's of any assistance to you, because it's an interesting question and one which we perhaps ought to have foreseen.
And in terms of standard of proof, do you think there's an issue here in the sense that the scheme depends on doctors and psychologists, obviously, to render opinions? They're normally people that have a therapeutic role. Do you think that the fact that they've normally got a therapeutic role means they're not perhaps ideally equipped in terms of objective assessments, that they might tend to favour, I suppose, the patient in some sense? And is that a dynamic that can be addressed through legislation, do you think?
Yeah. I might defer to Mr. Bowen.
And I accept they've all got professional obligations.
Yes.
I assume they sign certificates and they do certain things in codes of conduct and whatnot, but I just wonder, is there not an inherent tension there between those two roles, and is that something that legislation can engage with?
Well, speaking from my experience, and I've been involved for 20 plus years, I haven't really encountered that. There may be an impression that a particular doctor might be seen as more favourable one way or the other, worker, employer, but it is a fairly independent process. All the assessors have to be appointed effectively by CIRA. So I don't get the impression, and having acted on both sides of the equation, that is a particular problem, that there's a sort of a bedside manner, if you will, that is coming into play. So I think the system as it is robust in that sense of the independence of the medical opinions that are being deployed into these disputes. That would be my experience, but and as you touched upon, they are bound by their own professional obligations of independence, and so I don't see that as a major issue.
And I should add that in the case of, as has been touched on by Mr. Bowen, in the case of disputes, for example, about whole person impairment, there is provision for the referral to a panel, which is appointed by the Commission.
Yeah. Certainly, thank you.
On that note, I'll need to draw this session to a conclusion. Can I thank you all very much for coming along today at what is relatively short notice. The Law and Justice Standing Committee has always appreciated enormously submissions and oral evidence from the two peak law bodies in the state. It's always been important for us to have that high level of professional and detailed legal knowledge brought before any inquiry, and certainly this is an important inquiry. So can I thank you, both organisations, very much. With respect to some questions that have been taken on notice, the turnaround time is relatively quick. It's 5 p.m. close of business next Wednesday, which is the 21st. So that's a little bit tight, but hopefully you'll be able to make it. And once again, on behalf of the committee, thank you all very much.
Thank you.
We now move to our next set of witnesses. as people settle in, we'll get things underway. A very important panel, a panel made up of actually 7 individuals with great expertise and experience in the area from a legal point of view. So we'll just go through the formality, which is the swearing and affirming of all witnesses. I'd just like to draw everyone's attention that one of our witnesses, Mr. David Jones, joins us by video conference, particularly for committee members who may wish to address any question to him. So welcome, Mr. Jones. So in terms of the order of the swearing or affirming, perhaps if we start on my left and work across one after the other, and then we'll go to Mr. Jones. We ask that you identify your full name, position, title and the organisation you join us from, and then take either the oath or affirmation, whichever you choose, the words of which are before you. So we'll start.
Thank you. Ivan Simic, partner with Taylor and Scott Lawyers. I take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Simic.
Michelle Megan, solicitor at Taylor and Scott Lawyers. I take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Ms. Megan. Moving on.
Scott Dougal, partner at Carroll & Day Lawyers. I'll take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you.
Romina Dimitri, Head of Work and Road Claims, Slater and Gordon. I take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much.
Larissa Atkinson, Legal Counsel, Slater and Gordon Lawyers.
Thank you.
I'm taking the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much.
Rita Youssef, member of the Australian Lawyers Alliance New South Wales Workers' Compensation Subcommittee. I take the affirmation.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Mr. Jones.
Via AVL, David Jones, solicitor, partner from Carroll & Day Lawyers. I take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you, Mr. Jones. Now, what I'm about to say is in your own hands, but we put it to what was a group of witnesses this morning in terms of the possibility, and it's a matter for yourselves, that with respect to your opening statements, and I expect each organisation represented, at least maybe each person here represented giving evidence will have an opening statement, that one way of proceeding is that if everyone makes their opening statement, that's going to significantly depreciate the amount of time left for our members to ask questions. But if you're prepared to do so, that in fact if you provided us with your opening statements, they'll be tabled and incorporated as evidence to the inquiry. Now, if anyone particularly wants to make an opening statement, I'm obviously not pressuring you otherwise, but it would expedite the next session and enable a maximum amount of time for questioning, which may be of particular value to members. So I'll pause there. Sorry that there was no notice about that consideration I'm about just raised with you, but would there be any objection to that course of action I've just described?
No objection.
No, well, very grateful for that. So the committee secretariat will organise to collect your opening statements, and we'd like also, if you could, when back in your offices, to have them emailed as well. So on that basis, in expediting that, can I just say that the submissions have been received, processed, and those that have made them and others may be on the way, stand obviously as evidence inquiry, and we're grateful for that, and this is obviously an opportunity to provide some oral evidence and some additional evidence, so thank you very much. So perhaps on that basis, if we pass to the Honourable Damon Chudhope.
Thank you. I take it you're all in the room while the Bar Association and the Law Society were giving their evidence. Does anyone at the table quibble with any of the submissions made by the Bar Association or the Law Society? There was silence, no.
Perhaps on one point.
Yep.
With respect to Section 11A, I can understand the rationale behind those amendments to some extent. but I think it's otiose. There's no practical benefit to that provision at all. Section 8, capital E1, defines what is a claimable circumstance, and that does not include action by management. So on that basis, there's no reason to have a defence that the management action was reasonable if you cannot even bring a claim for a management action. So that section is now almost meaningless. That's the only comment I'd make with respect to that.
So, just in summary of that position, your position is that 11A, as it currently stands, is perfectly well functioning, and in fact, the amendment doesn't add or subtract anything from the additional from the current position which is adopted by the section.
Not quite, no. I would concede that the current provision may benefit from some modification. My point is that if this new Section 8E is the law, and that precludes you making a claim because of management action, then there is no need to have a defence that the management action was reasonable, because there just isn't a claim made for management action. It's not available under Section 8E.
Can I put this to you? Does anyone have any cases where the WPI is more than 30%?
No.
No, not in my over 25 years experience.
Yes.
Never.
So effectively...
I've had one member, yeah.
So effectively, in your experience, if collectively on the table, the provision adopted by this new scheme would be to eliminate just about every claim for psychological injury.
Correct.
Yes, in fact, one of my main concerns is that it pretends to make a carve out for people that have been involved with serious trauma, first responders and things like that. Say a train driver who has the bad luck to have somebody throw themselves in front of the tracks, they're going to be excluded from, it's just going to be excluded from the Act.
And if it was, say, 20% or 21%, what then? How many is the current level? If it was to be increased from 15% to 21%, what impact would that have on your
It would still exclude
practices?
a high number of claims. It would still exclude a high number of claims because the majority of the claims do fall within 15 to 20%. Sorry, it would exclude a number of claims. A high number of claims do fall within 15 to 20%.
So there is a number of also under the proposed scheme. There is a definition or a number of listed relevant events. Do you have any observations in relation to the manner in which the draft or the bill, exposure bill, seeks to define relevant events?
I certainly do. I think what's most notable about Section 8E1 is just how much is excluded.
This is Mr. Simick's point, I assume.
Yeah, and look, that involves any number of forms of discrimination, which could be based on gender, age, disability, family responsibilities, pregnancy, breastfeeding. It would exclude any adverse comment or act to make someone uncomfortable with respect to their competence, their intelligence, their appearance, their education, their command of English, their political and social views would all be excluded from categories where you could make a claim. And I think the majority of what's excluded would be inconsistent with most employers' codes of conduct, and it's certainly inconsistent with federal and state laws with respect to discrimination. So there's a whole range of categories that would be discrimination that do not give you a right to make a claim under this proposed section.
Does anyone else want to comment in relation to relevant events?
It also excludes examples like overwork, nurses, teachers, doctors, they'd be excluded. and events that are not quite violence or criminal conduct, but are still abuse that lead to psychological injury, as well as instances, say for example, retail workers suffering abuse day in, day out. That's not necessarily violence or criminal conduct, and they'd be excluded.
There appears to be amongst a lot of the witnesses that we've heard from, including the union movement, there is a necessity to amend or to have some sort of re-look at the manner in which workers' compensation works in relation to psychological injury. If you were doing this and you were in the government shoes, what would you be doing in relation to psychological injury? Because what the Treasurer argues is that psychological injuries are making the scheme unworkable. Is that your experience, or what would you be saying in terms of giving advice in respect of what the government should be doing to fix this scheme, if it needs fixing, or is it your view that it doesn't need fixing?
Look, I'm happy to answer that if no one else does. I think there is scope to certainly make some changes. I think there's a concept of provisional liability, which is a claim being accepted without any real rigour or process to investigate the merits of that claim. And that can cover an injured worker for up to 13 weeks. And it may well be that for a psychological injury, that's too long. That period is too long. It would be nice if there was a mechanism, and this might involve the IRC or another tribunal, where if there is an issue of bullying or harassment, there's a fast track to somehow get that issue to be fundamentally addressed, so that the root problem and the root cause of that circumstance leading to injury can be addressed. That to me would be a proactive way to get people back to work quicker, to reduce any incentive to remain on workers' compensation for a longer period of time, and to fix the underlying cause of the injury.
But it could have a adverse consequence that if in fact you potentially fix the problem, you may still have an injured worker who has no further entitlement to compensation.
Look, that's certainly possible, but I don't mean to change topic on you. When you have a definition of bullying, which requires there to be a significant injury, it means that if someone is unwell and would actually benefit from treatment and the opportunity to resolve the underlying concern with the employer, if they don't have a basis to bring a claim, they've effectively got to wait until they break down and it becomes significant before either their health or the cause of the injury is dealt with. So I'm all for early intervention, but it needs, I think, a two-pronged approach. It can't just be a stick to take away people's entitlements. There needs to be some mechanism to allow the fundamental underlying cause of the injury to be addressed.
Can I ask you, I think, I can't potentially read that, but the solicitor from Slater and Gordon, in your submission you state that access to common law damages serves as a broader public purpose and holds negligent employers accountable and incentivises safer work practices. Raising the threshold to 31% would severely undermine this deterrent, removing any real consequence for employer negligence in the majority of psychological injury cases. Do you want to expand on that?
I do, because I want to differentiate the no-fault scheme, where people are lodging psychological claims, from the 15% work injury damages threshold that allows people to bring common law claims in negligence. And that's a distinction that's not currently made in this exposure draft. So the traditional person is injured, they claim bullying and harassment, they will lodge a claim, provisional liability will be accepted, and then they either return to work in a gradual way, or they access their medical entitlements, they get better, and it's all over. The claim is closed. Not all of your people accessing the no-fault scheme will actually move on to be assessed at 15% or over. Those are the people that potentially would have common law claims in negligence against their employer, and there are two gateways to open that. First is a percentage of 15% whole person impairment, and that's a medical diagnosis. And then there is an assessment of the facts and circumstances that have actually given rise to the bullying, harassment, or the incident, either the frank incident or the nature and conditions that have actually culminated in that injury. So there are sufficient safeguards in the existing legislation, and the differentiation between no fault, statutory benefits, which are access to your medicals for psychological treatment, focus on a return to work strategy, and then on top of that, weekly benefits while a person is incapacitated and receiving medical certificates, is to be distinguished from a common law claim where someone achieves 15%. And we say that that's quite a high bar as is. Not all people will have that, and even if they do get assessed at 15%, the facts and circumstances aren't necessarily negligent. So they're not culminating in those common law claims.
I just want to, lastly, in this process, just touch on the process which we're asking bullying complaints to be handled by getting a certificate from the Industrial Relations Commission. You heard the Law Society give evidence that they have a lot of concerns in relation to how that would work. Do you have any observations in relation to, or do you have any concerns about requiring workers to obtain a certificate before they're entitled to lodge a claim for workers' compensation in relation to bullying, harassment claims?
I've got one further comment, and that is that depending on which tribunal you go to, there is the risk of an adverse costs order against you.
Yep.
And there's also the risk that...
That's presuming it's a cost jurisdiction.
Correct, but some of them are. And that would depend which tribunal we're talking about. There's also the risk that that there's a finding that the behaviour was obscene, inappropriate, but it didn't meet the bullying definition. And so that person's left without any remedy at all.
I'd just like to make a few comments about that. The Industrial Relations Court of New South Wales has only been recently reinvigorated. We're being put in the ridiculous situation to try to do law reform, and we haven't even seen what the other major act is, that is the amendments to the Industrial Relations Act. Having a bit of experience in that jurisdiction, no lawyer's going to go down there for nothing. The work will have to pay for it. It will be not an inexpensive process. It will cost some substantial money unless they have the backing of a union who's willing to fund it to get that finding. It's actually it's such a high benchmark. It's almost ridiculous. In our submission there's a good example of a young shop assistant from country New South Wales, and what her experience was under the present system. If you can imagine these new laws applying to her situation, it's case study A, you'll just see that it's just ridiculous, particularly for people that have suffered severe harassment or acts of violence in the workplace.
Can I just, before I pass to the Deputy Chair, just that Mr Jones had his hand up, so I think, would it be okay to allow him? Mr Jones, to you.
One further point in relation to that, and that is this, is that if people have to go off to another jurisdiction to get their certificate, that very process of delay can delay their recovery, and it may well, as a consequence of that delay, cause the condition to be worsened such that there won't be a reasonable return to work outcome. The other thing is this, is that many people who are affected by psychological injury will find this process overwhelming, and the thought of having to go somewhere else for the purpose of getting a certificate for the purpose of accessing benefits will be so overwhelming that they won't even go through that process. That's my additional comment.
Thank you, Mr Jones. We'll go to the Deputy Chair and then to the Honourable Mark Latham.
Thank you, Chair, and thank you to all of you for coming along this afternoon. I just want to pick up on a couple of points that have already been mentioned. So in relation to this section 11A expansion, it's my read that it's still possible for that to come into play, even though it's not included in relevant events. So if you have, for instance, an injury caused by one of those relevant events that is not a reasonable management action, but then the reasonable management action was a significant but not the main or predominant cause of the overall injury, you could still get excluded because of that 11A defence. Is that your understanding as well?
Yeah, that's correct.
Yeah. So
if there was an act of violence between two workers and they both stood down, there could be a contest as to what's causing the incapacity, what's causing the injury. Was it the management action or the act of violence? So it would have some application in that kind of situation.
Could you also have a situation, for instance, where somebody had suffered, it seems difficult to meet the definition of vicarious trauma at the moment, but just imagine they had suffered some sort of vicariously traumatic event, but then the management actions had also exacerbated that. So, for instance, by not allowing time off, or by not allowing time to debrief, or not having, policies in place to allow vicarious trauma debriefing, whatever it happens to be. Can you, I guess, imagine a case where this reasonable management action was then part of the picture and could be seen as significant?
I think that's a good example. I think that's where it would have some application, yes.
On the 30%, we talked before about, I think it's actually 31%, isn't it? It's more than 30. About the fact that, that would knock out a huge number of people, not from the scheme as a whole, but from certain aspects of the scheme. So we're talking here about going from 5 years to 2.5 years before you're effectively chucked off the scheme, or getting a lump payment at that 31%. In your experience, what would be the impact on people who were currently, say, above 15%, but not meeting that 31%, who get chucked off? Would that, in your experience, would that cover a significant number of people at a 2.5 year mark? Has anyone got anything to say about what the impacts will be?
It would effectively mean that there is a large group of people who are without benefits, because to meet even the 15% threshold, we've effectively usually got a worker who has never returned to work. So we can't even often get workers assessed because they don't meet the criteria to be medically stable to be assessed within 2.5 years. It's most often the case that it is coming up on the 5 years mark, or perhaps beyond that, before we can even establish that we can have the assessment performed, let alone resolve any dispute that arises about the percentage, and have that confirmed so that the worker can then access the benefits that come along with being over 20%, which is the payments past 5 years. So when we increase the threshold further, that means we will have people who have to wait longer because they will need to reach a higher threshold to even have a chance of getting there, which means they're going to have to solidify the level of their dysfunction before they can even make an application.
So I've met people who say that they were assessed at about a 22% or 24% WPI when they were effectively suicidal. If you got chucked off at that 2.5 year mark, and then that lack of support leads you to, for example, lose your house, have family breakdown, whatever it happens to be, and you then get worse and get over the 31% at a separate diagnosis, do you get to go back on the scheme?
You've raised a very good question there. This proposed legislation has got some absolutely draconian provisions that affect not just people with psychiatric claims, but people with serious physical injuries. Like Section 39, it's actually going to prevent people, if you had let's just talk about a really serious physical injury, somebody with severe burns. Let's forget about the psych just for a moment. You may actually have to go through a long process of medical treatment, multiple medical procedures, possibly going over 5 years. Your condition may not be able to be assessed for a long time in terms of WPI, whatever that means.
Yeah.
And that person will get kicked off the scheme. And then later on they may get assessed at 21% or 30%, but they won't be allowed to get their arrears of weekly compensation whilst they're being kicked off. That's extraordinary, and that's just for all injuries. The Act is actually, these draft proposals are actually quite, there's almost a sleight of hand, some of the stuff that's been put in there. If you go to section 153N, again, this affects people with physical injuries as well. And you may have a young apprentice, he's lost part of his toe, part of his foot, he doesn't get over 15%, he makes his best effort to get back to work. Medicine is complicated. I don't pretend to understand it, but and this legislation certainly is bereft of any understanding of the human condition or medicine. But he or she may have further medical treatment, and eventually they'll get over that threshold. But 153N says, look, it's not enough just to get over 15%. You've got to get another 20 extra %. And I don't know whether the government's. It's embarrassing. I don't know whether the government's thought about this. It's embarrassing. This is not just psychiatric injuries, it's going to affect physical injuries as well. And not only just, I mean, really, people with severe injuries from the worst sort of trauma you can think of. It's extraordinary.
Thank you. Honourable Mark Latham.
Thank you, Chair, and thank you to the panel for your attendance and input today. If I could come to the two Slater and Gordon representatives, Mrs. Dimitri and Ms. Atkinson. Your submission takes particular objection to the new clause 8A, meaning of psychological injury, and goes to what does appear to be an omission in the new exposure draft, and that is significant is left undefined. Is it that hard to define the meaning of significant in the context of significant behavioural, cognitive or psychological dysfunction, and what would you suggest?
It will be difficult to define what that is. It will take many litigated claims to decide what that is. It's not currently, as I understand matters, and once again I echo the submissions made on behalf of the Law Society and the Bar Association, that we haven't had enough time to go through and find if there is a source for this particular wording. But the definitions of what a psychiatric injury are well established and have been so since the early 90s. They've been tested many, many times. All of the practitioners practicing in the area, the independent medical experts, the decision makers across what is a psychiatric injury and what is not. I echo the submission made by Mr. Toomey SC in saying that changing the definition adds nothing. It won't change anything about what is a successful claim is what is an unsuccessful claim. It's simply adding extra administrative cost and appears to ask for a higher threshold to be achieved than is presently in circumstances where we, in our experience, can't see that there is a problem with things that are not injuries that are something less than a psychiatric injury getting through as successful claims.
Right. Hasn't the definition of psychological injury evolved, particularly in recent times? I looked at this a while back, and I think it's factual to say that the term anxiety depression in Australia was first invented by Jeff Kennett, a former politician, as the head of Beyond Blue, and the rise of these sort of quasi-medical outfits in the mental health space has been striking. And but once invented and used by the head of Beyond Blue, it becomes embedded in the various sectors and industries that, well, for want of a better term, can make money out of it. So it has evolved pretty quickly, hasn't it, into areas that weren't necessarily based in medical science.
If I could provide some comment to that, ultimately a psychological injury is a medical diagnosis. We have diagnostic criteria that's utilised by experts to assess whether a claimant is psychiatrically impaired. And so I feel like these changes actually add a legal definition to something that is quite well established in a medical sense. If we're asking a clinician to make a diagnosis of medical injury, and you know, psychiatric in this sense or physical, why are we trying to interpret that in a legal sense?
Well, we've heard evidence that these clinicians aren't necessarily genuine. There's a lot of fraud out there, and quite frankly, it's no secret in the suburbs you can find a whole range of doctors who'll tell you that you're mentally ill and get you off work. So this is what the Parliament is grappling with. But can I come to for the whole panel, can I come to a...
Do you want to agree with that or not?
No, I can't comment on that, and I suppose the medical experts can unravel that.
Well, the Treasurer probably is onto it, but anyway, the bill, the exposure draft deals in large part with the changing nature of definitions around mental health. But should it also be dealing with the changing nature of work itself? What's your experience with the rise and what looks like the permanent rise now of work from home and claims to that effect? Because doesn't that change the whole question of the basis of evidence about an injury? You guys getting experience? You must be getting work from home claims. The Treasurer said, you know, if someone cuts themselves, it's a physical injury, everyone knows the evidence for that. Well, how do we know they cut themselves in the kitchen or they cut themselves in the exercise of work from home? Is this becoming an issue? No? No work from home claims have come through? No. Any of your practices?
No.
That's pretty good. How do we convert that to the real workplace? Then we wouldn't be here. Okay. Are there any other, Slater and Gordon, are there any other definitional issues that you've got problems with? I mean, contentious 8E, meaning of relevant event. In the Mother Act, are there clear definitions about the meaning of threat of violence? Because it seems to me that can be across a whole spectrum of possibility. A big difference between saying to a work mate, I'd wring your neck over that, compared to, mate, I want to kill you. So have we got an established definition about threat of violence? Because it's used in 8E, but then for some reason it drops out under vicarious trauma, 8H. It's not a factor at all.
I haven't looked at that in detail, and I have to take that on notice, yeah.
Do you get cases where people have been traumatised by a threat of violence? How's it currently defined?
We need to establish they've had an injury.
Right, yeah, but it's a psychological injury. If someone threatened you.
And then that comes back to a medical assessment.
Right.
And that would also require to be in the course of their employment. So
yeah, sure. But okay. Right. Okay, I'll take that up with the Treasurer on notice. Thank you, Chair.
Thank you. Just before we pass on, Mr. Jones, I'm sorry, you did have your hand up probably now about 10 minutes ago. And it's my fault, I didn't see that raised. Yeah. You may well have even forgotten by now, and this is no fault of you, forget what in fact you were going to speak to. But if you do recall, can I invite you to speak? If not, I apologise for not identifying you quickly enough.
Chairman, I don't recall why
I do apologise.
I think he forgot to take it.
That's okay, but just in relation to the member's comment in respect of doctor shopping and fraud, is that there are within this scheme already processes and procedures which deal with fraud, and people can be subject to criminal charges and sanctions in respect of that. And where a case is considered not to be legitimate, an insurer can take action to investigate a claim and then put on a notice to discontinue benefits. Actually, now, so just in relation to that, I now recall what I was going to talk about, where the previous member talked about being chucked off benefits after 2.5 years and the effect of that, and in particular by reference to the increasing of the threshold. The scheme as it currently stands is if you were assessed between 0 and 10% permanent impairment, you are entitled to medical treatment expenses for 2 years from when your weekly payments cease. If you are between 11 and 20%, you have 5 years of medical treatment from when your weekly payments cease. And if you're 21% and above, you have medical treatment expenses for life, provided they're reasonably necessary. Well, I think all of my colleagues will tell you that in the case of psychological injuries, we see medical treatment extending well beyond 3.5 years from the date of injury. So what is proposed will have a significant impact upon the injured worker.
Thank you very much. I'm glad I did circle back. That was very evident. Thank you, Mr. Jones. Now we go to government now.
Oh, it's government turn.
Just before you proceed, just conscious of time, we're scheduled to finish at 2:45 for these witnesses, but I don't want to crimp time, which means there could be crimping of afternoon tea, which is an issue for us. So we'll just proceed with time and wipe government. Proceed with government questions and wipe afternoon tea. So people happy with that? Yep. Okay. Proceed.
Okay, I'd like to ask about the proposed Part 6, which relates to a change in the mechanism for assessing permanent impairment. I wonder if there's anyone who has some comments on whether that's a positive change or a negative change, and what the implications might be in relation to CIRA appointing permanent impairment assessors.
Which page is that, sorry?
Of the draft bill, page 21.
Oh, thank you.
Part 6, determination of degree of permanent impairment.
Just to confirm, Honourable, that that's the exposure draft document?
Yeah.
Yep. Thank you.
My friend Ivan did talk about section 153N and the requirement for a further 20% for a further principal assessment. That seems to be an excessively high threshold. I would have thought the more logical principle would be that if your additional impairment is going to see you reach a higher threshold, for example, if you went from 18% to 21%, that's significant. Whether it's only 3% or not, it's a significant improvement to your rights. But the idea of a further 20% is that's very unlikely that anyone's ever going to be able to do that.
I think Mr. Jones, is it?
Mr. Jones, would you like to respond to that?
Just in relation to the regulator having involvement in respect of the assessment of permanent impairment, it's not something that the regulator should involve itself in. There is already a process and procedure for the determination of permanent impairment to take place. That is, a worker can obtain their assessment, make a claim, the insurer can respond to their claim by obtaining their own assessment, and if there continues to be a dispute, there's a mechanism within the Personal Injury Commission that an independent medical assessor can go on and assess impairment, and that impairment can then be the subject of a medical assessment certificate, and there are appeal rights which arise as a consequence of the issue of the certificate. So this is an unnecessary duplication. It's likely that some workers may not be legally represented, won't know what matters are to be assessed. The items to be assessed may not be agreed upon between the parties. So it's a furphy for this process to be introduced within the Act.
Okay. I had a question about an observation that's made in the CFMEU submission around potential constitutional issues associated with the proposal for, just trying to find the section, the work stress payments, I think they're called. Let me just find the section.
I can indicate that I haven't had the benefit of reading that submission, but I assume that it says that fair work, certain jurisdiction.
Yeah, sorry, I'll let you finish.
Please proceed.
I would assume it says that fair work has certain jurisdiction in respect of New South Wales workers for some of the things that are expected to be the subject of certificates before they'll be entitled to benefits. But as I say, I haven't had the benefit of reading the submission.
The contention is that this is effectively an impost employer outside the insurance scheme, and therefore it's potentially an industrial question, and therefore affected by the Cover the Field provisions of the Fair Work Act. and therefore would be excluded. So there may be I wonder whether you've got any observations about this schema that's being proposed around work pressure that effectively places an obligation on employers outside of the system of the insurance question.
Issue.
Yeah, it's a jurisdiction.
We've only had a very short time to consider these reforms, but I can certainly see this being a very fertile ground for litigation because, as you know, most people are actually covered by federal legislation in New South Wales. So how this is going to work with the New South Wales Industrial Court, I'm not sure. But it's a very a good and valid point that's been raised by the CFMEU. It's going to be a fertile ground of litigation, and you could be waiting for a finding for a long, long time.
Find yourself in the High Court, mate.
Steve,
I've got a couple, yeah. Just a question for Mr. Dougal, if I could. We've had some things drawn to our attention this morning in relation to the definition of relevant event in proposed section 8E and the fact that it requires a worker to have witnessed an incident that leads to death or serious injury. And we've had witnesses talk about people that might, for example, deal with the aftermath of a road tragedy, be involved in removing corpses, perhaps on multiple occasions, and they wouldn't have witnessed an incident, even though they've obviously been exposed to trauma. I'm just curious, do you see any anomaly between that restriction in section 8E and the vicarious trauma provisions that follow in 8G?
To answer the first part of your question, I think if you don't witness it, if you see the aftermath, I don't think you're covered by 8.1.
Sorry, you're covered by what?
If you don't witness the incident itself,
8I.
I don't think you're covered by 8E1.
Oh, 8E1.
C. I don't think you're
C1,
covered by
yeah.
that. So there was reference before to a train accident. A train driver might feel a bump. He's not sure what it is. He stops. It's a dead animal or potentially a dead person. He hasn't witnessed that. He's dealing with the aftermath.
The aftermath.
As is the cleaner. So I don't think they're covered by. That would be my view, that they're not covered by that section.
So I was curious how you think that sits then with 8H, which seems to recognise liability when something happens to a work colleague and you hear about it, so therefore you experience vicarious trauma.
Yeah.
I mean, it's obviously different issues, but I mean, do you see that on a policy basis as anomalous, that one would be recognised and the other wouldn't?
I think so. I mean, what sprung to mind was the death at the Bondi Junction shopping centre where there was a guard killed. And if a fellow guard had an adverse reaction to that event, but didn't actually know that person, would he have a close work connection? I don't know.
Yeah.
So again, it's coming back to you really either have to know the person for 8H or you have to have witnessed the event for 8E. And that leaves a very large grey area where people will have exposure to trauma but not be covered.
Yeah.
A real and substantial connection.
So my further question is quite a general one, but we've had evidence this morning that the workers' compensation system was designed for physical injury, and now it's obviously being applied to psychological injury and claims of psychological injury. Is there something about the system that is able to be reformed that is inapposite to psychological injury? Like, is there something about the nature of psychological injury and the fact that it's an internal thing by and large? Obviously, you can have objective evidence of stressors and so forth, but it's ultimately an internal assessment about what's going on inside someone. Is there something about the nature of it that means that the standard of proof we're applying, the procedures we're applying are not apposite, and we're basically opening the door for a class of claims that we keep hearing about? And we heard some evidence from the business
people this morning talking about people being subject to performance management or whatnot, putting in stress claims, and that's cost $500,000 so far to the system, etc., etc. Is there something inherent in this type of claim that we just haven't got the system right yet? And do you have any ideas about how to address that?
That specific example, sorry, go. That specific example you gave about management action, I think that's adequately covered in
By
11A.
AT and all that.
Correct.
Yeah.
There is so much jurisprudence about that and interpretation, and if anything, that could be tightened. But 11A, ultimately, the burden of proof is on the employer.
Yeah, 11A, yeah.
And so I don't know whether those reforms or those proposed reforms are so bad in that they do provide further clarity.
Yeah.
And perhaps that should be the focus, as well as return to work strategies. At the moment, though, there's really no data to say what the drivers of this reform are. Is it the people on statutory benefits for a long time who don't get to the 15%? Or is it people over 15%? Is it people in the 20% to 25% cohort? And I think absent that information, there's really nothing that we can say that will inform the government's position on what should be tweaked to fix this problem.
Yeah.
Just one further point. The idea that the scheme has to remain static and that it cannot evolve, I think does not serve workers in the 21st century. We've had dust diseases evolve and we were able to incorporate that. We've had skin cancers and hearing loss. These things evolved. To say it was just designed for physical injury and therefore everything else should be excluded seems overly simplistic.
Yeah, I wasn't suggesting that everything else should be excluded, but I was just, I suppose, just pondering, like, the path that the exposure draft takes is to limit certain classes from the scheme in order to deal with this explosion in claims, if you like, and the threat to the financial viability. But is there some other way of doing it, whether to reduce payments, to impose a higher standard of proof? Is there some other way to do it that might not arguably be so unfair in terms of just excluding categories of people?
We had the benefit of hearing from Mr. Toomey from the Bar Association in the previous session, and I thought he actually addressed this question very, very well. And I think it's worth revisiting that evidence. One of the problems with this whole law reform process is that really the lawyers haven't been consulted or asked how do we fix it, and we've just had this thrown at us at very short notice. But I would encourage the committee to go back to the evidence of Mr. Toomey and some of the ideas he suggested there, how you might reform the area to address the issues you're concerned about.
Thank you.
And one point is
Please.
also, if the WPI percentage has to change, then we don't necessarily think it should change. If it has to, perhaps a consideration of 21%. And also coming back to the point about common law claims and the current percentage being at least 15%, if a person, especially with a psychological injury, it's been going on for years, if they can get to a point where they close a common law claim and they're out of the system, that can have instrumental impacts on their life and for the system and the employer. Arguably more so than someone who's suffering a physical injury only. You know, we see it day to day in our jobs, people who experience that kind of relief when their common law claim is done and they don't have to deal with the insurer anymore. They get a lump sum, they don't have to go back to the insurer for approvals of treatment or anything else. It does make a big difference to close off a claim. So that's part of why that percentage really needs a lot more consideration, and the 31% is just not adequate.
Can I jump?
Forgive
Forgive me. Mr. Jones, would you like to jump in? Because I believe you had your hand up first, so I think you want to make a contribution.
Thank you, Mr. Chairman. Just one comment in relation to amendment of the scheme. One of the issues will be how will it deal with existing claimants? The exposure draft provides no information as to how existing claimants are to be dealt with. The transitional provisions are silent. I did hear some evidence from the earlier part of the proceedings where there was questions in respect of first responders. First responders were exempted from the 2012 amendments and are subject currently to the 15% whole person impairment threshold. If those first responders are not exempted from these proposed amendments, you will simply not have police officers, ambulance officers, paramedics and firefighters in the state of New South Wales, because they won't be willing to go to work where they're subjected to a 31% impairment threshold and these types of reforms. So they're matters which will need to be considered in the drafting of any proposal to amend the scheme.
Thank you, Mr. Jones. Mr. McDougall, I think you may have had a final contribution you wanted to make.
Sorry, I won't take too long.
Would you like to make that now?
I think to answer the earlier question, I think the problem is that the rates of people getting back to work are falling away. The incentives aren't there for an employer to provide suitable duties. The model in place with REA providers is not working. Their costs are going up, and yet the rates of people getting back to work are going down. And that's not being considered in this process at all. And I think there's some significant savings to be made there.
Thank you. Sorry, I misspoke. I said McDougall, but Dougal, so I apologise.
Yeah.
Just before I conclude, just a point of clarification, and Damien, just going back to your first question, this is just a point of clarification. You put in your opening remarks, your opening question, I think a broad question to the panel about did any of them have anything to say, or did they, perhaps I think the words might have been, disagree with anything that was said by the two peak law bodies or thereabouts. Now, in the exchange, the only person who responded was Mr. Dougal, and then we moved on to another line of questioning. I just want to make it clear that I'm not sure whether silence means consent or not in that case, if you know what I mean. So are there any other parties to the table here, and indeed on the video conference, wanting to demur from what was the consensual position that was arrived at, subject to Mr. Dougal's comments, or do we take it as consent to the positions reflected in the two peak law bodies' contributions, both through submission and orally today? Mr. Jones.
I was in the waiting room for the last 15 minutes of the evidence, so I can't, without the benefit of viewing a transcript, I can't indicate if I agree or disagree with the propositions which were made.
That's a quite completely reasonable answer. So perhaps you might wish to take that on notice, and that might be the way of dealing with it. Well, on that note, sorry, anyone else wish to make a comment? If not, can I sincerely thank you on behalf of the committee for what's been a very quick and, dare I say, rapid response, if I could use that phrase, to what's now before us. Appreciate deeply the expertise and experience and insights that firms represented here today are able to bring to a very important, more than a discussion, serious debate about workers' compensation reform in the state. And thank you very much for that. That information through your submissions is very detailed and well supplemented by your contributions today. So on behalf of the committee, thank you very much. Some have taken some questions on notice. The return time and date for those is 5 o'clock next Wednesday for any questions that you may have taken on notice, and the committee secretariat will liaise with you if that's the case. So once again, thank you very much.
Thank you.
Thank you.
So we move now to our next panel of expert witnesses. Joining us at the table is Ms May and Mr Garling. Both I think are quite well known. Sorry, can't quite hear me. So thank you for coming along. With respect to the inquiry, just to inform you, your submissions have been received. Ms May, your submission stands as submission number 24 to the inquiry, been processed by the Secretariat, uploaded, and stands as obviously evidence for your submission to the inquiry. And Mr Garling, thank you for yours, same thing, processed, uploaded, and is submission number 28, and will obviously form written evidence to the inquiry. Now, before we proceed, we'll need to get you both respectively sworn or affirmed, whichever you wish to do so. First of all, if you could please give your name, title and or organisation you represent, or if you're here in your own capacity, please define that and say that's the case, and then take an oath or affirmation, whichever you would like to do, the words of which are before you. So we'll start with Mr Garling.
Thank you, Chair. Kim Garling, solicitor, appearing for myself, given a background for many years in this area. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Ms May.
Roshana May, lawyer, consultant, here in my own private capacity, with many years of experience in workers' compensation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. So I'll commence by offering each of the opportunity, if you wish to do so, to make an opening statement. Just bearing in mind that the longer your opening statement, the compression of the time for questions. So I'll leave it in your hands.
I don't have an opening statement. I might just mention that, having been cautioned by the office about my submission, I did suggest it might have been confidential. To the extent that I thought it should have been confidential, I don't need it to be confidential anymore.
And that's your position?
Yes, it was absolute caution. And
yep,
I can
abundant caution?
Yeah.
Thank you very much. Well, members who I believe would have a copy of Mr Garling's submission, it stands in now the form that he has said that he would like it to be in. So Ms May, did you have an opening statement you'd like to make?
I'd prefer to receive the questions.
No, indeed, I think the committee members want me to shut up and do just that, allow the questions to flow. So we'll start with the Honourable Damien Tudo.
Well, Mr Garling, you did make an opening statement. You had an article published in the Newcastle Herald, or the Sydney Morning Herald, yesterday. That in fact is an appraisal of what you perceive this exposure draft to encapsulate. Do you want to just go through what you observed in relation to that editorial piece that you wrote?
You're ahead of me. I haven't seen it, but I think I know the gist.
And I don't think it can be taken officially as an open statement to the...
No, I think I know the gist of it.
You're saying you wrote it?
I certainly played a large part in it. The essence of what I was saying there was that there were a large number of comments by various different commentators about the fact that the scheme protects workers. And I was trying to make the point that that's not the case. It never has been the case with workers' comp. Workers' comp protects the employer. And in the course of protecting the employer, there's a fund established to which the employer contributes, which pays the compensation to the worker arising out of a workplace injury. So we're not talking about protecting 4 million workers, we're talking about protecting some employers. And they're saving being sued at common law. And now they only have to contribute to a fund which picks up the liability they previously had. So it's a huge benefit for the employers. It's not necessarily for the workers. That was the gist of the first part of that article. The second part of that article was questioning the statements about financial sustainability. And they're difficult to convey in an article such as that. But that was my attempt to cover that area as best as I could.
So what do you say in relation to the sustainability of... We've heard a lot of evidence that this is an unsustainable scheme because of the blowout in relation to psychological injury claims, and this scheme, or the exposure draft, is an attempt to deal with non-physical injuries to the extent that they are now a major component of the manner in which both the TMF and the NI now need to deal with workers' compensation. And the corollary is that certainly in the NI, premiums are going to blow out to unaffordable levels.
Well, I find that those statements that have been made, and I'm not an actuary, rather startling, because in the iCare, as I think I've said in my submission, in the iCare annual report, it talks about claims increasing year on year, when the fact is they haven't. And there's been a lot of talk about explosion of claims, and the fact is they haven't. Simple answer is, we're talking in the NI scheme, an increase from 5% of the total to 7% of the total. So looking at individual claims numbers is helpful, but it's got to be seen in the context of the whole number of claims. So claims dropped significantly after the 2012 reforms, and I think they dropped probably by 25%, and they've slowly come back up, but so have the numbers of workers, so have the number of employers, so has the wages covered in the scheme. So one would expect it to have a different impact, but it's simply not correct, in my humble opinion, to say that there's been an explosion of claims, because the fact is there hasn't.
Well, but however, there is a difference in the nature of those claims, in that often, because it's a psychological claim, they're a lot harder to resolve. Would you accept that as a proposition?
I think the difficulty is that psychological injuries are difficult to manage medically, and for many of the employers present an issue which they're not capable of dealing with or understanding. So if you take a toxic workplace, and there are examples of those where the worker has an emotional, if I can use a neutral term, difficulty with returning to work, that is a real barrier to them coming back. But the 2012 amendments were supposed to deal with that. We've been through that extensively. The 2012 amendments said you either have capacity for work, and I think I made a famous statement back in 2012, which is going to haunt me, that you don't have capacity only if you're in a coma. Now, that was a bit of a stretch, but the fact is most people have capacity. So the next part is they're obliged to return to work or not get compensation. Now, we've dropped that practice or procedure, in my humble opinion, which would address a lot of the comments that have been made. The legislation's quite clear. It's a matter of process, in my humble opinion. But coming back to the claims issue, I'm talking only about psychological claims when I say it's 5% to 7% of the total. So there are 93% of payments and claims unrelated altogether to psychological injuries.
If I'm reading your position, you say that the current scheme is working perfectly well. It might not be perfect, but it is working well, and the amendments foreshadowed here, which in fact reduce claims and entitlements, are unnecessary within the current scheme.
Having been involved in looking at the workers' compensation system now since 1985, when I was closely involved in the 1985, 86 and 87 reforms by the then Ran Unsworth government, there can never be a position where a scheme such as this is in terrific shape. If you look, and I don't have the precise figures, but you look back at the Workers' Compensation Insurance Fund over the last 20 or 30 years, you'll find it's almost always been in deficit. And there's a good reason for that, because we don't want to overfund it, particularly. We want to keep it on a balance. So a slight deficit or a slight surplus is good. If it shifts either way, you'd want to think about it. But there are a large number of factors that affect that. And if I can add to that, I'm not sure I mentioned it, but if there's $16 billion in claims reserved at the moment, which is out of the last report, it's not payable in 1 year. It's payable over 20 or 30 years. And it's not really difficult in the next 5 or 6 years. And I challenge anyone who would have the wealth to take over that $16 billion worth of estimated claims, because they might end up being extremely wealthy at the end of the day. They're only guesstimates. I'm not being critical, but that's the only way the actuaries can do it. And they do it very skillfully, but it's over a long period. The philosophy is, do we fund everything up front with 100% plus, knowing that that will end up in a surplus down the track, or do we measure it according to current conditions and workplace conditions and costs? To look at it, $1,500 a year average premium is not excessive. That's what in the NI you pay, average of $1,500. I acknowledge there's all sorts of other
Well, they're more
mathematical
dangerous
issues,
industries.
but roughly, that's not a big impost. So I don't understand the urgency. I can see the argument that maybe in a year or 2 or 3 we might have to increase premiums. So maybe the test is to do a 3-year rolling valuation and view, rather than do it as at the 30th of June, 1 year. We're not an insurance scheme. This is a compensation scheme. It's totally different.
Can I take you to some specifics of the scheme? Now, there is a proposal to amend Section 11A in relation to the defence available to an employer in relation to various claims. Do you think that the current Section 11A is fit for purpose?
Well, I'd pose the question the other way. How does someone obtain or have a psychological injury as a result of being told that they're no longer working at work? I find that extraordinary, that someone would have a psychological injury as a result of that type of definition and that type of workplace incident. But however, on the current system they do. Under the new definition of psychological injury, they won't. So I see it as irrelevant at the moment, because to get through the gate, you've got to be seriously psychologically injured and to have all the evidence to support it, and then succeed in proving the case. Lawyers in practice often have to deal with pub tests. So the number of clients you have who come in and say, well, this is what my colleague did, and I was talking to him in the pub last night and he got $5 million worth of workers' compensation benefits. And you go, I don't think so. And when you actually look at the case, he lost the case. So with all the examples that we've been given, I would encourage each of those people that have suggested those to refer them to Jenny Aplin at iCare and ask her to investigate them as to whether they're true. Now, you might find a totally different story. That's not to say there aren't claims that go through that are unjustified. But you've also got to remember, in litigation, there are two sides. And the system we have ends up in a dispute resolution place called the Personal Injury Commission, where both sides go and argue their cases. One wins and one loses. Often the case is they both lose, because the person who was expecting the $5 million doesn't get it, and the person who was expecting to win didn't want to lose anyway. So you've got to balance those stories and just look at the fundamental principle. Workers' comp is there to compensate workers with an injury. Now, if you want to take out psychiatric injuries, that's a matter for the government. But it may be better to think about how we define the psychiatric injury a little bit more kindly than at the moment.
Can I just take you back to the previous observation you were making about the current viability of the scheme? The Premier has said that this is an insolvent scheme. The Treasurer this morning is saying he's not going to fund it anymore. if in fact we don't amend this legislation. What I'm hearing from you is what's the matrix that they use for saying it's insolvent, and probably that matrix is wrong if in fact that they are wanting to fund it of assets in excess of liabilities, because that's a wrong way of looking at the financial viability of the scheme. Is that a fair call?
I think, as I've mentioned, the scheme is not one scheme in the sense you're talking about of funding. It's two separate funds, completely different.
One's funded
not,
by premiums.
Not related. The NI is funded by business premiums. The TMF is a bit of a myth because the government is the defendant. And whether the TMF has enough funds is interesting, but the government has to have enough funds because they're the defendant.
Correct.
The fact that the TMF helps fund it is very wise, very sensible to put aside some money, but it's not the end of the story. So if the Treasurer doesn't want to put any more money into TMF, which is quite well funded at the moment, that's a matter for him. But if the claims go up, then the government's going to have to foot the bill anyway.
They're a self-insurer at the end of the day.
Self-insurer.
Can I just ask you one further issue in respect of a specific proposal? And I'm sorry I haven't got to you, Roshana.
Fine with me.
There is a proposal, in fact, to require claimants in relation to bullying and harassment claims to go through a process with the Industrial Relations Commission to get a certificate. Certainly in relation to the government, you expect those circumstances potentially where the government is defending a claim against itself from a claimant in its own workplace. Do you see an issue in relation to that?
The government's been a defendant in multiple cases for 100 years. I don't think the fact that they're a defendant is going to be a problem. How it works is something we're still to see. I observed yesterday 2 of my former colleagues were appointed as commissioners to the Industrial Court, presumably to deal with these, and I'm sure they'll be particularly clever and very capable.
Do you have any observations on that?
We just don't know.
Yeah. Well, we haven't seen a bill.
No.
No.
So we go to Crossbench. Forgive
Can
me,
I just add?
No.
Yeah.
Please.
You can add.
I just wanted to answer the question. I don't particularly see a problem with the IRC having a, whatever they want to call it, jurisdiction in relation to harassment and bullying, similar to the Fair Work provisions, Fair Work Act provisions, which seemingly apply to the private sector employers in New South Wales. Because I think that the government needs to be held to account for their own workplaces. And that's a simple observation. But tying it to workers' compensation is an irrelevant consideration.
The Honourable Mark Latham.
Chair, as we're falling behind time, I'll cede my time to help us out.
What's
I'll forfeit my 6 minutes.
Yeah. Is that agreeable?
Yeah, well, we're running out. We're behind time yet again.
I do understand that, but we are
As long as I
doing our
get my
very
full
best. So we'll go to thank you, the Honourable Mark Latham. We'll go to Deputy Chair.
Thank you. You're going to reset the clock though, right?
So please reset the clock for.
Thank you. Thanks very much. Every minute, every second is special. Hello. Good afternoon to both of you.
Thanks,
I'll start with you, Mr. Gulling. You have an incredible way of myth busting in what is a very complex area. But just to recap, from what I'm hearing you say, there is no great urgency when it comes to fixing the solvency or something else of the TMF or the NI. Is that correct? You don't see...
The TMF is the government, so
Yes.
there's no issue about solvency.
No, because it can't, because it's always going to be... It's
always going to be the government.
Effectively a
The
solvency
NI is not going to go broke tomorrow.
Okay.
But I don't oppose reform and working through some of these issues because I think everyone's concerned about how we deal with psychological claims, whether they're minor or major. And that's a really difficult issue that really needs some further inquiry. This committee's already looked at that sort of issue before, and maybe we need to refresh that and look at that
Agreed.
separately at all.
Agreed.
How do we treat it? How
But
do
it's
we deal
not
with
urgent.
it? And so on.
Yes, take the urgency out of it though. Yeah.
No reason to stop moving at all.
So when we come to the nominal insurer, if we are looking at psychological claims basically going from 5% of total claims to 7% of total claims, just imagine that this entire package of reforms goes through unamended and a huge number of these psychological claims get excluded. From what you were saying before about this being effectively the NI being a scheme that insures employers as opposed to employees, if there's no cover for an employer, does that mean that a worker could go to court then to claim against their employer to get some compensation?
It's an interesting question, and I'm told, probably by way more of gossip than anything else, that there are a number of barristers sharpening their pencils at the moment on that very point. One of the questions that needs to be considered is that the definition of injury is such that if you're not determined to have a psychological injury as defined, then you have no injury and you have no right to submit a notification to the insurer under the Workers' Compensation Act. If that be the case, then the question arises as to whether you then have full common law rights outside the scheme. But I'm not offering an opinion on that. I'm not qualified, but I do know there is some sharpening of pencils going on about whether that's possible.
So it's feasible to think then that even if there was to be some relief from premiums through these changes for a business, that you may then also be faced with needing to cover yourself somehow for liability that then arises from all the claims that are no longer under your workers' comp.
I think most significant employers, whether small or large, would already have management liability insurance. And there's a question of whether the employment practices section of that management liability policy would cover you. At the moment, most of those policies exclude bodily injury.
Yep.
But the question then arises as to what else they exclude.
So these reforms are then not only gutting compensation entitlements for workers, but potentially coverage for employers.
Correct. Possibly. I'm not expressing an opinion on
No, of course not. But yes, I think that answers it for me. Could I ask you, Ms. May, it's proposed that CIRA will have primary responsibility for appointing an assessor for WPI assessments. Can you see any difficulties with that proposal?
Yes.
Can you explain that
And
to
I
us?
think I think I've tried to explain it in my submission. If we go back to 2014, when the regulator was All Things to All People, Work Cover Authority, there was an inquiry of this committee that said that there were many conflicts of interest in them being the insurer, the judge, the jury and the executioner. So I think it was explained by some person. Opinions have been expressed since then and before then, even post-2015, that the regulator should regulate and have no part in claims management. I think that CIRA removing the ability of workers and insurers to obtain their own medical opinion as to the position of the worker's assessment or capacity or anything is very dangerous. I think that the process within CIRA would be costly, more costly than it is now, and there are impacts to, firstly, freedom of choice, access to justice, the ability to resolve matters which often happen between a worker and an insurer by a single assessment. I understand the purpose of potentially confining, trying to confine parties to one assessment, but I don't think this is the way to do it. I would prefer to keep the status quo.
And can you tell us what the impact of changing the reasonable necessary test to the reasonable and necessary test would mean?
It increases. The changes would mean that there has to be a greater level of necessity for treatment. So when we talk about the objectives of the system being prompt access to prompt treatment and early return to work, reasonably necessary means someone can front up and say that potentially with any injury, I might need some acupuncture or some medication or some form of treatment that will allow them either to remain at work, to prevent deterioration of their current condition so they can remain at work, or improve, or surgery, or anything else. The reasonable and necessary test requires both those limbs to be satisfied, which means there will be more challenges to the offers of treatment, and the principles behind reasonable and necessary will be lost. They were to facilitate effectively early return to work, and they are captured remarkably in section 297 of the 1998 Act. Actually captures the principles which were espoused in the case of Rose and the Health Commission in getting an interim payment direction, which is something that a worker would get within early confines of their claim to facilitate them getting access to treatment. And it says, despite liability, if you've got an injury management plan that says you need a treatment, we'll consider the four limbs, whether or not it either heals, cures, but maintains a certain status quo so the person can continue to work. It doesn't worsen the condition. That's a much easier test to satisfy than reasonable and necessary.
Thank you.
Thank you. Now, before I pass to government members, we all know we're breaking. The next transit witnesses after this kicks off at 3:45. Now, if we take our full allotted time, that'll effectively almost get us to 3:45. So I'm wondering, in light of that, and I think members need to stretch their legs. Could we perhaps just keep it nice and tight, please? Thank you.
Okay, well, I'll just ask one question, and perhaps to you, Ms May, and I hope you'll forgive me, but I'd like to refer to an article that you co-authored in 2014, Principles of an Effective Workers' Compensation System, which I found fascinating, where you talk about the compensation effect on health and well-being. Sorry?
You found it yourself?
I did, actually.
Good on you.
The compensation effect on health and well-being, you look at the two broad categories of secondary gain and secondary victimisation, and then you conclude, taking the evidence together, effort is required to minimise system-generated stresses and to improve scheme design so that people are supported to exit the schemes as quickly as possible. With that lens, what are your reflections on the scheme as it exists, the scheme, the reforms proposed, and if you had on your hands on the levers, what would you do with that in mind?
I had my hands on the levers basically in the Parks inquiry, which was where I was contracted to the WIRO, Mr Garling, to direct an inquiry into the mechanical and operational difficulties with the Act. And there are lots of things I could do. But you've asked a three-limb question, and my brain is so fried from having written a submission that's about 32 pages long and has about 60 pages
May,
of an
I said I don't want to interrupt, but I will. Just for this reason, you are entitled
take it on
to
notice.
take
well,
parts of it, if you,
yes.
just to enable you perhaps that
Thank you.
scope to more fulsomely deal with it, but I don't wish to cut you off. So I'll leave you, you might want to put the difference on them.
Thank
or
you,
answer
Chair.
any part of it that you wish.
Just so
you'll
you
have
know
to
you can do
repeat
that.
the question because I think I'll take it on notice and I'd be happy to
And I
answer.
apologise, I
No.
don't want to cut you up, but I don't want you to shortchange your opportunity
No.
by just having to think you've got to deal with it now. So
Thank you. Thank you.
Is that okay?
Yeah.
I'll just ask one question because we're short of time. The Treasurer, in his evidence, made a great story about getting to break-even premiums. Is that something that we need to prioritise?
Look, I haven't carefully looked at the last 20 years, but as I say, my recollection when I did look at it carefully is that we've always operated in deficit or close to it. So I'm not sure we've ever had break-even premiums. And at the moment, in my submission, I pointed out that last year the premiums received in cash and the claims paid in cash resulted in a $600 million surplus. So going to the actual basics, if I was running my household, I've got $4 billion or more dollars in cash and I've spent 3.5 or 3.6. Now that's not the answer because there's a whole lot of other issues. But, you know, it reflects on break even at the moment. That's a significant issue. But I'm conscious of the shortness of time. I just want to raise one other quick thing if I could, because I think it might answer some of the earlier questions. As a matter of interest, there is this difference between doctors' opinions. And it's very hard to deal with because some doctors say, I don't know why you can't walk just because you don't have two legs. And the other doctors say, well, you've got a slight cut on your ankle so you can't walk. We did an exercise at Wairo, which was very interesting. And I don't think we published it, but we dealt with hearing loss. So I invited the top 6 medico-legal hearing loss reporters in, and they turned up. And we sat around the table and we said, do you realise individually, I can tell you how you do your reports. I can tell you the outcomes, and I can tell you that you over there, Dr. X, when you're acting for the insurer, you go 3% to one side of the norm. And when you're acting for the worker, you go 3% the other side of the norm. And we're tracking you. And we track every report because that's the information I was obtaining by way of from the applications. 6 months later, we had them in again for a cup of coffee, and it was extraordinary. They're all about the same. Now, you know, there are issues like that which, with a bit of left-wing thinking, you might just be able to improve the position because the Wairo has every medical report, has every circumstance, and it's simply a matter of collecting the data. So, you know, there's one answer if you're looking for alternates to trying to bring the scheme back together. But look, it's not easy. And I think it's important that this committee deals with the alternatives that exist, and you're not going to be able to do that in 5 minutes. So, but thank you very much to all of you for listening, inviting me in the first place and listening. I'd be happy to help any time to give you my thoughts, right or wrong. I'm sure there are others who will have a suggestion that they know better, and I'm sure they do.
Thank you, and perhaps I might take the Chair's opportunity to ask the final question, which I'm sure we'll all support, is would you be able to, notice, tell us what brand of coffee you served the representatives when you sat down with them? And on that note, we'll break for
I like the left-wing thinking too. That's
Thank you very much, and we'll take
Damien does too.
Short break until 3:45. Thank you very much. And thank you for your detailed evidence.
Right.
two expert witnesses, particularly in the area of psychiatry and related fields. So what we'll do first, we need to do is require, just in order, and we'll perhaps start with the witness here in the room and welcome Dr. Dinnan, who's joining us remotely. Your name, your position title, indicating whether you're appearing here in your right as yourself, as an individual or an organisation, swearing either an oath or an affirmation, whichever you prefer, and then we can commence the formal questioning of you after you had the opportunity to make the opening statements, if that's agreeable. So we'll start with Dr.
Thank you for inviting me. My name is Dr. Julian Parmigiani. I'm a retired psychiatrist and the principal architect of the Psychiatric Impairment Rating Scale. I was also one of the most senior psychiatrists within the Workers' Compensation Commission system, or the Personal Injury Commission, for over 20 years. And I'm now here in my personal capacity because I've been invited by this committee to attend.
And we're grateful for you making the time available.
Thank you. Now, would you like me to proceed to the oath?
Yes, please.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, Doctor. And Dr. Dinnan, if you please go through the same procedure.
Yes, thank you. I'm Dr. Anthony Dinnan. I'm a clinical psychiatrist in private practice. My background is that I went into private practice after being in charge of the neuropsychiatric unit and being a research psychiatrist, and I've been in private practice on my own for well over 50 years. My area of special interest has always been military veterans and post-traumatic stress, as it became known from the 1980s onwards. And I've been giving evidence in court over many years for claims that have been disputed either through Veterans Affairs or workers' compensation. For many years I've been assessing for one particular law firm, Federation Law teachers, and also nurses who've got work-related claims.
Thank you. Sorry, we don't mean to cut you off, but that's a very helpful background. And there may be some questions arising, will be directed to you on it, but the qualifications I don't believe are being contested. So sorry to cut you off. It'll just mean that we have less time to ask you questions. So take either the oath or the affirmation, please.
Affirmation is I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Doctor. We'll now then commence with the opportunity to make opening statements.
Yes, thank you, Mr. Chair. I'd like to make an opening statement. First of all, I'd like to thank you for inviting me, because I called a number of senior colleagues still working within the Personal Injury Commission, and they've told me they've all been gagged, been directed not to make a submission to this committee and not to give evidence unless invited, which to me it was very disappointing given the importance of this committee. So that's something to...
Can I just
yes.
commence? And you may or may not be in a position to answer now, but if there is detail available about, and you used the word gag,
yes,
your words, not mine, but if in these individuals who you say have been gagged, this committee would like to know in more detail about that. So I'll leave that general statement with you.
Thank you.
But I believe, I speak on behalf of the committee, that would like to know more details about that.
Of course, you may at any time request from the Personal Injury Commission whether they have sent an email to the medical assessors in the last few days to that extent. I'll be happy with that.
That was your statement, so I thought I'd respond immediately.
Yes.
We'll have limited opportunity in the time available with the inquiry to follow it up, but I'll leave that with you.
Yes, thank you. Now, my opening statement is I think this committee really needs to ask quid bono, who benefits from the current workers' compensation system. It is clearly not the employers who are paying increasing premiums which they're finding unaffordable. It is clearly not the state government because of the cost of the scheme, and it is clearly not the worker who finds himself stripped of their dignity, their income, their privacy, and ultimately their mental health. So my understanding, my observation is that there is only one organisation or an alliance of organisations that actually benefits from the scheme, and that is CERA, the workers' workers' compensation insurers as agents, and the medical legal industry, of which I was part thereof. And looking at that prism, I'm happy to answer any questions about the harmful effects of the scheme, which I've tried to change over many years, but of course was precluded from doing so. And I found that ultimately it was easier for me to leave the scheme because I saw it as being so harmful, so toxic, as to be perhaps the future equivalent of asbestos exposure.
Thank you for that opening statement. Dr. Dinnan, could I then move to you, please, to invite you to make an opening statement?
Thank you very much, Mr. Chair. The main point I'd like to address the committee about is the concern that has been raised about the increased level of impairment from 15 to 30% as the basic upper limit, or in fact the threshold, I should say, for patients receiving compensation. My background is that I've been clinically involved, as I say, in a range of compensable illnesses and have been treating many patients, both state and federal compensation schemes. I'm aware of the difficulties my patients have encountered always in negotiating the systems to enable them to get the full benefit of their entitlements. But my focus has always been on trying to help them to be as well as they can under the circumstances. I'm involved in addressing this committee, I believe, because I was asked by the law firm that I've been working or providing assessments for and treating patients from Federation Law to give an opinion about that increased threshold. I sent them a report or an opinion about that matter. That led to me being invited to attend a meeting at Parliament House last Thursday with the unions that were dealing with some members of Parliament to give them background as to what was their concern, and that led on to me being asked to address this committee. I can only give my assistance to the committee as from the viewpoint of a clinical psychiatrist. I've not ever worked as a member of the system, as Dr. Parmigiani has indicated he has. My role has always been as a clinician treating someone and from time to time giving advice and helping them to deal with the systems. But I know from my patients and my clinical experience over many years, because I've been in practice for many years, that and to increase the threshold from 15 to 30% would eliminate virtually every patient I've ever seen, except maybe Frank, one or two, from being eligible for the scheme. Thank you, sir.
Thank you, Dr. Dinnan. Thank you both for the very helpful opening statements, which I'm sure will stimulate some questions. I know will stimulate some questions from the committee members. So we'll start with the Honourable Damien Hutto.
Thank you, and thank you both for making yourself available for the committee. Dr. Parmigiani, we've heard a lot of evidence today, and it's been very. We've had a lot of people come forward, and but one of the themes has been is that psychological injuries are really very hard to assess. You're the author of the psychiatric injury. What is it? The
impairment rating scale.
Yeah.
Psychiatric impairment rating scale, PIRS.
Yeah, rating scale. So, is it your view that that actually assessing psychological injuries is so difficult that it requires its own scheme for determining liability for employers relating to assessing those injuries?
No, the assessment has changed from diagnosis, which are difficult to make, to function, and the PIRS, the Psychiatric Impairment Rating Scale, is an assessment of function. That is the impact of the psychiatric illness. And by the time you're looking at areas of function like relationships, capacity to enjoy recreational activities, capacity to work, travel, and capacity to concentrate. Those are all the effects of a psychological injury, and they're observable by a third party. They're not subjective like a symptom might be.
Well, then perhaps I'm concentrating on the wrong thing, and I should be looking at the Diagnostic and Statistical Manual of mental disorders. Is that the way?
Well, a diagnosis under DSM is required, but it has really very little relationship with the level of impairment as measured by function.
So are we really saying that there is a problem in terms of the way that psychological injuries are assessed?
No, I don't think there is a problem there. I think the problem is with the system, and I'm happy to expand if...
There you go.
Well, the problem is that there is an event, as defined, in the workplace, and there is a psychological reaction to that event, which may be a perfectly normal psychological response to perhaps bullying, perhaps disciplining, and it upsets people. Now, once you embark on a system which requires you to lodge a claim and then go through the assessment process, and this is an assessment process which stretches over months, if not years, if you include appeals, disputes and appeals, you have a person who's gone from having a dispute and a range of symptoms, perfectly normal responses to a conflict, for example, which are then stretched over months and years, and there's sleeplessness and loss of identity and basically loss of dignity because you're now a workers' compensation case. And so by the end of that trajectory, which has taken a long time, the injury becomes real and people have lost sleep over it. People have committed themselves. If you go to a no-win, no-fee firm, you sign your rights away, and you can't withdraw from it. If you withdraw, you're liable for all the costs associated with the case. Basically, you lose your house. So you are committed. You signed a contract which makes it mandatory for you to be in this state of paralysis for 18 months, 2 years, and sometimes even longer. Then you get all the anxiety arising from disputes between assessors and your capacity to, or lack of capacity to generate any money to feed your children or pay the mortgage. And so by the end of it, you have created a mentally crippled person.
There's a whole lot of issues which arise from just what you said. Same set of facts and circumstances, for example.
Yes. In
a work environment. Mr. Latham might take them really very easily. No worries, can't bully him. I might be much more sensitive.
Yep.
And for me, it's a bullying event.
Yes.
How does an employer deal with that?
That situation needs to be addressed as quickly as possible. Perhaps independently, perhaps by a government organisation. Someone needs to go there, make a judgment, a little bit like the unfair dismissal claims, where you just resolve it and let people move on with their lives, look for another job without necessarily labelling them as mentally ill, because then if the assessor under these reforms, whether they be a tribunal, which I'm scared to think how long it would take to arrange a hearing under such circumstances. If they find that the employer is liable, then you have to be psychiatrically assessed. Then the insurer will get a psychiatric assessment, and then if the other side doesn't like it, they'll get their own assessment. Then it'll be a dispute, which then goes to the Personal Injury Commission. Now, if they don't like that, it'll go on forever.
So the model which the exposure draft seems to indicate is that for that scenario where there is an allegation that I was bullied in the workplace, is that you have to get a certificate from the Industrial Relations Commission.
Yes.
Do you see that as the right model for quickly resolving whether a bullying event may or may not have occurred in relation to the environment in which it's suggested that it has?
Well, the devil's in the detail. Superficially, it sounds great, very attractive proposition. The issue is the time that it takes to get that certificate and what happens after that certificate. What happens is not, you have suffered an injury, here a certain amount of money, take it, or we can go through the courts, like it used to happen in the 19th century with injury cases. Now it's like, okay, you have an injury, you have to be assessed. And now you embark on this long path which will strip you of your mental health.
Well, but there's an equally problematic part of that process, that the person making the allegation would potentially be the subject of an extensive cross-examination process and potentially be re-traumatised in respect of the circumstances, because may involve sexual harassment, racial bullying, or workplace bullying.
Well, you do need to find the facts. An investigator needs to go, someone who's properly qualified, needs to go to the workplace as quickly as possible, find out what has happened, and if the employer is liable, quickly bring the case to its conclusion, not let it stretch on indefinitely.
And you've then identified the nature of the system that people actually then get involved in after they get their certificate. Yes. They then have to continue it.
Yes.
Now, is there a problem in the system which exists because we now need to adapt our persona to be a continuing litigant in that system?
Well, absolutely, because the more you enter that role, you become that person. You are the injured worker and who has been damaged, and you will hear permanent impairment and permanent damage. And so you start to think and behave like you're permanently damaged, and you don't look for other work because it's going to reduce your chance of getting any compensation. And lawyers and others will advise you, look, you've embarked on this path, stop trying to go back to normal, stop trying to get a job, because then you have no case. And that in itself is stripping the person of their role within society.
So effectively what you're saying is that lawyers or doctors at that point will coach you about how you've got to be behaved to be the 25%, or as is suggested by this exposure draft, to reach the 30% level of incapacity, whole person incapacity, to be able to continue your claim.
Look, I don't think lawyers or doctors coach claimants. They just help them understand the criteria on which they're going to be assessed. And if those are the criteria, that's how they prove that a great injustice has occurred, and they're going to be compensated because they're angry. This is before they actually develop a mental illness. While they're still angry, they lose sleep over it, they lose their appetite, they become grumpy, irritable, the relationship suffers, and before you know it, the relationship has broken down, their friends have avoided them, they look like they've got a mental illness, and they do. That's what happens.
In terms of getting to potentially a scheme which deals with that in a much more compassionate way, or a way which doesn't exacerbate the injury,
yes,
this needs a lot more potential thought than actually exists in this exposure draft.
Yes, I see it, first of all, the current Act and the exposure draft as being basically written by lawyers. And the claim handling process goes as fast as a car designed by lawyers. It just does not have any input by people with knowledge. On the iCare board, there's no occupational psychiatrist, and they're overseeing the whole system. As an expert within the system, basically, we couldn't do anything because we're always told what to do, where to turn up, and where not to turn up.
And I suppose the length of time that it takes for a claim to be resolved then would, in fact, impact on the person. Can I just ask you this? I think you started your position by suggesting that, in your experience, no one would reach the 30% whole of body impairment. Is that right?
Very rarely. I mean, I can see over the 22 years, perhaps a handful of people, I could count them on one hand, that people have reached 31%.
31%. So this scheme certainly allows the claimant for 2.5 years to make the claim, allows them for medical expenses for 12 months after that date, but then cuts off their entitlements for any further claims and certainly any lump sum claims after that date if they're below the 31%.
Yes, but the 31% or any percentage of permanent impairment does not kick in until the person is assessed as being permanently impaired and therefore let go. And that process is the damage. The 2 years, the 18 months that it takes for the system to say, okay, this is your permanent impairment rating. By that stage, you've already damaged the person.
But Ms. Boyd made the point earlier on. At what point do you make that assessment that they're 31? Because a person at the commencement of the process might be 22%, but by the time they get to 2.5 years and 1 day, they might be 30%. Would that person be required to start again? Because they've gone through this process, you've cut them off, they're now potentially...
Look, when you look at the criteria, if you read the PIRS, to get to 31%, basically, you're not working, your relationships have broken down, you're unable to look after yourself. So basically, after that time, and you cut them off the system, you might as well give them a cardboard box and they can move in the street because they've got no agency left.
You've had an opportunity of looking at the exposure draft.
Yes.
Are there any aspects of it which you say are really something that you would embrace in terms of this looks like a good initiative?
Look, I'm sure its exposure draft is paid with good intentions, but because of the further delays that are built into or suggested in the claims handling system and the process, I fear that it's going to be causing more harm because you're now going to stretch the process by another few months while you get the, I don't know if it's going to be the ARC or the Fair Work Australia to assess whether they've had a workplace injury or not. So I take into account the harm caused by further delays, and I think it'll more than counteract any good intentions of the draft reforms.
Thank you very much. Before I pass to the Deputy Chair, Dr. Dinnan, if you've got any contribution you'd like to make as the questions progress, could you just put your hand up, please? And that's a signal to me to defer to you. So to Deputy Chair.
Mr. Chair, I didn't want to interrupt Dr. Palmer's now, but I must endorse everything he said. The other thing that occurs to me is when we're talking about assessment, we're talking about a way of calibrating the number that we would give on this scale that Dr. Parmigiani developed 20 odd years ago. That I think can be confused with what we psychiatrists normally regard as assessment, which is when you when you see a patient and you examine them and you come to an opinion as to what's wrong with them. That's really a medical type assessment. So I wasn't sure whether that was part of what was being asked. If it is, then clearly I don't think there's any difficulty in making diagnoses. But I agree with Dr. Parmigiani, even if there are some patients where it's not that straightforward, what's involved in the compensation process is looking at how much impairment there is, and that really doesn't depend on the diagnosis, it depends on the clinical features that you're dealing with.
Thank you, Doctor. That's very helpful. The Deputy Chair.
Thank you, Chair, and good afternoon to both of you. I might just start with you, Dr. Dinnan. Just in relation to, I think a lot of people have made the point that there is a need to distinguish between physical and psychological injury claims when it comes to a lot of aspects of the workers' compensation system, particularly the management of those claims. But when it comes to the assessment process for an impairment, that an injury is an injury, and that's the spot where psychological and physical injuries should really be treated the same. Would you agree with that statement?
Yes, I do. The only other thing I would say is that psychiatry is starting to evolve in a way that we've been hoping to see for a long time, and that is we're starting to move towards a biological basis to understand psychiatric illness, which has been lacking until now. So there's a lot of research being carried on around the world at the moment into the genetics of psychiatric disorders. We know now increasingly a lot more about the neurobiology of psychiatric disorders. The distinction you're making between physical and psychological makes sense, except that for a lot of the patients that I deal with, the way I manage them is to tell them, if you haven't got a psychological injury where you can be talked out of it, or you can talk yourself out of it, or you may be reacting psychologically, what you've got essentially is a brain injury. And I think that's increasingly an understanding of where psychiatry is going nowadays, because particularly with people being traumatised, as Dr. Parmigiani has described, once they get to that point where they're really ill and incapacitated, it's not a question of psychological therapy getting them better. It's a question of their illness is going to persist, the impairment is going to persist, and the long-term consequences often lead to permanent disability, and that's often poorly understood. That happens in physical injury, but it is also very relevant to psychological injury.
The workers' compensation scheme is designed around the principle that you are compensated because you were injured, not you are compensated because your employer did something wrong. It's been pointed out by other witnesses that, you know, if you injure your leg because you trip over a chair, that's not treated any differently to if you injure your leg because you've tripped over a couch or anything else for that matter. Whereas these reforms are looking at psychological injury and saying, yes, you're injured, but unless it's because of a particular reason, we're not going to cover you. Does that, to you, Dr. Dinnan, make you, I guess, question whether the designers of this proposal understand that psychological injury is just as valuable or just as valid as a physical injury?
It's a very important question to ask. I mean, if it's true that with a psychological injury in the workplace, that we have to look at the events and sort of categorise them. Is it bullying and harassment, or is it overwork, or is it unsuitable working conditions, or is it being subjected to assaults, or something which can be seen as an injury physically that gives rise to a psychological injury. Someone who works in a mine who gets injured and develops a secondary psychological injury, for example. I agree with you. To try and compartmentalise those elements, if it's going to apply in psychology, it should also apply with regard to physical injury. It seems to me this whole issue really is an unfair approach to the management of psychological injury. And that's my initial reaction when I got told that the threshold is being raised to 31% or 30%, I was told, for psychological injury, but that doesn't apply to any other injury in the workplace. I mean, the problem, if there's increasing claims, which apparently is the problem, for psychological injury, the problem is not then to say, well, therefore we won't pay those because we'll make it more difficult. The problem is to find out why and what's going on here. And one of the things that I've seen already from this brief involvement with this political process is that it's not well understood as to how this is all coming about when psychological injury is essentially, in my experience, a medical issue in the same way that a physical injury would be a medical issue.
Thank you. Dr. Parmigiani, there's been discussion about the similarities or not between the 30% test under the South Australian legislation and the proposed 31% test here in terms of that threshold being based on a different scale. Yeah. Obviously, you're the person to ask about this. Would you agree that there is a difference between
Look, I'm not familiar with what scale South Australia has introduced, so I can't really comment on that.
Okay.
But taking back, if I could just clarify a point, a very important point made by Dr. Dinnan, is that we're now converging physical and psychiatric injuries seem to be also physical because of the stress hormones like cortisol and the lack of sleep. What happens? You get real changes on MRIs. Parts of the limbic system, which is a part of the brain, starts shrinking because neurons die, and then you remove the stress and the person remains broken. So that is a physical injury in the brain. You can call it a psychiatric injury. Because if it was just a reaction, you remove the stressor and the person within days or weeks goes back to normal, which is probably what would happen in the initial phases of an incident, unless you just keep stressing that person.
I'll remark that.
Thank you, Chair, and thank you to the two doctors. To both of you, you've been around a while and seen the emergence of new trends and patterns in this space. How do you explain the rise of psychological injuries? I think reasonably you can say workplaces themselves over the last 20 or 30 years, they haven't become more dangerous and damaging to people. I mean, we've got a multitude of DEI programs, identity programs, all sorts of consideration and compassion for people in the workplace that wouldn't have been there, say, 30 years ago. And for goodness sake, you can even work from home. You don't have to turn up in many categories. So what's been the trend that in that environment has led to this increase in the injuries that we're dealing with in this draft exposure bill?
Clearly, the culture has changed, as you pointed out. Had you been born 150 years ago, you would have lost various brothers and sisters and family members either through war or diseases that can now be treated. So you're not exposed to stresses, and that in a way does not forge you into a stronger individual. So we're not as used to, we're not learning how to cope with stress early in life because we're all being very well looked after, and you probably wouldn't have it any other way these days. You wouldn't go and brutalise children just to make them tougher. So we are a little bit more prone to getting upset and getting angry. But then again, I don't think that's something that should necessarily lead to a psychiatric injury or claim unless something else comes on top of it and makes your life
What's
hell.
the something else that's changed? I agree with what you're saying about the general outlook on resilience, and you don't have to be brutalised as a child to toughen up. You can grow up in a tough area, in a tough financial circumstance. But anyway, be that as it may, what are the other things that have changed that you've just mentioned?
Well, as I said, there is a culture of being a victim. That's and feeling hard done by. All those things certainly do apply. But I think for our purposes, you may argue that we have some less resilient individuals, so we don't need a system that basically makes them into more grist for the mill. It's a sort of sausage machine of compensation, because that really breaks people.
No, but so too in the finances of these schemes. If we've now got a culture of victimology, that doesn't mean people have got real injuries.
People feel it, they believe it.
Well,
they feel they're the victim of an injustice.
It's like
they lose sleep
the
over it.
Costanza principle. If you feel like you're injured, then you are.
Well, you can certainly you can talk yourself into it. And
You can talk yourself into it.
Yeah, and that's current culture, but that doesn't make any less suffering.
Okay, Dr. Dinnan, what says you?
Yeah, if I can come in, I mean, the notion that people are faking psychiatric injury is an easy one to adopt, but in reality, it's I don't think it's an issue. What is an issue is that if there has been a very big increase in psychological injuries in the workplace, you have to understand what's caused it, and Dr. Parmigiani has given some reasons. To give you an illustration, I have patients who have developed PTSD and get medically retired from the police force after 30 years of frontline service. That makes sense. If you know what happens on general duties in the police force, I wouldn't want to do a day's work, right? But those 30-year police retiring on medical grounds through PTSD are now becoming very uncommon. And what's common is young policemen with 5 or 10 years service are also not able to continue any further and are being medically retired with PTSD. And I ask my police patients what's going on. And I say, how long can you last as a young person coming to the police force nowadays? And I'm told 5 to 7 years. I asked ambulance officers that I encountered when I had an unfortunate incident, I was in an ambulance, and I said to them, very nice to see you, how long have you been in ambo? 10 years. I said, that's impressive. I said, how long do people expect to be in the ambulance service today when they join up? And they said, 5 years. So there's something going on. Now, maybe it's because benefits are accessible, and maybe that allows people to say, well, I am sick, I don't want to push it any further. Dr. Parmigiani, I'm sure, would agree with me that the earlier you identify yourself as having mental health problems and get attention for that and get out of the situation that caused it, whether it's a bad marriage, a bad workplace, a home environment, whatever. The sooner you get out of it and get back to something alternative, the more likely it is that you're going to get a reasonable level of recovery. So I think there's a lot of answers to the question, but it's an important issue.
Yeah, well, to both of you, on this trend, just away from the workplace, is there a comparable rise in non-workplace psychological injuries? And what does that tell us about the workplace environment?
Look, I think there are various areas where people do come to compensation, whether it's medical negligence or public liability. And, I haven't been around for 100 years, but I suspect that people are probably more vulnerable these days, and being told that they've been injured or they've been they're the victim of an injustice, and there is a system to compensate them to bring this justice, and some people take advantage of that and will pursue that path.
Right, but is there a rise in the non-workplace psychological industries, or is Dr. Dinnan's point valid? It's happening in the workplace because benefits are available.
I'd say there's a very good answer to that, and that is the model that has been used now for the past years, since the government started to fund psychological services, that the person will go to the doctor and say, I'm stressed and anxious because my nephew died, or the workplace is difficult, or I've had an illness. And the doctor will say, because you've only got 6 minutes, the doctor will say, well, I'll send you to a psychologist. Now, when this scheme started to fund psychologists, there were about 5,000 or 6,000 in the Commonwealth. I think that's now above 30,000. So they're looking for work. They very rarely would ask a psychiatrist, what do you think the diagnosis and management should be? But they're not medically qualified. They are in need of patients, they are in need of clients, they want to keep working. They're not going to send people away. So I think that's part of the problem.
So, in economics, we call that Say's law, supply creating its own demand.
Sorry, just to follow up with that question, I did see a study which was interesting, and looking at the causes of post-traumatic stress disorder in the community. And one of the highest causes was watching a relative die in a hospital. So this is something that used to occur commonly throughout the history of mankind, but now it is the biggest cause of post-traumatic stress disorder, one of the biggest
Watching a relative die in a hospital.
Yes.
Used to die at home, yes.
Well, you shouldn't see it, shouldn't watch it, because this is so upsetting. You've never seen a dead body before.
Yeah, they'd be killed at work accidents.
I want to take both members of the panel to the proposed Section 8A, which is the meaning of psychological injury. Presumably, if this is legislated, there'll be judicial consideration. What is a mental or psychiatric disorder? How do you...
Well, clinically, we use the DSM, the Diagnostic and Statistical Manual of Mental Disorders, which is an American classification system with criteria that we mostly agree with, talking to each other. So that's what we use. I'm not sure whether there's a legal definition that they want to work in there.
And how would you assess, because it causes... under the definition, you've seen the definition, I'm assuming.
Sorry, let me bring it up again.
It causes significant behavioural, cognitive or psychological dysfunction. How would we determine what significant is?
Again, that is subjective. I think what is
presumably
significant...
the court's going to ask someone like yourself for an explanation of that. What are you going to say?
I mean, we as in treating psychiatrists and assessors have an experience of what is a normal reaction to a stressful event and what is abnormal. Clearly there are a continuum, and somewhere you have to draw the line and say this is definitely abnormal, this is pathological, this is a psychiatric disease or injury. But that's, it's subjective, and that's why sometimes you find a difference in opinion in diagnoses between psychiatrists, because someone will think, oh no, that cognitive response or that behavioural response to me seems to be within the normal range, and someone might say, no, I think that's outside the normal range.
Can it be a temporary thing?
Sorry?
Can it be temporary?
Oh, of course. My point is that most reactions to stress, even major stresses, are temporary.
So how do you distinguish between something that's temporary and a kind of permanent disorder? Like,
well,
at what point do you make the assessment that
generally they
this
put
is no longer a
they put a limit
thing?
of about 4 weeks. If you're still suffering symptoms after 4 weeks, then perhaps you've got something diagnosable. But most people are still resilient enough, Honourable Latham, to come good eventually. But there is something else going on here
So
with
you
this
could
compensation system.
have a psychiatric disorder that's temporary and where the symptoms, for want of a better description,
Yep.
Have disappeared before you've had a diagnosis.
Well, then you don't have a diagnosis. They're gone. It's a normal psychological response.
Surely you've still sustained an injury under this definition.
Well, legally, you've had something unhappy at work. It's an event where if the employer was negligent in what they did, then the lawyers will say, oh yes, that's an injury. But in terms, when you're speaking medically, if there are no symptoms, if there are no consequences, no problems in everyday life, then you don't have a disease or a diagnosis.
But surely you could imagine a situation where someone experiences a psychiatrically traumatic event, have behavioural or cognitive psychological dysfunction as a result of that event.
Yes. Which goes away.
Then they recover.
Yep.
They need time off from work.
Yes.
In that period. But that won't be diagnosed. It'll never be able to be diagnosed.
No, but
how does that work in terms of the
what I'd
compensation
like to
system?
stress is that that is a normal psychological reaction. We don't live in an emotional vacuum. Things that happen upset us, and we lose sleep over it. We might become irritable. We might even go off our food for a little while and not want to socialise, because that's a normal response to an unhappy event, an incident. But that's the part of the human condition. That's how we function.
Can I ask about the causality? How do you assess that a relevant event has caused a psychological injury? Presumably psychiatrists are involved in the assessment.
The issue of liability is that not for the psychiatrist. I mean, clearly someone has to determine
Causality.
the facts in the workplace. If it did, and there's a close temporal relationship with an incident and the development of symptoms, and there are no other explanations for that person developing that set of symptoms, such as other incidents, relationship breakdowns, drug or alcohol problems, pathological gambling. So you have event A leading to condition B, then you can be confident because of the temporal relationship that A caused B.
And what if it's not as clear as that? Then
What caused it?
How do you well,
Just
it
comes
could
out
be
of the blue.
Could be there are other factors that might suggest that are exterior to the workplace, but there's obviously some strong evidence, countervailing evidence that suggests that it was. How do you?
Well, then you
draw
have to
that line of
you have to
distinction?
apportion what's causing or how much is causing what, and then you try to, in your mind, work in the normal person. Event A would cause these symptoms, and event B would it cause greater symptoms, lesser symptoms? And it's not uncommon for people to have a number of incidents occurring, and for me to be asked in the past to apportion the causality, and I would say, well, 60% is due to A, 10% is due to B, 5% is due to C, and so on, because we try to put it together. That's why we're called experts. We've got clinical experience in assessing the psychological response to incidents and their magnitude.
Can I ask, I think in an earlier answer you referred to the process of doing the whole person impairment assessment, looking at functional capacity.
Yes.
And presumably that's also how you assess work capacity. Can you perhaps talk a little bit about the intersection between the kind of process of how you look at someone's functional capacity and how you might make an assessment of whether they're capable of working
Clearly,
1 or 2 or
all
3
those
days a
areas of
week?
functions are intertwined. If you can travel to your workplace, if you can relate normally to other people, if you can concentrate, you're carrying out activities which require a degree of concentration, such as doing a university course, clearly your concentration's fine. If you're able to look after yourself, all those things can translate into work capacity. So we assess what people do. Clearly they're not at work, otherwise they wouldn't be seeing you. But you take a screenshot of their lives and what they're doing. And if that translates into being able to function at work, concentrate and get there and relate to others, then they've got work capacity.
Are psychiatrists involved in work capacity assessments?
I think they are. They have been asked, but well, it depends on psychiatric injuries. We're often asked to assess work capacity.
Can I say that if there was any opportunity perhaps to bring the government questioning to almost a conclusion at this point, that would help us get to the next bit. There's a lot of time, but without being disrespectful to government members. Well, on that basis, that brings us to the allotted time. Doctors, to both of you, thank you very much for making yourself available. We know you're very busy. We respect your obviously your training and experience and capacity to bring some real expert knowledge before the committee this afternoon. So we thank you very much.
Thank you.
Fantastic. Thank you.
Thank you, Dr. Denon. Thank you, Doctor.
Thanks.
We'll panel and we welcome to the inquiry this afternoon two experienced individuals. Mr. Chris Gambian joins us this afternoon in person, and we thank you for that. He's the Executive Director of the Australians for Mental Health, and joining us shortly, he's here, okay, thank you, is Professor Pat McGorry, AO, via video conference. So, gentlemen, thank you both for making yourself available on a Friday afternoon.
My pleasure.
Thank you. We'll go through the formalities, which will involve just each of you individually, just your full name, your position title, swearing, I should say, either an oath or affirmation, whichever you prefer, the words of which you should have before you. So we'll start with Mr. Gambian.
Thanks, Mr. Chair. My name's Chris Gambian. I'm Executive Director at Australians for Mental Health. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, Mr. Gambian. Professor.
Yes, my name's Patrick McGorry. I'm Executive Director of Origin, the National Centre for Excellence in Youth Mental Health, and Professor of Youth Mental Health at the University of Melbourne. And I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, Professor McGorry. Now, we've received, just to confirm this, and thank you very much for this, the submission from Australians for Mental Health. It's submission number 19 to the inquiry. It stands as number 19. Received, processed, been uploaded to the web page for the inquiry, and is obviously now evidence. So thank you very much for that. And of course, the evidence this afternoon from the back and forth of questions and answers will form oral evidence to this inquiry. So thank you. Now, perhaps we'll start with the opportunity for one or both of you. I'm not quite sure how this has been arranged to make an opening statement. And then, if agreeable, we'll move then to questions from the committee, of which there are members of opposition, government and crossbench. So, Mr. Gambian,
thank you,
to make the opening statement.
Thanks for the opportunity to say a few words today. The workplace mental health system is in urgent need of reform. On that much, at least, we and the government are in heated agreement. Workers in New South Wales need jobs that support mental wellbeing, and when things go wrong, quick access to quality mental health care and support. The draft legislation will not achieve that. Changes that make it harder for workers to get help through the workers' compensation system for psychological injury will push thousands of injured workers straight into public mental health system that is already at breaking point. To force workers who are experiencing what is likely to be the worst moment of their lives to commence and win legal action before being able to get support for a mental health issue is to punch down on some of the most vulnerable people in New South Wales. Everyone knows someone who has struggled with their mental health. Mental health issues affect every family in New South Wales. Our research tells us time and time again that work is one of the leading causes of mental distress. But this draft law is built around the idea that workers are faking it. I wonder if the drafters of this law would be willing to look a firefighter or a nurse or a paramedic or a social worker in the eye and tell them they are faking their mental distress. Would they sit in the waiting room of a mental health service or the emergency department of a New South Wales public hospital on any night of the week and tell the people who are struggling with their mental ill health that they are faking it? People who work in the construction industry make up about 9% of the workforce, but 21% of the deaths by suicide. Are these people faking their mental distress? Change is needed, to be sure, but this is change designed by lawyers and accountants and politicians for a fundamental question of health, wellbeing and workplace design. There is a better way. Slow down. Make this reform count to improve workplaces and improve lives. Bring mental health experts together with workers and employers to do the things that reduce harm in the first place. As a start, we could design jobs to meet workers' wellbeing needs, including those with pre-existing conditions, hold employers accountable for maintaining psychologically safe workplaces, resolve workplace relationship issues quickly and focus on rebuilding trust rather than litigating, provide adequate interim supports so distressed workers can focus on recovery, ensure long-term care is available for those who need it. Let's design a system that improves human outcomes. Doing that will save even more money and get workers back to work healthy much faster.
Thank you, Mr. Campion. That's a very concise but very helpful and thorough opening statement, so thank you for that. We'll now move to questions. And we'll
does Dr McGorry...
I do apologise. Professor McGorry, do you wish to add to that opening statement of Mr. Campion?
I don't think so, but I'm very happy to answer any questions that in relation to this, what Chris has said, and any other questions that the inquiry might have.
Thank you, Professor McGorry. We'll move to the opposition. Calling it Dr. Damien Shudo. The Honourable Damien Shudo.
Thank you. Thanks, Chris, for coming along. In your submission, you warned that the bill, if it were to pass, would push thousands straight into the public health system. That is already at breaking point, overwhelming services and leaving many people without care. What are the elements of the bill that lead you to that conclusion?
Well, I guess first and foremost, it is when a person is injured, when their mental health has been injured, in any context, work or otherwise, they need to go and seek out supports. There is already massive shortages of those supports. I think that's been traversed pretty thoroughly. That getting in to see psychologists, psychiatrists, counselling, so it's all under a lot of pressure. The benefit we have with the workers' compensation system is that people who are able to access insurance are able to access a range of services that a person whose means might not extend to private psychiatrists or private psychology are able to access. That's the first thing. But the second thing is just the fact of being able to take some time off work. One of the points that I think we made in the submission, but it's been sort of canvassed more publicly in the last couple of days, is that the quicker a person can get assistance, the less severe their conditions are going to be. So if we're saying to somebody, you can't even have time off work that is covered by workers' comp, then what possible hope do they have of being able to recover from their injuries? It does force people into, the more publicly available options for mental health care, like the public system, like, emergency wards and things like that. If people aren't getting care through the workers' comp system, the problem doesn't go away. It just changes who's responsible for it. And right now, the supports that we've got in place for people who need mental health care in New South Wales are woefully inadequate.
Well, one of the proposals is to amend Section 39 to require 30%, 31% WPI in relation before you can continue claims after 2.5 years and continue to get access to medical treatment for a further 12 months. Some of the evidence we've heard would say that that would, in fact, just about include everyone, and there would be no one. Is that your experience?
Look, I'm not going to claim expertise adequate to answer that question. Mr. Tudor, hope as people on the committee would know, I'm relatively new to this space. But certainly the briefings that we've had, the information that we've had from some of our experts that support us is that there's two problems. One is if you get a person who doesn't meet the criteria for 30%, which, yes, we've heard is very, very, very few people, those injuries don't go away. So then what? Who's looking after them at that point? It is already...
Well, they might be forcing them onto Social Security.
Well, you might be forcing them onto Social Security. I'm sure the life insurance industry would say you'd be forcing them into claims for permanent disability through the superannuation system. Certainly the need for care doesn't go away just because the government decides it's not workers' comp. And I think that's a pretty fundamental
Dr.
problem.
McGorry, what's your assessment? Would 30%, a 30% WPI exclude most claimants?
I think so. I think it's lifting the bar too high. As Chris is saying, what's the alternative pathway for people that are sort of in between that 15 and 30%? There's a whole swathe of people that would be whose longer term care would be severely compromised with very few other options for them, I would say, based on the initial sort of statements that Chris just made. Mm-hmm.
Some of the anecdotal evidence that people always put up in relation to this, to the workers' compensation system, is that anecdotally someone is put under a pressure situation at work and their response is to go away on stress leave or some sort of other leave because of the stress situation they've been exposed to. Generally, and the evidence we also heard just prior to yourselves was that, there are mental reactions or emotional reactions to just about everything in life. We either like it, don't like it, react to it in some way or other. How do you differentiate between a mental health issue in response to a workplace issue and one which is just a normal human reaction to sort of potentially a stress situation?
That is such a great question, and I've been addressing that in my sort of career more widely for a long time, and also even just recently in the media, because there is an issue with the boundaries of mental illness, and there is an issue about that. We know in Australia from the National Mental Health Survey that the prevalence of mental illness is going up dramatically in a genuine sense, because the National Mental Health Survey has got very tough and rigorous methodology, so it measures things very accurately using objective diagnostic criteria. So it is going up in a genuine sense. On the other hand, there's another layer on top of that of people who are in distress or where the boundaries of diagnosis have softened. And two examples of that would be ADHD and ASD, where we're seeing a huge increase of diagnosis of people that probably don't necessarily have a need for care. So that is the issue that needs to be decided in these cases. Is it just something that's just part of life and will be transient and not have a need for professional help, and will resolve with support and just time, a short time frame, or is it something that needs care? That is a skilled decision that has to be made by an expert, not by lawyers or accountants or people seeking to kind of constrain government expenditure or insurance expenditures in different ways. And it's been a battle over things like back pain and all sorts of other things in this kind of domain for many, many years. I've seen many cases where that decision in the physical health sense is called into question. But there's no doubt that workplace stress and things that happen in the workplace, unsafe work environments, whether they're physical or mental, can contribute to a need for mental health care, for healthcare generally, and also mental health care. It's a little bit more difficult to define that in some ways in mental health, but it has to be defined, and it's really what is the accurate level of need for care amongst these workers, and that is a decision that should be made by clinicians, not by accountants and lawyers.
Thank you. Now, I apologise as I became back and forth. Do you remember who was the first last time around? Okay, start Nathan.
Okay.
Go ahead.
Well, we all end up at the same destination, don't we? Thank you, Chair. Thank you to the two witnesses and to Dr. McGorry. Can I ask you, in the submission, there's an expression used that we haven't seen in any other part of the day, to my knowledge, psychosocial injury. What exactly is meant by that?
Well, I think it's sort of where the causes of the onset of an episode of mental ill health are psychological or environmental is probably the best way to explain it. And obviously there are causes of mental illness that are fairly intrinsic to the brain or the genes or the biological vulnerability, but we know that risk factors that transform that vulnerability into manifest disease or need for care are very often psychological stress of various kinds, or social factor, environmental factors, such as, I suppose the workplace stress would be one. Even stresses like unemployment, social or housing difficulties can basically tip people over from a healthy state into a state of acute depression or psychosis or other forms of mental illness. So the onset of mental illness is often a complex interplay of these things, and that term psychosocial is used to kind of capture the kind of external triggers or risk factors.
Right.
Does that make sense?
Yeah, no, it makes perfect sense. On page 3 of your submission, second last paragraph, you write about the impact of clause 8H in the exposure bill, where if a paramedic who attended a crime scene where a child had died had experienced a vicarious trauma in the workplace, rather than mental health practitioners, lawyers and the legal system would judge that, and you say it's plainly absurd. You can only imagine how bad that is, that circumstance in that job, but we live in a society where, for a range of reasons, we need people who do that kind of work. And,
yes.
And doing that work, no matter the human tragedy and difficulties that must confront a lot of those paramedics on a daily basis, it does help a lot of other people to have them on the job. And but it doesn't necessarily follow, does it, that every paramedic will suffer the vicarious trauma by virtue of being in that job? And in terms of prevention, are we doing enough in the selection of people in those occupations to ensure that they're of a mental framework, an outlook, a life experience where they're less susceptible to the type of trauma we're talking about? And I think that selection process, as opposed to strictly equal employment opportunity, is actually good for the workers, isn't it? Because if you throw people in who aren't able to confront these problems, then you've got twice the problems, haven't you?
Yeah, that's a very good question, a good area to discuss as well. I think you're right to say that there are certain personality characteristics or strengths that should be valued when you're recruiting people for these type of jobs. That's a very good point, because some people are more vulnerable than others to kind of to the exposure to trauma. But I have treated and seen a lot of first responders over my career, including police and paramedics and firefighters and other people who do a fantastic job for the community, as you pointed out. And they are often not well enough supported by their organisation. I've got a friend actually in Sydney who was a fantastic paramedic in Sydney on the helicopters for many years. He performed heroic acts and was highly respected by all his colleagues. And when he kind of when he reached the tipping point of too much exposure to these very traumatic experiences, he was not well supported by his organisation. So I think no matter how strong and resilient the person is, and we see this with military personnel too, when they're exposed, for example, in the First World War, when you were in those trenches on the Western Front, very large numbers of very strong men were had major nervous breakdowns and psychiatric casualties as a result of just exposure to extreme, overwhelming trauma. And I think if you think about the police, for example, who were exposed to, maybe dozens of very hideous and traumatic car accidents over a period of time, the cumulative effect of trauma will probably overwhelm most people if they experience enough of it. So it's kind of it's a complex interplay of how vulnerable you are in the first place, as you pointed out, and then what they actually get exposed to. But to say that because they don't have a personal relationship with the person who's affected, that rules out vicarious trauma. That goes against all the research evidence. Vicarious trauma can happen to anyone.
Oh yeah. Well, the police, the biggest thing they talk about is, and it's horrific, having to cut down people who've hung themselves.
Oh, exactly. I couldn't agree with you more.
And it goes also to leave conditions, pay, support, as you say. I would have thought leave conditions need to be reassessed to give people a break from these sorts of jobs. But anyway, thank you.
There's a lot of factors involved there. Thank you very much for bringing up that
Professor.
point.
Deputy Chair with a full time.
Oh, thank you, Chair, and thank you to both of you for coming along today. I'm going to start with you, Mr. Gambian. We know that there's a lot of different rising costs within both sides of the system. And we have examples. For example, a very good one is the silicosis. We ended up with an increase in rates of silicosis, not part of the scheme, but the government's response to that was, as you would expect, to take very serious preventative action and also to give better support to workers who are suffering from that. What does it tell you about this government that they've sort of taken psychological injury and decided that that's the one that they're going to just turn their backs on and exclude? What does that mean in terms of stigma around mental health, I guess?
Sure. I think, as I said both in the submission and in my earlier remarks, the whole construct of this piece of reform, so-called, seems to be we have a financial problem. Now, I don't know enough about the financial problem to tell you whether or not there is in fact a financial problem. I take it on faith that there is. We have a financial problem. We have growing prevalence. Yeah, that's true. And so it follows that the solution to the financial problem is to deny the prevalence. Now, 100 years ago, there were no claims for psychosocial injury, I wouldn't have thought, because we didn't accept that it was an injury. I don't think that's because there was no psychosocial injury. I think that is because we didn't accept that there was an injury. And I think it is a terrible both missed opportunity and shame that an area that does need attention, we're not arguing that workplace mental health is not in need of some attention, is getting that attention through what I would say is a quick, hasty process designed for financial outcomes and not designed for better mental health outcomes. And the problem with that, apart from the obvious problems with that and all the rhetoric that's going around, is that if we were to get this right, if we were to change how we looked at workplace mental health, because I don't argue for a second that the current system works. As somebody who was a trade union official for 16 years, I've supported numerous workers with very extreme mental health problems at work. I was an official with the finance sector unit 25 years ago in the finance industry, in the banking industry here in New South Wales. There was on average an armed robbery once a week. That is to say, once a week in metropolitan Sydney, a worker, usually a woman, would have a gun pointed at her in the context of an armed robbery. The PTSD injuries that arose from that kind of a system, from that kind of a prevalent, crime prevalence, were absolutely devastating for any number of people. There's famous examples of times when workers who'd been injured multiple times couldn't work anymore. Their employer's response was to hire a private investigator to prove that they were lying, rather than give them the support they need to get back to work. That's where we've been at in the past. The solution came for the banking industry when we started getting serious about reducing armed robberies. And today there are no armed robberies in metropolitan Sydney. Now that is psychosocial injury that has been prevented. That is literally hundreds, if not thousands of people who are not needlessly suffering, and it is fundamentally cheaper for the insurance system as well. So if we were to take this seriously, if Parliament was to say, this shouldn't be a financial exercise, we absolutely accept that there is a financial dimension to this, not trying to argue otherwise. But if we started to say, what is it going to take to make the workplaces in New South Wales safe for the mental health and wellbeing of workers, we will end up with less pressure on the insurance system, more productive, more profitable workplaces, more effective public services, and less injury, less harm done to both the workers themselves, their families and their communities.
Thank you.
Thank you. To the government, the Honourable Bob Nambar.
Thank you, Chair. Just the first question I've got is, obviously this committee is looking into measures to improve the financial sustainability of the workers' compensation system. Obviously, one way of doing that is to improve the return to work rates. That's not just about financial sustainability, though. Would you agree that improving our return to work rates would also improve the health and wellbeing of individuals that do suffer from psychological injury at work?
Oh, absolutely. I couldn't agree more. And I'll let Professor McGorry say a few words on this because he's certainly the clinical expert. But just from a practical standpoint, if you think about, let's talk about the fabled case where a person who, and as an employer I've experienced this, where a person who feels like they're under a bit of pressure at work, they decide to take some, so-called stress leave. So what does it take in those circumstances to remedy that situation where you've got probably some sort of breakdown in communication between at least two people? You've got a person who is probably feeling quite distressed and not necessarily able to work, but an employer who might quite reasonably be trying to get an employee to work in a particular way or to change their behaviour or to do something different. So what is the remedy in that situation? I'll tell you what it's not. It's not to say to that worker the only way you're going to get any support in this situation is to start an action, like to start a legal action and start start with litigation. I mean, let's use another realm. Could you imagine a situation where we said we're going to have people go to the family court and try to get back together? Is that the time you're going to get back together, when you've started litigation? Or could we have a system that recognised some of these fundamental relationship issues, provided support at an early level, intervened quickly, assessed for genuine psychological injuries quickly and with clinicians, and then said, what is it going to take to either fix this situation so that this person can get back to work really fast, or recognise that this ain't ever going to work and move that person to somewhere else? That is, in my view, a far better outcome for both the employer and the employee, and a cheaper outcome for the insurance system.
Professor McGorry?
Yes, I think that I also very much agree with the premise of the question that, in fact, we've carried out research here at Origin showing that if you provide, this is to young people basically who have dropped out of employment or education because of their mental illness or mental ill health, if you provide what's called an IPS worker, individual placement and support worker, which is like a vocational recovery, almost like a coach alongside the clinical care, you get return to work rates which jump from 30 to 40% to 80 to 90%. And that actually saves on welfare and other clinical costs, but it also rescues the person from a life of disadvantage and poverty on the welfare system. So we definitely want to do that with people with mental ill health and mental illness. Even severe forms of mental illness, that's quite possible with. But those workers, that workforce has not been properly developed by state governments in their mental health services, and only to a limited extent in headspace centres by the federal government. So there's a very big missed opportunity by government here across the whole mental health spectrum, even beyond workplace injury, in terms of helping people with mental illness get back into mainstream work and education. And we've been, advocating with government for many years to invest in this workforce and this component of mental health care that helps people recover functionally and socially, not just symptomatically.
I mean, the anecdotal view is that, the longer that someone takes to return to work, the chances are they may never return to work. The longer they're off work, the more they're at home passively, becoming, potentially sliding into depression, I suppose. And the downstream effect of that is that the medical costs counterintuitively then increase with respect to the claim. So, I mean, that's the anecdotal evidence, but that's a clinical view as well, is it?
Well, it's not just a clinical view, it's an evidence-based, research-backed view, which we've spent years developing the evidence base for, but sadly governments are very slow to respond to. If it was a cancer treatment, it'd be delivered tomorrow, but it's just not. There are many other examples of that in mental health care, where things that we've worked hard to create, new treatments and new ways of working, they're not implemented by health departments and by governments.
There was a criticism today that the scheme operates reasonably well with respect to physical injuries, but its ability to cater for those that suffer from non-physical injuries obviously leaves a lot to be desired. The return to work rates for non-physical injuries that just remain stubbornly low, both in the public and private sectors. Is there a sort of secret sauce that you're aware of in other jurisdictions that we should be looking at that haven't previously been explored in New South Wales?
Well, without getting too much off track here, the mental health system in Australia is in crisis, and it's actually good to see the federal government starting to invest more strongly in it with the election commitments. But we've seen deinstitutionalisation happen about 30 years ago in all states, and what's happened since then is a complete failure to develop public mental health services capable of responding to filling that hole. And that is why you're seeing in New South Wales at the moment 200 psychiatrists resigning from the public sector, because it's falling apart. We had a Royal Commission in Victoria because the Premier, Daniel Andrews, admitted that the system was broken and had just steadily fallen apart since deinstitutionalisation. He held a Royal Commission, brought in a levy to fund the rebuilding of the system, and that is now beginning to. It's underway. It's sort of been slow as well, but and in the federal side, we spend $4 billion a year federally in mental health care for the whole country. As you're probably aware, we're spending $48 billion a year for a relatively small number of people funded through the NDIS. So the asymmetry of funding and the neglect of funding of the mental health system, both federal and state, is the reason that you're not seeing any improvement in these recovery rates, not just in relation to people injured at work, but in relation to anyone with a mental illness. The return on investment and the recovery rates could be dramatically better if we flipped around the investment on, or at least rebalanced the investment on the NDIS versus mental illness. But it's actually not happening at state nor federal level.
On that note, the time has come. There's many more questions that we'd like to ask, but the time has come. Gentlemen, on behalf of the committee, thank you very much, Mr. Gammon and Professor McGorry. As usual, very good evidence, quality evidence that will be taken into account by the committee. So thank you very much for appearing today.
Thank you, very good.
Thanks for the opportunity. Nice to meet you all.
Thank you.
Thank you.
making yourself available what is late on a Friday afternoon, going to the evening. We'll go through the formalities of having you either sworn or affirmed with respect to your evidence for this afternoon, this evening. So starting from my left, perhaps full name, position, title, and then swear either an oath or an affirmation, whichever you prefer. You should have the words in front of you.
Thank you, Chair. Samantha Taylor, I am the Independent Review Officer. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
Afternoon, Chair and members. Trent Curtin, Acting Deputy Secretary of SafeWork New South Wales.
Thank you, Mr.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Ms Young.
Thank you. I'm Amanda Young, I'm the Chief Executive of CIRA. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me will be the truth, the whole truth and nothing but the truth.
Thank you very much. Now, having dealt with that, I'm just wondering whether there is an opening statement or statements plural. Is there one or multiple, just so we have a sense of?
I've got a short statement, Chair, if you'd like me to read it.
Any other statements to make?
I do as well.
Yep.
And no, Chair, I'm happy to just take questions. Thank you.
That's fine. Well, thank you very much. Obviously, you would imagine that committee members are keen to be able to engage and ask questions. So with that in mind, yes, please proceed with your opening statement.
Thank you. Thank you for the opportunity to appear before the committee today. I'd like to just give a quick brief overview of SafeWork's framework for regulating psychological health and safety. This framework is important for guiding our actions to enable workplaces to develop a culture of psychological injury prevention. The SafeWork New South Wales strategic plan outlines our purpose, our objectives, the outcomes and what we want to achieve and how we're going to measure that. It's underpinned by an annual regulatory statement that focuses on 5 high priority areas. One of the areas is managing psychosocial risks at work, including the risk of sexual harassment. The Psychological Health and Safety Strategy, which is from 2024 to 2026, further guides our work in this area. It has a strong focus on compliance by supporting New South Wales businesses to manage psychosocial risks and use good work design to prevent psychological harm. This has guided key initiatives for us, such as statewide inspection programs, psychological WHS checks, and mental health training programs for small businesses. All these initiatives will continue to ensure that businesses meet their obligations under work health and safety laws to identify psychosocial hazards and put in place appropriate control measures. The SafeWork New South Wales Respect at Work strategy also reflects our focus on preventing sexual harassment at work. Since 2023, we've conducted statewide awareness raising campaigns, released a code of practice for sexual and gender-based harassment, and published a suite of resources to help businesses take proactive action to address this harm. On the near horizon, SafeWork New South Wales is being established as a standalone agency from 1 July. A key part of this change is the establishment of the SafeWork Advisory Council, and I'm confident that the Advisory Council tripartite membership will play a vital role in guiding SafeWork New South Wales towards making a greater impact in all areas of workplace safety, but especially in addressing psychosocial hazards in workplaces across New South Wales, which remains a regulatory priority for SafeWork New South Wales. Thank you.
Thank you very much. Ms Young, I understand you have one too. So.
Yes, thank you. And thank you to the committee for the opportunity to appear before you. As the independent regulator of the New South Wales Workers' Compensation System, CIRA plays a vital role in ensuring the system operates in the public interest, supporting workers, employers and the broader community. Our role is set out in the legislation to implement and uphold government policy, advise government based on data and evidence, and ensure the scheme's affordability, sustainability and fairness. And for clarity, CIRA is the regulator, not an insurer, and we do not manage claims. So CIRA's focus is to ensure people injured at work receive timely access to the treatment, support and services they need to recover where possible, to return safe and to suitable work. We know that effective early intervention and high quality injury claims management and return to work management practices are important factors for a person's successful recovery. And we recognise the need for reform and have contributed to many key reviews, including the McDougall Review, the Treasury Managed Fund Review, as well as the various inquiries undertaken by this committee as well. These reviews are central to improving system performance, return to work outcomes and financial sustainability. Our independence is a critical feature of our regulatory role. While we operate within the policy framework set by government, we are not subject to direction on how we exercise our regulatory functions, and it allows us to uphold integrity, accountability and oversight of the system. And today I just wanted to address two key areas. One, improving return to work outcomes. Improving return to work outcomes is a system priority. While most people with physical injuries return to work within 13 weeks, return to work rates for people with psychological injuries remain significantly lower. Only 4 in 10 return in that time frame. These injuries are also more complex and costly and disproportionately affect certain sectors, including the New South Wales government sector. To address this, we have implemented a range of initiatives, including regulatory audits, insurer workshops and improvements in risk assessment practices. Our focus on early intervention, person-centred care and ensuring insurers meet standards of practice. We are currently evaluating our funded programs to determine whether they're fit for purpose and identify opportunities to expand and develop new programs to better meet the needs of workers and employers. And our value-based healthcare strategy is a cornerstone of this work. It prioritises integrated person-centred care for people with psychological injuries or complex physical injuries based on data, insights and lived experience. The second is ensuring accountability and scheme performance. So since the last committee review, CIRA has undertaken a significant compliance and performance review of the nominal insurer, including a targeted audit of psychological injury claims. And I'm sure the committee is aware we also completed a detailed review of the Treasury managed fund with a focus on psychological injury trends across the public sector. These reviews will inform ongoing system improvements and support government decision making. We remain committed to supporting government through evidence-based policy, advice and regulation that improves system performance and better outcomes for workers and employers. The challenges we face, rising psychological claims, post-pandemic pressures and a changing workplace, also present an opportunity to evolve the scheme to be more responsive, integrated and sustainable. I'm pleased to appear today alongside my colleagues at Safe Work and the Independent Review Office. Together we're working in close partnership to improve the return to work outcomes through strengthened prevention and early intervention and enhanced employer supervision. This coordinated whole-of-system approach is essential to delivering better outcomes for workers and ensuring long-term effectiveness of the workers' compensation system in New South Wales. So thanks again for this opportunity and I'm looking forward to assisting in the inquiry.
Thank you both for those opening statements. They're very good opening statements and set a nice context now for questions from committee members. So we'll now get that underway. So we'll commence with the Honourable Damon Chitto.
Thanks. Thank you for being here this afternoon. I don't know how much of the evidence today you've watched, but it's been a very full day. Can I just ask you, Ms Young, did you lodge a submission?
Yeah.
No, we did not.
Why not?
Well, I'll ask the question. But you were consulted in relation to a working group which Treasury asked you about the framework for what we now have as an exposure draft of a bill. And yet you didn't lodge a submission in respect of this inquiry today.
So we have been providing advice to Treasury and to the Treasurer and the task force that he has set up to do that piece of work. We didn't provide a submission primarily because most of what we would say is in the public generally, and additionally we've been putting inputs into that work as well, and figured that, to be honest, you would ask whatever it was that you would need from this space that's not already in the open public domain.
Well, who else was involved in the task force?
So the task force is, I think Treasury may have answered this question this morning, but the task force includes Treasury, the Department of Customer Service, iCare and ourselves provide input to that. So
you had in fact were involved in a review of the Treasury managed fund in relation to psychological injuries?
I personally was not, but CIRA undertook the review, yes.
Given the nature of this legislation and given that you had conducted a review into the Treasury managed fund, or not you, but the CIRA had, don't you think it would have been helpful to have had some insight into the pressures on the Treasury managed fund arising from psychological claims?
So I think that the information that we would have provided would have been that was in the report of the TMF. itself.
Has the government responded to that report?
As I understand it, the work has been undertaken by that. I would need to check whether the government's responded. I can come back to you and formally respond.
And you'll have to excuse me, I don't have the report in front of me. Is it public?
The report into the Treasury Managed Fund, yes it is.
And do you recall what the recommendations were?
There's a range of recommendations within that. So if you just bear with me, I don't want to miss them all.
If you can find it.
So there's a range of recommendations in the report.
Could you just, for the record, just specify the name of the report you're referring to, please?
So it's the Treasury Managed Fund Review Report.
Yeah, and what's the date of that, please?
April 2024.
Thank you.
Yeah. So there are a range of recommendations in that. Some are around governance, some are around return to work, and particularly psychological injury. We provided a range of recommendations to the New South Wales Government to review their claims process and undertake some work in that space, and reviewing the process for engagement with government employers, and looking at some of the rising costs. We looked at considering how that continued, to look into that work, government employers and the entitlements that sat in that space. So there's a significant amount of recommendations that sit within that report.
Well, is this legislation a response, or this exposure draft, a response to that report?
That would be a matter for the government, but it's my understanding that it is not. It would be a component part to how they manage the scheme more broadly, but it's a decision for government in terms of work.
Did CIRIT form the view at the time that the Treasury Managed Fund was unable to continue in a solvent state in terms of assets to liabilities?
We don't. The Treasury Managed Fund is in itself a self-insured model. We don't actually look at solvency or the financials of the Treasury Managed Funds, and we don't have oversight over that.
But there was no recommendation, was there, for legislation of this sort?
No, there wasn't.
As a result of that review?
Not as far as I'm aware.
I must say that
strong community represented over half. Is that right?
Would any of the changes which are recommended as part of this exposure draft, when would you say that they would have an effect on the nominal insurer?
So it would be dependent on when they were introduced and.
Okay, we'll say the premiums payable in respect of workers' compensation by those who insure with the nominal insurer. If the changes or this exposure draft was adopted by the 1st of July, would you expect to see changes to the premiums payable for the nominal insurer?
We wouldn't expect to see premiums change in the next financial year. The filings will have already been completed for this financial year, so we wouldn't see it in that. We would expect to see it in the following years.
But the following year you would expect?
The following years I would expect that we would see some change.
Would you expect that they would be reduced?
It would. I think that's a matter for iCare who set those premiums.
Well, but you have to approve.
So we can reject a premium, but we don't actually approve a premium filing. So we have the option to object it based on its reasonableness. So dependent on what they put in front of us, if it's essentially a reasonable test, and we can reject.
So one of the things that the report suggests is that government employers are not meeting their current legislative requirements, and that's having incurring the likelihood of an impact on positive outcomes for injured workers. That was contained in the report, wasn't it?
Yes.
So it was the government not complying as a self-insurer, I think, as you have described them, that are contributing to their own difficulties in relation to the management of the Treasury managed fund because they're not meeting their own obligations.
Yeah. As an employer, they should improve their.
And how would you say that they should improve their workplace arrangements?
So some of the things we talked about were consistent and timely injury notification, compliant return to work programs,
Yep.
Enhancing their internal audit and risk management policies and processes, a range of work around how they actually manage the claims.
So
and
it would be your recommendation, would it not, that those things ought to be engaged in before you would start to think about reducing workers' entitlements?
I think that's a matter for...
Sorry, I don't want to interrupt the flow of questions. I don't not meaning to do this. But just this issue of policy in terms of government policy, what the government policy may be, and the public
Regulator.
servant, the person who works in the public service, and expecting them to perhaps reflect on policy matters. I just simply, we're getting perhaps near the line, I'm just simply making the point, and the ability for people to take a question on notice if they're not completely sure.
Well, you're the regulator, and have produced a report in relation to this workplace. Would you expect that? Would you expect that those things would be looked at before you were seeking to reduce entitlements to workers?
To the Chair's point, that would be a matter for the government in terms of how
Was
they
there
want
any
to manage that
recommendation by you in that report that workers' entitlements be reduced?
No.
For the financial benefit of the fund?
No, there was no recommendation.
For that effect. So there was no recommendation, was there, to increase to 30% the the WPI for psychological injuries?
Not in this report, no.
And was there any recommendation to set up a new bullying tribunal and harassment tribunal?
Not in these reports.
And certificates to be obtained before a worker? So this would, if in fact, have you actually read now the exposure draft of the legislation?
Yes, I have.
Is it something which you would say, as a result of the consultation you were involved in, is a reflection of the sustainability of the scheme?
It's not a matter for my opinion. We simply provide inputs and advice to the government and they make that decision.
Okay.
Thank you. Come on.
Thank you very much, and thank you for coming along this afternoon. I want to take you to the evidence you presented to this committee as part of our inquiry into psychological claims, and specifically there was a submission that Sarah made in that inquiry that set out really nicely for us what the impact was of the first psychological payment for a claim being made within the first 2 months. And in that, there's a lovely table that says effectively there's about 1/6 of median payments if you get the first psychological payment within 2 months. The total payments for a person ends up at being somewhere around 1/19th to 1/20th of if you wait until after 2 months. And really importantly, that return to work goes from being 49% to 73% if you actually get those payments to a person in the first 2 months. You then say in the report that's just been referred to, the great work you've done looking into the TMF, you say that the percent of workers covered by the workers' compensation insurance in New South Wales by the TMF is about 8%, but that active psychological injury claims in the TMF represent 48% of all active psychological claims. You then go on to say that the review identified a significant lack of compliance with legislative requirements and conformance to serious standards of practices in what are the basic obligations at the start of the claim and in the provision of injury management planning and essential in supporting injured workers in their return to work. So given the evidence you've given that we can reduce, or that maybe that's a step too far, given the evidence you've given that the sooner you get a person their payments, the cheaper it is for the system, and given the evidence that you've given that the government itself is not following practices that it should be in order to get those payments out to people quickly, would you still be recommending that the government work on reducing its obstacles to claims management and improving its claims management as a way to reduce overall scheme costs?
So I think there's probably, to clarify in that, I was not in this role for those two previous reports, so I'm more familiar with the TMF report. I'm not clear of the first report that you're referring to, so it would be helpful to understand that. But I would say that we would always be asking government and any employer to continue to improve their claims management and their compliance with legislation.
You say in this TMF review that 90% of government agencies failed to have a compliant return to work program, and that 50% of agencies failed to notify all injuries within the required time frame, or not at all. That is pretty damning on the government agencies when it comes to their responsibility for returning workers to work after they've had a psychological injury. Again, wouldn't you expect the government to actually improve its own processes as an employer and prevent these injuries getting worse than simply cutting off these workers?
And so I do understand that the government is working on that, whether the formal response is out there or not yet, but they have been working on a whole of government return to work strategy. We've been working with them on a return to work best practice framework. We've been providing data and expertise to them to help them to uplift. And we are doing a claims management review of the TMF, a further one, and developing some vocational support programs. So there's a range of work that is happening in response to that work and to improving the outcomes that they have in this space.
In relation to the nominal insurer, if we look at that now, your audit report from July 23 stated that for psychological injuries audited by CIRA, only 42.5% the employer had actually notified the insurer of the injury within the time frame as required by the legislation. Is that correct?
I would have to again, I wasn't in the role and I would need to check that and come back to you and take that on.
Okay. Similarly, in that report, from what I can see, it says that for psychological claims that are audited by CIRA, 40% of claims within the NI failed to have a subsequent liability decision made within the legislative timeframes.
I'm sure if the report says that, then
this pattern of not managing claims in an appropriate timeframe in both the NI and the TMF indicates quite a severe failing on the parts of claims management and claims managers. What is CIRA doing to ensure that the claims management process is up to scratch?
So there's a range of things that we've been working on, particularly, so I could say I have not been in the role for very long, almost a year now, but since coming into the role that we have and asked similar questions, I suppose, coming into the role, as would be expected. And we have established a nominal insurance performance framework that we are setting up. So that's some key performance metrics for the nominal insurer and the TMF. We have what we have set out as a 12-month supervision plan to start to look at that uplift and what that can be. That will include some further claims management reviews. We will continue to look at the various areas in which we're doing that. Are there policy and underwriting, a claims management focus, some real oversight of their information technology processes, looking at where they are and how they are delivering on their recommendations and commitments through the various reports and inquiries, and understanding that. So we have actually set and started to set that plan in place and done that with iCare, so that it's very clear that these are the things that we are going to focus on to uplift the performance of the NI and the TMF.
Your Honour, Mark Latham.
Yeah, thank you, Chair, and thank you to the witnesses. Just to follow up, Ms Young, having a look at this report, which is quite stunning and perhaps could have been lodged as some form of submission to inform the committee. It says here that CIRA found that the TMF, which represents approximately 8% of workers covered by workers' compensation insurance in New South Wales, was responsible for 20% of claims in the 22 financial year. Significantly, the review has confirmed that in the same period, active psychological injury claims in the TMF represent 48% of all active psychological industry claims in the system. I assume that's in the TMF. The state average is 37, so again, massively overrepresented. And of those 48%, stronger communities represented over half. Well, my first question is, what's going on in stronger communities that's led to this outcome? Is it really that stressful and devastating to make a community stronger?
So statistics only really tell part of the story in that. So
well, tell us more.
The public sector has some unique roles that are very high risk from a workers' compensation perspective that's not generally seen in the private sector. So police officers, firefighters, ambulance officers, correction officers, hospital emergency departments, doctors, nurses, child protection caseworkers, those roles face a different set of issues and a different set of things that come through with that. So I don't think it's unreasonable, given that those roles and those caring roles where people would have and be seeing quite traumatic things often would result in those particular results.
Okay, but it goes to the heart of the financial stress the system is on and the reason for this initiative by the Treasurer. And then most importantly, you say in the very next sentence, 8 out of the 10 psychological industry claims are from preventable workplace behaviours like work stress, bullying and harassment and other mental stress factors. Well, what's being done to actually have prevention? And if 8 out of 10 could be prevented, we've certainly got no need for this legislation, have we?
So I think that statistic is true. So the 8 out of 10 is workplace stresses and other issues. And I think that's where we work very closely with our safe work colleagues on how do we actually get employers to do more in that space, because if we can prevent these issues, that is all the better for everyone involved. So Trent, did you want to?
Well, Safe Work's got its own set of challenges and changes that we've examined at budget estimates, but can I come to your statement? Did you say earlier on there were no recommendations out of this report?
Which report?
The TMF review
No, there
report.
were multiple recommendations.
Yeah, there were 15
yes.
suggested
Multiple.
courses of action, mainly reviews. Perhaps on notice, can you give us some detail about what's happened over the past 13 months in these reviews and suggested courses of action, a pseudonym for recommendations? Because I would have thought if action had been taken, why is this bill necessary?
I can get that to you on notice.
Yeah,
We
and we'd like a lot of detail as to the 15 courses of action, a lot of reviews, what have these reviews resulted in, and what progress has been made in dealing with these horrendous statistics which embed and demonstrate the particular problem that the TMF is under. So could you do that? And it would be in lieu of making a submission to inform the committee. And then I would come to Mr. Curtin and ask, well, what improvements are you making at Safe Work, particularly in getting ahead of the curve with prevention? Because I don't want to be rude about it, but your minister did point to systemic failures in the institution. I think across the parliament there's a lot of disappointment about the past performance of Safe Work, and you're obviously crucial in dealing with these type of issues by way of prevention.
Yes, Safe Work New South Wales inspectors have a really important role to play in providing advice and guidance and support for businesses, and also for undertaking compliance activities to ensure compliance with our laws. Our current psychological health and safety strategy lays out a number of actions for us. Some of that is undertaking training with small and medium businesses. Some of it is having direct one-to-one coaching with psychologists with small businesses to help them lay out their risk assessments and to set their safe systems of work up. That's progressing extremely well. And then Safe Work inspectors are also taking, for large and well-resourced organisations, a stronger compliance focus. So our inspectors who attend businesses with more than 200 employees will always undertake a check in relation to psychological health and safety.
Can we get from both Safe Work and CIRA some breakdown of the industries that have a high prevalence of these psychological injuries? We've obviously got stronger communities department that you've mentioned, but it'd be good to get a breakdown of sector by sector as to where the problems are, again to inform the committee and give us a handle on the nature of the challenge by way of prevention. Thank you.
Thank you.
Is that okay on notice?
Yeah, I've got some here. We can take it on
Yes,
notice
okay,
if you
thank
want
you.
to do it that way. Yeah.
Thank you, Honourable Mark Latham. Now move to government. Anthony Van.
Mr. Curtin, is it fair to say that Safe Work's priority is actually the private sector? That in terms of the public sector, it tends not to devote a lot of resources to compliance work, given there's an expectation. There's also a principle around Crown Shield and not prosecuting, the Crown not prosecuting itself effectively. Can you maybe perhaps comment on, what the sort of rough balance is in terms of the resource allocation towards public sector compliance versus compliance in the private sector around psychosocial hazards?
Yeah, so we've been increasing our focus on government departments in relation to psychological health and safety. We've been doing that over the last 12 and 18 months with the new psychological health and safety strategy, and the recommendations from the Law and Justice Committee as well set out for us to work closely with CIRA, iCare and some of the government departments to do more to increase the health and safety for workers in those departments. We've undertaken a number of specifically targeted psychological health and safety compliance campaigns. We've looked into occupational violence in emergency departments, in the health department. We've been looking at occupational violence and psychological health and safety in the education department, undertaking a range of visits across the state to confirm compliance, to do two things. One, to help those schools get more advice and to become more compliant with our legislation, but also to provide advice back to the education department to see where those systemic changes might be, where they could continue to do more to help those schools. We've also undertaken compliance programs in relation to the hospitality industry and looking at sexual harassment there. So we've been learning a bit about that, and so that we can scale that across other organisations and see where we're seeing some of the failure points and where we can see opportunities for improvement across both government departments and private industry.
How does your record stand in terms of prosecutions around psychosocial hazards?
We've had very little prosecutions in the psychosocial space. It's a new and emerging area. New South Wales was the first state to adopt the National Model Code of Practice for Psychological Health and Safety. We do have investigations underway. We have initiated prosecutions. We have had a successful prosecution, but we are continuing to increase the number of prosecutions we're doing at the moment.
I'll ask about under-insuring. The main enforcement liability, or enforcement responsibility, sits with Safe Work. I mean, you've got the inspectorate. I'm assuming that in terms of actually enforcing under-insuring, the primary load is borne by Safe Work. Is that fair to say?
We do that under delegation from CIRA, but yes, our inspectors have the power to go and check that.
And so how many prosecutions have you done around under-insurance in, say, the last 5 years?
My understanding is we have not prosecuted for under-insurance.
None?
That's my understanding, yeah.
Okay. Can I ask about some earlier evidence? This is directed to you, Ms Young. We heard from Dr. Parmigiani, a sort of set of circumstances which I found alarming around the nexus between no win, no fee, law firms taking on workers with psychological injuries, and effectively the set of circumstances that he described seem to positively disincentivise return to work for workers who've sustained psychological injury. Did you hear the evidence?
No, I don't think I heard that part.
No, perhaps on notice you might want to review the transcript on that. I wondered whether this is something that's on the radar for CIRA, because as the steward of the workers' comp system, this seems to be something that clearly is working against improving the rates of return to work for psychological injuries, and it looks like something that perhaps needs to be addressed if it's not currently being addressed. So perhaps you could, if it is being addressed, my question is, what are you doing about it? If it's not being addressed, what do you propose to do about it?
So the workers' compensation legal supports are primarily run through the ILR scheme, through the IRO, and it's a fee-based service where the fees are set. So I'll have a look at the transcript and come back to you on what the particular issue might be, unless, I don't know if Samantha is aware of anything else other than that.
No. Can I ask Ms. Taylor, the exposure draft bill envisages this situation where effectively a tribunal is the gateway before an application. Is ILR's resourced to support injured workers going through that, I suppose, gateway process? How would that process impact on the obligations currently for ILRs?
Thank you for that dream question from a bureaucrat to ask about resourcing. I appreciate it. For the committee's reference, we in IRO deal with the back end of the process where there is a dispute or disagreement between a worker and their insurer under workers' compensation laws. And we address those issues in three ways actually. One, through our solutions function, where we seek to broker a change in the position of the insurer, and that is a very successful function. It's a very small function. I have 15 expert people who manage that and negotiate with insurers on behalf of injured workers to get good outcomes. We then have an inquiry power which can assist in, getting the insights from that particular function, and also what we do in the grants line, which I'll talk to in a moment, to make recommendations or to make observations about what's happening in the system more broadly and the impact on injured workers arising from those experiences and what might need to change. And I'm 3 months into the job, and I'm already looking at how we can use that inquiry power to influence some of those behaviours of insurers and their case managers more positively. And then we have the grants line, which is effectively the assistance that's provided to injured workers through lawyers for legal representation. Now, my assessment is that if the inclusion of a provision for a representation at the IRC is part of the workers' compensation framework and acts, then it would be covered by ILRs. At present, ILR's costs are determined through a demand and forecast arrangement and on recommendation or a request from me to CIRA around our share of the workers' compensation fund. We would need to assess what the depending on what the outcome of the bill is and its ultimate passage, what the demand and forecast projections would be in that context, depending on that design. It's not a straightforward volume issue. There are a number of considerations that we would need to take into account in making that request, I guess. I have initiated a project around redesigning our demand and forecast model for ILRs. At the moment, it's a relatively naive and flat model of projection, which is based on the experience within the grants program itself, with little reference to the policy environment within which that fund operates. And it's important that we have an actuarial view of the demand and therefore forecasted cost for ILRs. So we're basically looking to see, as a result of whatever might pass through the Parliament, what the implications would be, have a model ready that enables us to build that in, so we can have a conversation with government about what a reasonable level of resource would be, so that workers have access to legal representation to secure their rights under workers' compensation law.
And Ms Young, was that element factored in terms of consideration by the task force when providing advice to government on?
That would be a matter for the task force leads. So we provide inputs. The decisions that are taken are are done through the Treasury process and through the Treasurer, so we would have provided advice. We would not have yet provided advice on this because it depends on how the bill
Well, surely
ends
in
up.
terms of the advice around, the proposal, you would have had some idea about whether there would be, that it would involve additional funding to resource workers to be represented in this additional stage that's required in order to access workers' compensation.
We certainly would have provided advice that would need to be considered depending on what model they came out with.
If I can add that whilst there may be the need for people to have representation, which, if they need to go through a process which is, confronting, legalistic, and they're not prepared to represent themselves and all the things, that it's important that happens. But, depending on what the Parliament determines around this, there may be other adjustments to ILR's costs down the track with things that we are currently handling, and they may no longer be part of the infrastructure of workers' comp. So it is important that we understand what all the changes look like, and then anticipate based on what we've seen both through the program, through the Personal Injury Commission's experience, and so forth, what the actual impacts would be in terms of legal representation costs.
Well, that brings this session to conclusion. Thank you very much. First of all, thank you very much for the great work you do for the New South Wales Government through the respective agencies you have responsibility for. It's very important work, and we appreciate what you do, and we appreciate you coming on this afternoon and providing some very helpful evidence to the inquiry. So thank you very much.
Do you want to remind
Thank you.
the deadline for sessions on those?
Oh, yes. Sorry, I think there might, sorry, just there may be, there are some questions taken on notice, I believe. The return around time is by close of, that with respect to questions taken on notice, sorry, I'm just confused myself now. What we've got 5 p.m. till next Wednesday, is that correct?
Wednesday.
To respond to, so you receive them from the Secretariat, so by 5 p.m. next Wednesday, 21st, to be back to the Secretariat. And I'll be liaising with you. Okay, thank you.
Thank you.
I've just got 2 things to say before we proceed with the formalities. First of all, to thank you both for your forbearance with respect to the nature of the time slot provided to you to participate in this inquiry. The second thing I want to say is please don't think in any way that time slot reflects in any way disregard or disrespect for the most important work that NCOS does. It just happens to be a very challenging day, and we've just had to be very tight in terms of getting witnesses before the inquiry. But I just wanted to say that because I didn't want you to think that because you've been pegged at the tail end in some fashion, there's disrespect or disregard for NCOS and the great work that it does.
Thank you, Chair.
Sorry?
No, just joking. Sorry, go.
We're all still here.
Yeah, we're all still here. There was some joke, but I didn't hear it, so we'll keep listening.
Funny.
It wasn't funny. Sorry, we've just been here for quite a while today. What I'll do though, please, if I could, just formalities, just from my left to right, name, position, title, oath or affirmation, whichever you prefer, and then we can proceed.
Cara Varian, CEO of the New South Wales Council of Social Service.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given is by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Varian.
Thank you, Chair. Ben McAlpine, Director of Policy and Advocacy at NCOS. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Can I just move on to acknowledge and thank NCOS for its submission to the inquiry. It's submission number 37 to the inquiry. It's been processed, uploaded to the inquiry's webpage, and stands as evidence to the inquiry, obviously, as your submission. What we'd like to do, if you agree with the format, is to invite you to make an opening statement, and then once that's done, we'll then move to questions to you, if we could please, with representatives at the table from the opposition, Crossbench and government, if that's okay.
Thank you, Chair.
Thank you.
As you know, we are from the New South Wales Council of Social Service, and we advocate for the need of individuals and the communities experiencing disadvantage in New South Wales and represent the community services sector. They're a dedicated group of people who provide essential services to support the people, families and communities of New South Wales, and we welcome our invitation to participate in this committee today. Community service work is deeply rewarding. It's profoundly personal work, and there can be a toll supporting people experiencing poverty, violence and trauma. Our sector faces critical challenges. Service demand is increasing without commensurate resources to meet that demand, and this is causing ballooning workloads, burnout, job insecurity amid rising living costs. Simultaneously, provider organisations struggle with escalating operational expenses, including sharp increases in workers' compensation premiums. Given these pressures, getting this reform right is crucial. It will be important that the right balance is struck between effectively supporting the psychological welfare of workers, supporting employers, and managing scheme sustainability. This recently released exposure draft, and there are a number of issues that require further clarity. But the success of the reforms will depend on achieving that clarity with the input of experts and people with lived experience, balancing the needs of workers, employers and scheme sustainability, and ensuring transition arrangements support the people and the organisations with the knowledge to move into these new arrangements. We welcome the proposed preventative measures that have been flagged by the government and request that these measures are extended to support the social service sector. We advocate for reforms that balance the scheme's financial sustainability with ensuring the well-being of essential workers and the organisations who fulfil the government's social policy objectives. Without protecting these organisations, the broader social policy goals are compromised.
Thank you very much. We will then move to questions, if we could then, if you agree to that. So,
thank you very much, and I'm sorry it's so late. What reforms do you say are worth embracing and which would benefit the social services sector contained in the exposure draft?
Well, certainly we acknowledge that reform is required. The premiums at the moment are putting an enormous amount of pressure on community service organisations. We also support that there will be stronger definitions around psychosocial injuries, and the intent to address unsustainable insurance costs is important. But given the amount of time that we've had, I would say our main message is that greater clarity is required.
Well, would you agree that there will be a lot less people able to make claims for psychological injury at work as a result of this exposure draft?
Yes.
And that's part of the intent of the bill? Exposure
I
draft?
wouldn't want to comment on the intent of the government's bill, but there is a balance here between making sure that workers are safe in their workplace, and also ensuring that organisations have sustainability. And it's a tension that we need to acknowledge, and that we want to make sure that what reforms do happen will support both the workers and the employers.
Well, have you been able to identify any provisions in the legislation which would in fact impact on workers in a way which is detrimental to workers and which may impact then in terms of the services you would be required to provide?
I refer back to my previous comment. I think the issue here is that we need some greater clarity. Our submission included a number of items within the exposure draft that we request additional clarity on. I have a further list from our members of things that require greater clarity. Of course, there will be impacts, but at the moment there is an onus on the government to provide a bit more detail, I think.
So, I'm not being... part of the potential here is if you increase the WPI in relation to workers to 30%, a lot of workers who currently have psychological injury claims will not be able to continue making those claims after 2.5 years, and there will be a lot more potential services need to be provided by the organisations which you represent.
That's right, and I mean that's true. We do have concerns that if the right thresholds are not met, then the people that don't get support through this scheme will end up with the community service organisations who are already stretched. That is a concern.
And that would be a significant drain on your member organisations' resources. So, on the one hand, they're seeking to ensure their viability by reduction in workers' compensation insurance premiums, which is obviously an expense which they will have to bear. But on the other hand, the resources would be impacted by potentially a cohort of people who would be making...
It's complex reform, and I would say that with the information we have now, we don't have enough clarity to know really whether the thresholds are.
So you would support, would you, further work being done in relation to making sure that we've got the balance right here?
I think that is important.
Yeah, and the short time frame for some inquiry in relation to this legislation hasn't been all that helpful.
It's been a tricky week.
So who does the who prepares the submission? Do you, Mr. McAlpine, do you prepare the submission?
I led the work, yes.
When was the first time you saw the bill?
I believe it was when the exposure draft was released. I think it was on last Friday.
And you saw it last Friday?
Yeah, and then we were invited, I believe it was on Monday, to provide a submission by midday on Thursday.
To make a submission? Were you given much time to consult with your membership?
I think it's safe to say that 3.5 days is a small window in which to do detailed consultation.
And if the stated object is that potentially the TMF and or alternatively the NI is financially unsustainable in circumstances where if we didn't pass this legislation, would you in fact say that that is the correct lens through which to be looking at withdrawing benefits for injured workers?
Sorry, Mr. Trudeau, I think I may have lost the train of that question a bit.
Well, if the motivation for this legislation was the solvency of the NI and the TMF, rather than a focus on benefits for, and that focus was that was achieved by withdrawing benefits from injured workers, would you be supporting that legislation? If that was the purpose, motive of driving this exposure draft?
Well, our focus would be ensuring that the workers are getting the coverage and support that they need, and that our members, the frontline essential community service organisations, are getting the sustainable premiums and the support that they need. That would be where our focus would be.
And where's the balance?
That is, I suspect, exactly the challenge for this committee and the government.
Yeah, I've got no further questions.
Perhaps have a couple of Deputy Chair.
Thank you. Thank you very much for appearing today and for the very, within the very short time frame. Your members know better than anyone whether they're working in homelessness or mental health services or DV services or anything else, that early intervention is key in terms of saving society and the government money in the long run. That's correct, right?
That we are, as a principle, preventative care and efforts is very important to NCOS and the community services sector.
You are in a very difficult position, if I may say so, because you are, as you say, not only looking at the long-term prospect of people not getting the help they need and then putting more pressure on your services, but you also have the immediate pressure right now of needing to, some sort of assurance from the government that your premiums aren't going to go up as well. This is all in the context of a government that is under-resourcing community services. Would it be better, in an ideal world, if the grant funding and the ongoing frontline service funding for services like the ones that you are here representing actually took into account things like increase in premiums? If your baseline funding for a service increased over time, if there was an increase in something like workers' compensation, wouldn't that be a fairer situation to be in and put you in a less difficult situation today?
I think you will have seen in our submission that we raised the issue that making sure that the funding arrangements are sustainable for community service organisations, because it does cause stress and an impact on community service organisations and their ability to deliver those services to the New South Wales community. So most recently, the government has announced the Secure Jobs Funding Framework. It's a great plan, but it's not the delivery of longer term contracts yet, and it's not a delivery of recognising the real cost of service. So that's what I would hope to be the next step, and it is urgently required.
And we all hope to see that. We all hope to see procurement at all levels taking into account the real cost of labour and move with it when it's government money that's being spent. But when it comes to your own members, I've spoken to, in my portfolio responsibility for domestic and family violence, gender violence, I speak to a lot of services that point to the lack of government funding as itself creating psychological stress and moral injury within their services. Where are those employees going to turn to in such terrible times if we also take away their cover under the workers' compensation scheme?
Yeah. Well, as per our submission, we have made this exact point that not only is the workers' compensation scheme reform required, it's a complex and difficult balance to make that reform, but so is the funding models for community service organisations, because they are entwined. Environmental circumstances will contribute to injury in the workplace as well.
Honourable Michael, any questions?
Yeah. Thank you, Chair, and thank you to the witnesses. I can understand, having had the exposure draft for just a week, why your submission basically calls for clarity. But aren't there some things that are particularly objectionable? I support some of the things in the bill. I think it needs some extra measures. But the one that seems very problematic is this section 8F, this so-called gateway, because effectively for the people you represent, I suppose, right across the community, if you are genuinely traumatised and mentally ill, psychologically injured out of this process, it's going to be particularly horrendous, isn't it, to have to jump through 2 hoops to get your workers' compensation? I mean, imagine having to go to the police, wait a while they investigate, and then I suppose you might have lawyers involved to go to a tribunal, commission or court to prove your finding of harassment or bullying, to then be eligible for workers' compensation. Isn't this something that, instead of calling for more detail, we should just rule out straight away as unsatisfactory?
I agree that it's problematic, and it's one of the reasons why we wanted to get more information. It would not be a bad thing if we could find a different mechanism to ensure that people can get the support that they need. But again, we did this quickly, and we wanted to make sure.
I'm not against gateways or triaging your way through to more cost-effective system, but I just don't think this is it. But I'll leave my question
I think it's
there.
problematic.
Given the time of day, I'll leave my question there and thank the witnesses for their patience in
Thank you
appearing
very
here when it's dark outside and the footy started on a Friday
Yes.
afternoon.
I appreciate there's 10 minutes left for government questions, but I will say I won't press you really hard for 10 full minutes of questions, but if you've got that, please proceed.
I have just one question. So one of the issues that has been identified is the impact of single claims in terms of the premium, the penalty premium, when you have a psychological injury in a small business, for example, where a worker goes off and they're off for a very long duration, unlikely to return to work. It's a high value claim and there's a consequential increase, penalty increase in the premiums for that business. Do you have a view about how that element of the system's premium setting should be reformed? I mean, it has a obviously, the bigger the business, it's easier to absorb those kind of costs, right? But for a small business, it could be, the difference between them staying. And I use the small business, but most in the community sector would fall into that category in terms of the number of employees. And so the impact, particularly for funded services, is quite dramatic if they've got a big hike in their premiums arising out of a single claim. Can you perhaps provide some comment on that?
I'll let you add to my thing, but I can confidently tell you that members have raised this with me as something that is very challenging for them to manage. And as we talk about the importance of place-based organisations, and as you rightly point out, there are many very small community service organisations where a single incident like this would jeopardise the viability of their organisations. I don't think I'm the best person to give you the suggestion of that exactly how it should be reformed, because I'm not a workers' compensation expert. I'm a community service advocate. But I think it's a problem that is tricky and worth spending time on how to resolve it better.
I think this links back to Ms. Boyd's commentary around the general underinvestment in the sector. So some of the issues that have been brought up in the last week, but certainly for many years before, is what would actually support frontline service organisations prevent psychological injury happening in the first place, so therefore avoid the ramp-ups in these premiums, would be investment in learning and development, professional supervision, getting the manager to worker ratio to be at a better level. All of these things create an environment where it can increase the risk of psychological injury. If you were then to introduce additional costs that are adding more financial burden to organisations that are already struggling to meet community need, then I think that could be problematic and create a very difficult cycle for a lot of organisations in our sector.
Yeah, do you think it's fair to say that the risk, like the whole purpose of a workers' compensation system is to spread the risk around, but clearly the risk impact is actually greater in those smaller businesses and smaller entities, perhaps that we need to spread the risk in a different way?
Yep, I think spreading risk would be a good idea, but I think the other part of it is that inherently there is great risk in community service organisations because of the trauma based work that they do, and so it is a really kind of, it looms large in the eyes of all of our members. They're very concerned about how this is going to move forward.
Yeah, just one question from me. And I'm conscious of the difficulty of your position, and certainly won't ask you anything, about the fraught nature of workers' compensation reform, the specific nature of that. But just as a general proposition, would you agree that changes to workers' benefits should only be considered if they're seen to create this sort of perverse disincentivisation of returning to work, or if they are putting an unmanageable burden on the scheme. Would you agree with that as a general proposition?
So they should only be put in place if they're creating an unreasonable burden.
An unreasonable burden, an unsustainable burden on the scheme, or if it's disincentivising an individual's return back to work.
The test.
We should only reform the scheme if it's going to cause
Well, make changes or significant changes to workers' benefits specifically.
Can I say, with no disrespect,
You can take it
if you
on
wish
notice.
to take it on notice, sorry, it's the question, it's got some complexity to it, and it has been asked of witnesses during the day. So if you'd like to take it on notice, I know it's hard to drop that one on you at the end of the day, but if you'd like to take it on notice, you'll have it in front of you, you can respond.
Maybe I should do that so that I can give you a sensible answer.
No,
sorry.
I'm sure you'll give a sensible answer, but just perhaps more time to read the full question might be a bit easier for you.
Help if you ask a sensible question. So
I'm sorry for my blank stare. I would like to answer that question properly.
Yes,
I'll take that on notice.
That's what I was thinking you might want to do. So
thank you, Chair.
On that note, can I conclude by thanking you both once again for coming along this afternoon. The submission is very helpful. I appreciate the 6 recommendations carefully thought through, and particularly Part B of the report, which gives us some particular focus on sections in the exposure draft that you wish to draw to our attention. So I do appreciate the effort that's gone into that. So once again, apologies for the lateness of the day, but thank you very much for coming along and the work that you do. Thank you.
Thank you.
Thank you, Chair.
Thank you.
That brings the